Advocate S. Sridhar, President of Revenue Bar Association, and Advocate T. Vasudevan, Secretary of Revenue Bar Association. Thank you. We will begin today's program with an invocation song. I request you all to rise for the same. Thank you. I now invite Advocate D. Anand, the chairman of this conference committee, to address and welcome the gathering.
Lordship, Honorable Mr. Justice Mahadev, the Acting Chief Justice of Madras High Court, Lordship, Honorable Dr. Justice Anita Suman, Judge, Madras High Court, Honorable Member of Central Administrative Tribunal, Sri Swaminathan, Senior Advocates, Commissioners, and Officers of the Income Tax Department, Chartered Accountants, colleagues from the bar, esteemed delegates, and students from the law school. A very good morning to all. It is my distinct honor and privilege to stand before you today as the chairperson of this esteemed tax conference to extend an heartfelt welcome to all of you and to our esteemed guest, Lordship Honorable Mr. Justice R. Mahadevan, Acting Chief Justice of the Madras High Court, and Lordship Honorable Dr. Justice Anita Suman, Judge, Madras High Court, who have graciously spared time amidst the demanding schedule to attend this inaugural session of the two-day tax conference, Tax Litigation Embracing the Future. It is my honor to welcome His Lordship Honorable Justice R. Mahadevan, known for his extraordinary memory, legal acumen, profound wisdom, and unwavering commitment to justice. Lordship's impactful judgments blend legal vigor with human empathy, embodying the balance between justice and mercy with grace and dignity. Lordship's positive courtroom demeanor, marked by a reassuring smile, ensures respect and understanding for all parties, even in adverse decisions. Lordship's landmark judgment in the Temple ID case exemplifies his deep appreciation for cultural heritage and legal integrity, fostering trust in our judicial system. With his remarkable achievements and his path set towards becoming a judge of the Supreme Court of India, Lordship stands as a beacon of judicial excellence and integrity. On behalf of the Revenue Bar Association and conference delegates, I extend my heartfelt welcome. It is equally my honor to welcome Her Lordship's Honorable Dr. Justice Anita Suman. Her Lordship's presence here is a testament to her unwavering dedication to the progress of the Revenue Bar Association and to the legal profession, and her exceptional contribution to the field of law. Lordship's journey to the bench is deeply intertwined with the Revenue Bar Association, where Lordship played a significant role. Her Lordship's contribution to the Revenue Bar has been invaluable, and her legacy continues to inspire and guide its members. Her Lordship is known for her sharpness in grasping issues and handling critical situations with grace and calmness. Her Lordship's prolific knowledge and profound understanding of legal system are matched only by grace and humility insights and judgments have been pivotal in shaping contemporary tax litigation practices, making it a relevant item in legal community. On behalf of the Revenue Bar Association and conference delegates, I extend a heartfelt welcome. Their Lordships' presence here elevates the significance of the gathering and tax conference and would stand as an inspiration to all of us gathered here. Additionally, it's a moment of great pride and honor to acknowledge and celebrate the legends from the Revenue Bar Association and the accounting profession. These individuals have not only shaped the contours of tax litigation, but have also set exemplary standards of professionalism, integrity, and dedication. Their contributions have been instrumental in advancing our understanding and practice of tax laws, and today we honor these remarkable legacies. I extend my heartfelt welcome to these legends and family members present here. In a world that is rapidly evolving, the landscape of tax litigation is no exception. Tax litigation, once perceived as a conventional area of practice, is now undergoing a transformation. The advent of digital economies, complex financial transactions, and international trade agreements necessitates a rethinking of traditional approach to tax disputes. Moreover, the integration of artificial intelligence, big data analytics, and blockchain technology promises to revolutionize the way we handle tax-related cases. As we stand at the cusp of the significant changes driven by technological advancement, globalization, and evolving legal frameworks, it is imperative that we embrace the future of tax litigation with foresight and preparedness. I take this opportunity to welcome the chairperson and speakers of the technical sessions and all the delegates to this tax conference who have been our inspiration and source of support. The intricately curated tax sessions at the tax conference is marked by a seamless collaboration between senior members of the Revenue Bar and ever-dynamic junior members, epitomizing a harmonious blend of experience and fresh perspective. The exemplary dedication of junior colleagues in orchestrating this event underscores their valuable role in shaping the future of legal excellence. Thank you all for your presence and participation. Let us make the most of the opportunity to learn and grow together. Welcome to TAC Conference 2024. Thank you.
Thank you, sir. I now invite Advocate S. Sridhar, President of the Revenue Bar Association, to address the gathering.
Good morning to everyone. It is with immense happiness, pride and privilege that I welcome you all to this significant two-day tax conference hosted by RBI Chennai. The theme of this conference is dedicated entirely to young tax professionals, including lawyers, CAs and ITPs. On behalf of RBI Chennai, I extend heartfelt thanks to Honorable Acting Chief Justice of Madras High Court for graciously accepting our invitation to inaugurate this session. We are deeply grateful to your Lordship for gracing us with your presence, which underscores the strong bond between the RBI and the bench. I also extend warm greetings to Honorable Justice Dr. Anita Suman. RBI appreciates your presence, eagerly awaits your special address on the conference theme, Tax Litigation Embracing the Future. In the illustrious journey of RBI, there are several legends whose commitment to tax litigation practice remains unparalleled, making them integral members of our esteemed RBI family. Recognizing their extraordinary contributions, RBI has identified 4 such legends, 2 from legal profession and 2 from the accountancy profession. 2 will be honored today with the citations and shields presented by Honorable Acting Chief Justice and Honorable Justice Dr. Anita Suman. The other 2 will receive their honors from Honorable Justice M. Sundaresh, Judge Supreme Court of India, tomorrow. It gives me great pleasure and privilege to announce the names of these 4 undisputed tax legends, recognized for their experience, brilliance, and success in income tax litigation practice. In this inaugural session, we honor Mr. T. N. Sitaraman, Advocate, past President RBI, and T. Ranganathan, Chartered Accountant from Salem. We salute their dedication and invaluable contribution to the income tax litigation practice. We consider ourselves truly blessed to have the opportunity to honor such tax legends. The other 2 esteemed recipients of citations or Shri Philip George Advocate. Past President of RBA, and Shri E. Sitaraman, Chartered Accountant, and past President of ICAI. They have received their honours from Honorable Justice M. M. Sundaresh and Honorable President of ITAT tomorrow. Before concluding, it is RBA's duty to uphold the honour of the Madras High Court, and our efforts at RBA are on ongoing commitment. I would like to highlight to the Honorable Acting Chief Justice of the Madras High Court that there are deserving, experienced, committed tax lawyers among the audience today, including several senior turned lawyers. With this, we look forward to opening a new chapter in the history of RBA. Thank you all.
Thank you, sir. We take great pride and privilege to say that Senior Advocate Shri K. Parasaran is a founder member of this Revenue Bar Association. He has been kind enough to send us his warm wishes through a video. We will now play the same.
It gives me great happiness when I see that the Revenue Bar Association is this year celebrating its 61st year of its age. Do we carry on the association activities and continue to carry it on after 61 years is the divine blessings of God. When it was found that I was practicing my 13th year as the God, probably I was the junior member of those who founded this association. Stalwarts were there on the taxation side, the activists were there, who took great affection, who extended to me great affection, love and blessings. Just as this way, was then a practicing lawyer, he was also a founding member. He used to appear as federal government lawyer in list of petitions, and I used to appear in a number of petitions arising out of the Madras Estate abolition and conversion in the Right Act 2648. That brought both of us together, and our friendship lasted till he retired. But as a judge, he kept himself aloof from me, and as lawyer, I kept aloof, though I used to meet him once in a month as a courtesy call. That I have been able to say a party word in this year's function is also again the blessings of God. Together, I am now running my 96th year completed, running 97th year again. This is the blessings of God that I have arrived to see this function and say a few words about on this occasion. I am sure with the members who have all been active members and who are all known to be dedicated in the service to the profession will carry on this association very successfully. And this association will celebrate not only 760 years, but century after century, 7 centuries. I pray to God to bless this association. Thank God.
Thank you, sir. Honorable Justice Dr. Anita Sumant is always a pillar of strength to this Revenue Bar Association. It would not be out of place to mention that Lordship's father, Senior Counsel Mr. V. Ramachandran, has contributed immensely to the growth of this organization. I now invite Honorable Justice Dr. Anita Sumant to unveil the theme of this conference.
Respected Justice Mahadevan, Acting Chief Justice of our court, Mr. Sridhar, Mr. Vasu, Mr. Anand, respected seniors in the audience, members of the RBA, chartered accountants, my dear friends, good morning to all of you. We have just heard from Shri Parasaran that this is the 61st birthday of the Revenue Bar Association. So this is the Shashtikdabhuti celebration. I didn't know that. My best wishes to the RBA and going forward, Sadabhishekam and many, many more landmarks to be achieved. Tax litigation, for me, is one of the most scintillating branches of litigation. Now, over the decades, tax litigation has assumed many different hues commensurate with the increase in volume of litigation and multiple surrounding issues that impacted and necessitate such changes. Now, I have been given the honor of unveiling the theme of the conference. Normally, you find that it is the organizers who unveil the theme. So, what do I take from this? What I take from this is that the RBA and other tax organizations, the AIFTP, they are all part of my DNA. And they have been, they are, and they always will be part of my DNA. I am happy to be carrying out this task. My mandate is to envision in broad brush strokes the destination that tax litigation is charting for itself. Now, to do this, I must divide my talk into perhaps two rough modules. One is to take stock of taxation as it is today, and then to see where it is headed or to chart the way forward. Tax litigation has always been a niche practice area. All those who practice in taxes will know that it is a fairly small and a compact body of professionals who practice here. When you have a mix of professions from the practitioners from the accounting profession as well as lawyers engaging in client advocacy, strategy and appearances at the initial levels up to the level of the Income Tax Appellate Tribunal, we thereafter have a small group of counsel before the High Courts. Now, the cross-section of practitioners before the writ courts, I find, is far wider than what it used to be, and this is a cause for great happiness as far as I am concerned. We have a lot of new faces, a lot of young faces, and may your tribe increase and keep increasing. The spectrum of issues that one encounters under Article 226, this routinely encompasses violations that would stand the test of alternate remedy, such as natural justice violations or the bar of limitations, such violations. I don't find anything very earth-shattering that comes up in terms of substantive tax issues in Article 226. The advent of goods and service tax has led to a proliferation of litigation, mostly because the law is yet to be settled, the procedure is yet to be settled, and I would perhaps see this trend continuing for a little while longer till there is clarity on all these issues. Having said so, in revenue enactments that have stood the test in time, barring the new regime of reassessment, we don't find too many novel issues that are coming up. As my theory has always been that one should give a coitus to litigation if it comes up, whether in the writ court or otherwise. I am not a very firm believer in remand, as many of you would know. So, going forward, I would think that it would be an advantageous proposition for the other stakeholders also to look at settling the law before the fora, rather than to work towards a remand, which is only going to give us one more round of litigation and not settle the law by any stretch of imagination. Now, that's as far as taking stock today is concerned. There are other facets of today's tax litigation which I will advert to briefly in the minutes to follow. What does the future hold in store? First, increased emphasis on international taxation. Because you have an increased proliferation of international transactions, both e-commerce and in the field of digital currency as well, one would have to be equipped with the modes of digital currency that we have, cryptocurrency, etc., and we will have to work out modes and methodologies of how to tax them, whether to tax them and how to tax them. The reckoning of a permanent establishment thus becomes critical. Of course, this has been an ongoing exercise for many decades, and those in tax practice are not strangers to the place of effective management rules and the other methodologies that have been devised to arrive at or to reckon a permanent establishment. But that saga continues and becomes more critical in the years to go. Practitioners desirous of keeping abreast with concepts with international taxation must concentrate on double taxation avoidance agreements, BEPS, base erosion and profit sharing concepts, safe harbor rules, rules of transfer pricing. And here my information may be a little dated, but I have always found a clear demarcation between domestic tax practitioners and international tax practitioners. And my fond hope is that going forward, this gap must be bridged. How does one bridge this gap? This can only happen with increased exposure. It is common knowledge that multinationals, those engaging in large revenue transactions, with the e-commerce transactions having a huge significant revenue impact, may prefer going to one of the big 4 or big 3 or big 5 or whatever it is that we have today, or the corporate firms. So how one would equip and get the necessary exposure to deal with it, I think one must work out. And organizations like the RBA have a great role to play in this, in ensuring that the younger members have exposure to such issues. We must organize study circles, call guest speakers, try to see if secondments can be obtained for young practitioners in corporate firms so that they have exposure to international tax issues as well. This, in some measure, coupled with in-depth study, is what is necessary to bridge this gap between domestic tax and international tax practice. Now, coming to global tax policy. The OECD has been instrumental in forging a breakthrough in tax cooperation in, today I find, over 135 countries. We have the automatic exchange of information to multilateral information to avoid double taxation and foster cooperation. We've had tax information exchange agreements for many decades now. The effectiveness of this is somewhat political because one cannot deny the perspective of political involvement in all these matters. But as far as professionals are concerned, our role is to ensure that we keep abreast of these developments, to ensure that we make use of them when the time demands it. Now, the global tax regime is new. There are a lot of wrinkles that still need to be ironed out. As governments and businesses work through the kinks, the current stage in tax uncertainty and tax disputes will become inevitable and they will increase. A variety of measures, including cooperative compliance arrangements and mediation programs, must be implemented to help businesses to understand and predict the tax effects of international activity. You will notice that I use the word mediation. This then brings us to dispute resolution measures. We have enacted the Mediation Act, and we find that the revenue enactments stand outside the pale of the Mediation Act. So tax disputes historically fall outside the ambit of mediation as an alternate dispute resolution mechanism. And we know the reasons why. Revenue sharing between assessees and governments and revenue sharing between states and states are sticky subjects, and we would not like to leave them to the discretion of any one official to decide using ADR mechanisms. But having said so, old-timers in the audience would know that earlier we had a provision for settlement of penalty by the Inspecting Assistant Commissioner. I am talking maybe about 40 years ago. IAC had the power to negotiate and settle penalty. That was deleted. Then we had the chapter relating to Settlement Commission, and then the Authority for Advanced Review. The Settlement Commission has, the chapter on that has perhaps given way to more litigation than what was envisaged. Now, would that mean that it has defeated its purpose? No, because there have been several matters that have been settled before the Settlement Commission as well. And then nowadays we have the Dispute Resolution Panel, the DRP. And again here my information may be a little dated, but over the last 2 years, perhaps there have been other methodologies that have also come in to enable a settlement of dispute between the citizen and the taxpayer and the state. But I am cognizant that this is tough ground. But the role of a tax professional becomes very important to ensure that ADR has some play in resolving tax disputes. And where this happens at the first stage, where it is the tax professional, the income tax practitioner, the chartered accountant must provide the facilitation between the assessing officer and the citizen to iron out issues that may be settled at the time of assessment itself and continue only those matters that are substantive to continue onwards to litigation. This would ensure that there is some play of ADR also available in tax litigation. Today we have tax morality and fairness on the part of the citizen and tax transparency and fairness that is important as far as the state is concerned. You will see that I use the term fairness both for the citizen and for the state. That takes a cue from the fact that if mediation is to survive, if more amicable and civilized methods of dispute resolution are to survive, there must be fairness on both sides. And organizations like the RBA have a great role to play in this. Post-COVID, fiscally challenged governments have applied societal pressure on businesses to do more to support education, training, and other work-related requirements. As businesses accept their side of the social bargain, they will become more forceful in ensuring that governments fulfill their side of the bargain as well. And as a result, the pressure on making tax policies work becomes that much more necessary to be enforced. Tax policy must be geared towards creating a more sustainable and inclusive world, whether you are talking of arresting climate change or kickstarting circular economy. It is important that tax policy must be geared towards this, and organizations like the RBA, professionals here, must put forth your views to ensure that tax policy that is formulated. Of course, the judiciary has a role to play in this as well. But if we are cognizant of the roles that we have to play in formulating that policy, the world will be much better for that. And when we are looking at embracing the future, we are looking at guiding tax litigation to embracing a future that is more sustainable, ecologically, and in every other way possible. We are racing against time, so I just take a few minutes more. We are today in the world of data and the transparency of data, and this has to be married with the Digital Data Protection Act that India has also enacted last year. It is a nascent and virgin area, the marriage of data and transparency with the application of the Act. And I leave it for the young and fertile minds here to work out how that is possible. Artificial intelligence is playing a big role today, and I think a couple of sessions in the conference are also curated towards presenting the initiatives of Indian entrepreneurs towards artificial intelligence. The world over, there have been great strides taken. In fact, we have what is called BlueJay, all of you may be aware, which is a generative artificial intelligence tool that allows for AI to give solutions for tax disputes. This, they say, is going to take the world by storm, and we look forward to such initiatives coming from our entrepreneurs as well. I read somewhere that when you talk of embracing the digital transformation, there was a quote in the New York Times which said, quote, "Move too slowly and risk getting left behind. Move too quickly and neither the staff nor the technology will be ready." So this is a fine balance that we have to achieve. The state has to achieve it, the tax department has to achieve it, the taxpayers have to achieve it, we the judiciary have to achieve it, and that's the only way forward to ensure that we embrace the future in a holistic manner. I'll again end with a quote. They say, "Once a new technology rolls over you, if you're not part of the stream roller, you're part of the road." Today, we are all part of the road. The steamroller of technology has rolled over all stakeholders in the tax world, and we must equip ourselves in order to ensure that we embrace the future holistically and in an appropriate manner. Thank you very much. It was a pleasure being here.
Thank you, Lordship. I now request Advocate D. Anand, Chairman of the Conference Committee, to present a token of appreciation to Honorable Justice Dr. Anita Sumanth. Thank you. We will be honoring a few legends who are inspirational and have contributed immensely to this field of tax litigation. I now call upon Advocate Vikram Vijayaraghavan to say a few words about the legends to be honored today.
Thank you. Salutations to the legend. Salutations to the legend, Shri T.N. Sitaraman Advocate. Yes. Salutations to the legend, Shri T.N. Sitaraman Advocate. Immaculate and straightforward. The Revenue Bar Association has a glorious existence of 61 years, and the doyens of the legal profession, specializing in income tax laws, have been members and part and parcel of this great and impressive journey. The Revenue Bar Association Chennai, with profound admiration and respect, and to commemorate Shri T.N. Sitaraman, the pillar of the Revenue Bar Association, whose legacy of diligence, leadership, deep-seated belief in the power of law to empower and protect is unparalleled. Shri T.N. Sitaraman joined the Indian Revenue Service in the year 1957, and thereafter he began his practice as an advocate in the year 1971. He has served as the President of the Revenue Bar for the period 2001-2003. The Revenue Bar Association, in this two-day tax conference, Tax Litigation Embracing the Future, seizes this opportunity of honoring his achievement and his enduring impact in the tax litigation sphere. To Shri T.N. Sitaraman sir, on behalf of the Revenue Bar Association, we extend our heartfelt gratitude, our admiration for your unparalleled dedication and contributions to the field of income tax. May your wisdom continue to guide and inspire young tax professionals. I request Lordship to hand over the citation. The next one, salutations to legend, Shri G. Ranganathan, Chartered Accountant. Revenue Bar Association in Chennai, profound admiration and respect, commemorate Shri Ranganathan, a pillar of Revenue Bar, whose legacy of diligence, leadership and deep-seated belief in the power of law to protect is unparalleled. Shri G. Ranganathan qualified as a Chartered Accountant in the year 1956 and has appeared before various adjudicating authorities. He served as the chairman of the Southern Indian Regional Council of the Institute of Chartered Accountants for the period 91 to 95. The Revenue Bar seizes this opportunity to honor his achievements and enduring impact in the tax litigation sphere. Sir, on behalf of the Revenue Bar Association, we extend our heartfelt gratitude and admiration for your unparalleled dedication and contribution to the field of income tax. May your wisdom continue to guide and inspire all young tax professionals. Thank you.
Thank you. We are very happy to see that the families of these legends have also joined us today.
Honorable Mr. Justice Mahadevan, Honorable Dr. Justice Anita Sumant, President of the Revenue Bar Association, Sridhar, Chair of the Conference Committee, Anand, and friends. I must at the outset thank Vikram for the very kind words he has said about me, about my role with I thank Revenue Bar Association for recognizing me as a legend. If longevity is the criterion for a legend, I qualify for the recognition. After graduation in 1956, I sat for the UPSC examination. Upon selection, I was asked to give my order of preference out of various central services. I opted for railways, audit and accounts, etc. Income tax was my last choice. I got income tax. I joined service in December 1957. On completion of training at Nagpur, I was asked to choose the first place of posting. In the order of preference, Calcutta was my last choice. I got Calcutta. During my 6-year stint at Calcutta, between 1959 and 1965, I obtained my law degree. The next best thing which happened during that period was I got married to Vasanta in 1963. Between 1965 and 1971, we led a nomadic life, being posted in Bombay, Coimbatore, Chennai, and Trivandrum, where I served as an upper assistant commissioner for 2 years until March 1971. In July 1970, with the guidance and help of Mr. V. Ramachandran, I enrolled in the Madras Bar while still in service. In March 1971, I left service for the sake of my children's education and settled down at Madras. 50-odd years have gone by. I have done my job as an advocate to the best of my ability, ethically. I have not done anything spectacular. I developed a passion for income tax and have enjoyed every moment. I hope to continue the good work. With these words, I once again thank RBA for recognizing me as a legend in the presence of the honorable judges. Thank you, RBA.
I can request Mr. G. Ranganathan to say a few words.
Srimati Anita Suman and friends. I am twice blessed today in that I have been honored by the Revenue Bar and that it was so fitting that I have received it from Justice Anita, whose father, P. Ramachandran, and I had a long association. I cannot but now tell you, in my long innings of nearly 70 years, my association with the founding fathers, namely Swaminathan, K. Srinivasan, K. Ramamani, S. Padmanabhan, V. Ramachandran, made me acquire good knowledge of courtcraft, which is a must to all of us. I need to make a mention of my good friend V. Jagadisan, auditor, who was my good friend over long years in practice. I further learned much of civil laws, which I consider a must for any practicing chartered accountant, which I had the advantage to
Suresh, and our speakers, Mr. Rishikesh Datta and Mr. Hemant Bhattacharjee on stage, please. Mr. Rishikesh Datta will join us shortly. The topic for this session from algorithms to advocacy, the AI revolution, is the topic for this first session. For this, we have Mr. Kalpathy S. Suresh as the chairperson. And given the significance and importance of this topic, we have not one, but two very apt and eminent speakers for the day, Mr. Rishikesh Datta and Mr. Hemant Bhattacharjee. I now invite Advocate Vikram Vijayaraghavan to give a brief overview of the session and introduce the chairperson and the speakers.
Hi, good morning. Let's get started. Welcome to today's session titled From Algorithms to Advocacy, the AI Revolution in Law. See, Arthur C. Clarke famously said, any sufficiently advanced technology is indistinguishable from magic, and it certainly fits the bill with AI. AI in a short time has transformed not only our daily lives, but our professional lives too. And we are just getting started with this new age industrial revolution. So we are really looking forward to hearing from today's panel on their insights and wisdom on how artificial intelligence is going to transform the legal profession and can transform the legal profession from improving its efficiency, from improving its accuracy, to addressing new challenges, to ushering innovations in the field of law. Towards this, we are honored to have Mr. Kalpathy S. Suresh as the chairperson of the session with his vast experience as an engineer, founder and investor to offer his services. Thank you, sir. Let me introduce him formally. Mr. Kalpathy S. Suresh is the executive director and chairman of Veranda Learning Solutions. Entrepreneurial by nature, he is an active venture capitalist, angel investor and businessman. He is an inspirational leader and he helps the Veranda Learning Solutions, a listed company offering end-to-end solutions to the education space. He began his entrepreneurial journey in 1991 when he founded SSI, a software education IT training company, and by the mid-1990s, under the leadership of Mr. Suresh and his brothers, SSI became a publicly listed company, entered a joint venture with NASDAQ, and acquired Albion Orient Company, and by 2004, it had successfully bought Aptech and merged SSI's education arm with Aptech. He is often an invited speaker at IIT Madras in several societies and large corporations to talk on entrepreneurship. In addition to having been the IIT Alumni President in the past, Mr. Suresh is also a member of Young Presidents Organization, a global leadership community of chief executives. Mr. Suresh holds a bachelor's degree in electronics and computer engineering from the Indian Institute of Technology, Madras, and a master's from Clemson University, South Carolina. Thank you, sir. Thank you for gracing the occasion. We have two eminent speakers here today who will provide the unique insights from the ground, the battleground of AI, and they are Rishikesh Dattar, who is the founder and CEO of WakilSearch.com, India's largest and Asia's fastest growing legal technology platform. During his student years at the National Law School of India, University, Bangalore, he had the opportunity to work with an interesting cross-section of lawyers ranging from lower courts to Advocate General and Mr. Arun Jaitley in the Supreme Court. After graduating, he founded Vakil Search with the vision of making legal simple for millions of Indian citizens and businesses. Through a relentless focus on customer satisfaction, Vakil Search today has the largest client base, over 500,000 clients and 58,000 lawyers on its technology platform. They continue to innovate with products including Vakil Search, GRC and Libra. But Rishikesh has also been recognized as one among the 30 leading entrepreneurs in Asia by Forbes magazine in its 30 Under 30 list 2017. Mr. Hemant is a co-founder of Jana.ai, a startup that builds homegrown law-native foundational intelligence. Jana AI paralegal works like a chatbot to research and draft with quotes and citations and is releasing imminently. Their other flagship is a document management system for large firms and in-house counsels. Before co-founding his startup with two Harvard classmates, Hemant graduated from Harvard with a degree in economics. He was a co-author of the Economic Survey of India with the then Chief Economic Advisor. He led health and governance tech verticals at the Gates Foundation Delhi office, and he published research at institutions like the RBI and the MIT-based Poverty Action Lab, JPAL. We clearly have a very distinguished panel, and I'll let them take over. Let's get this started. I invite the chairperson to address his opening remarks.
Thank you. It's an honor to be able to talk to an eminent group of lawyers. I think many of them I know in my various walks of life. Great to have a couple of people on the podium who have built something in technology, but both come with a background of law and economics which I do not have. I will probably just sort of mention from a technology perspective the type of changes that have come. Before something like Vakil Search, I remember days, and sometimes it might even be very cinematic, but days when a senior lawyer counsel that when you walk into that room, you would typically find lots of big books. And here is somebody who would say that, for this particular case, you should take a reference of this case in 1926 from state of Maharashtra versus Raghuvanshi Mills. And by just quoting it, the case gets won. And that person as a senior counsel is revered. Something like Vakil Search can do it in an instant. And so things changed. I know of a very eminent Supreme Court counsel whom I have heard can review a case history of 100 pages in less than half hour and dictate as to how this should be argued in the court in about 15-20 minutes. A ChatGPT, not 4.0, but a ChatGPT 1.0 can do it in a few seconds. And so it moved on. I think the changes that AI is bringing into the field, in many fields, but also in terms of law, is going to be very significant. And I will, before the other two of my eminent people on the dais start talking, sort of in some sense throw the cat among the pigeons. There are many questions of law that will have to be fundamentally understood with the progress that AI is making. And I will talk of a few instances, and that will be a great food for thought, and probably set the stage for the discussion that we will have today. Many of us who have become great authors, who write, journalists, eminent authors who write books, literary and non-fiction books, we learn at the school. We read books like Thomas Hardy, we learn books from eminent personalities, Jane Austen, we build our knowledge, and then we become great authors ourselves. People, in fact, often say that a particular author's style of writing sort of depicts the influence of a certain author. And that was seen to be okay. Today, when AI can read all of those books and write a book exactly as how Mahatma Gandhi would have written, cases are being filed. In fact, one of the cases that happened in the US which brought the entire film industry to a halt in Hollywood was because exactly of this being called plagiarism. There are script writers who are saying that scripts that are written by an AI tool, because it has reviewed a lot of other scripts written by people, will actually have to pay royalty to the people whose copyright that it read. The case was won. And it was passed that if AI has reviewed a set of books and basis which it has written something, then the authors of those books will now be paid a royalty. And today an AI tool creates an audit trail of where this information came from. But if you sort of just look back to the example that I gave you, all authors who have come in this world did not grow up and learn in isolation. They learnt in school, they learnt in college, they learnt the Shakespeare's, and that molded them to write the books they wrote. And no case in the past until AI came has ever been made against the people who wrote in the style of a Shakespeare. They never paid royalty to the Shakespeare estate at all. And the law did not see it as an occasion to even think there has been a violation of law. Now that has got to be rewritten. If an AI tool can be asked to pay royalty because it picked up a scientific knowledge from a few journals, why aren't human beings being asked to pay that royalty? So far in this world, the law was not there to charge. That law will have to now be fundamentally investigated. So it might lead to even people going back and saying what we thought was not a violation of law might have to be pondered upon. It might actually be a violation of law that we were okay with because it did not move at that speed. A person from growing up to be able to become a mature author and write took 30-35 years. And that was an assimilation of knowledge which was historically available, but over such a long period of time. And the law seemed to connive such a violation. When AI started doing it in a few seconds, everybody is up in arms. That's a case one has to investigate. The second one, as all of us know, in a court of law, any digital evidence is really not accepted. A recorded voice, a recorded video can be provided to substantiate, but it's not a primary evidence. We will look for physical evidences. The way the world is going, it is possible that in many of the cases, majority of the submission will be in digital form. And hence, what would be seen as acceptable evidence that can be submitted in a court of law would also have to be investigated and possibly rewritten. And the third is, if AI, not just AI, but artificial general intelligence, and people are saying an artificial super intelligence which is typically defined as 10,000 times faster than the human, will they be considered as an entity in front of law? Or will it just be human beings? So if a driverless car hits somebody, will the liability be on the person who made the car, who made the software, or on AI? And it goes on. Very recently, about 2 weeks ago, I came across a company that can actually produce an entire business all by itself. An example was a company that trades in grains. An AI tool that creates the website, that creates all the pictures, it produces contact numbers, and when people call, there are chatbot agents which pick up the call, understand the inventory, cost of inventory, give discounts, close the order, take the money, place orders, supply, and complete. It can produce 10,000 agents, it can produce 5 agents, and all of it with nobody asking to recruit anyone. And it produces this entire business in all of 6-7 seconds. If that business does something which is against the law, then will the case be made against that software or that AI or the person who wrote it? So I think AI is bringing things at a speed that we have never seen before. And that's also the reason why the adaptation by humans has become very difficult. I'll sort of, give an example from an industry that we are involved in. All of us see the recent edition of Raiders of the Lost Ark as a movie. And Harrison Ford comes as a young person that we saw in the first edition of Raiders of the Lost Ark. Majority of that was produced by AI and de-aging software. It was never Harrison Ford. And Harrison Ford was actually paid for that call sheet, though he never acted. And that was also part of the contemplation in the cases that were filed on Hollywood, that if one can use AI to produce a personality and complete an entire movie without the involvement of the physical person, what is the royalty to be paid? And how much should be paid? In movies we have seen before, it is often common where we see somebody talking and behaving in mannerism of another famous actor. And it was all seen as in jest and in humor. People laughed at it. When AI does it, not many of them are laughing. They are running to the courts and filing cases. Right? So AI will lead, and with the progress that it's making at that speed, it will lead the entire legal fraternity to go back and think fundamentals of what is an entity in front of law, whether a human and an AI are treated the same. Will there be a separate set of law books for AI and separate set of law books for humans? What would be accepted in a court of law as evidence, and in what types of cases? I think it is going to lead to so many fundamental aspects that I wouldn't be surprised, like when Ambedkar endeavored to go and write the constitution, we might have to go back and write a lot of the law books all over again. And with that, I will close my remarks and sort of hopefully set the cat among the pigeons for very fundamental questions, and hopefully my eminent panelists on the dais will address them in their presentation. Thank you once again for the opportunity, and a very good morning.
Thank you, sir. I now request our first speaker for the day, Mr. Rishikesh Datta, to address you.
Very good morning, guys. Real pleasure to be here. See some very eminent personalities in front of me. Humbled by the people in this room. So the focus of the discussion today is really going to be around what are we seeing as a company at Vakil Search in terms of AI. What does the future hold? So naturally, as an individual, I'm very excited about the prospects of AI and machine learning in our industry. Our industry meaning finance, accounting, compliance, tax, and legal. So we look at it as one unit, we call it FACT. So in finance, accounting, compliance, tax, and legal, what is going to be the impact of AI? The common resistance of us lawyers when we think of AI is resistance. Because we think that, okay, it's going to disrupt everything else, but is it really going to disrupt the law? And most lawyers, if you ask them honestly, they don't believe it's going to happen. They don't genuinely believe that tomorrow there's going to be a robotic process happening in courts, allowing for justice to be dispensed in minutes. They don't believe that cases can actually be heard and disposed of by sentient robots in a matter of days as opposed to years and decades, as is the case today. But as someone famously said, magic is just science which is yet to be discovered. So I think, genuinely, based on what we are seeing today, it's a brave new world, it's an exciting new world. And what's the real difference, if you ask me, is that in the past, the role of a human being was to connect the dots. When I joined law school, as Suresh rightly pointed out, the biggest skill a lawyer could have is just the accumulation of knowledge. Anybody who had the most number of cases and arguments stored in their memory, they were the leaders of the pack. That very slowly evolved over 5-10 years to analysis. So the ability to not just know the dots, but connect the dots. But what is happening with GPT 3.5 and GPT 4 is that the dots are now being connected by machines. And what the role of us as human beings, and specifically as human lawyers, is going to be, is to imagine the next dot. And I'm going to talk you through some of the things that we are doing. This is in the context context of what is happening in the Silicon Valley, this is very pedestrian. This is not path-breaking, revolutionary stuff in context of what's happening in some of these deep tech firms sitting in Tel Aviv and San Francisco. However, in our industry, I believe that we have a lot of room to grow and improve. And I'm going to show you some of the stuff that we have done. Maybe the next slide, please. So, this is basically the core of what an AI engine does. This is the core of what an AI engine does. So if you look at it, if you ask it, can a non-director give a loan to a company? So what the AI bot will do is it will break this sentence up, which is just the English sentence, into necessary components. So it will identify that, okay, there is a non-director here, there is a loan here, and there is a company here. So it will then look at the knowledge base. It can process hundreds of millions of judgments in a second. It will look at the knowledge base of all the acts, all the bare acts, all the judgments available to mankind in India and across the world. And it will identify what the answer to this question is. Like the GPT-1, GPT-2, this was still very basic. But the GPT 3.5 and GPT 4, the AI bot has begun, the AI engine has begun to become very, very, very efficient. So it will then start reading out not just the law, it will give it to you in a summary, but it will also give you case laws supporting its point. So this is actually what is already happening today. So the knowledge base, this is the foundation of AI. So you can feed billions of pages of inputs over a matter of a few days, and then that machine will start reading this knowledge. And once you ask it questions, it will connect the dots, which is already there in its database, and start giving you answers. So the role of us, so this, for example, this is an email which was completely answered by AI. For example, if there's a customer whose GST has been rejected, right, it will understand the question. It will say, okay, this application has been updated. The government GST department has requested further clarifications, and our team is working. So basically, it will read the government notice. It will understand what the government was trying to say, draft an email response, and send it to the client. Now, no human being has actually prepared this email. This email was prepared and sent based on the GST department's notice completely by a bot. And I believe this is just the beginning. What is happening in Tel Aviv today and what is happening in San Francisco and to some extent even in Bangalore is actually mind-boggling. Very soon, AI will start creating a persona. So today it's just text. But the next phase of evolution, which Sam Altman of ChatGPT, OpenAI, already announced, is for AI to create a human being. So it will create somebody who looks like me and talks like me, who will actually get on a call with you and answer this question for you. Okay. So that's the next phase of a virtual lawyer. A lawyer who is actually created instantly by AI. You can give it any face, any voice, you can make it sound like, Amitabh Bachchan giving you legal advice instantly on this point of law. And Amitabh Bachchan will have all the knowledge which all the lawyers in the world have. Again, the point is not for us to get scared of this. This is just the state of reality. This is what exists. And regardless of what we want to do or don't want to do, this is going to keep getting better and better and better. The question really is, how do we therefore take advantage of this? And what do we as lawyers do as the next phase of evolution of lawyering itself? I think that the answer, like Mr. Kalpati Suresh rightly pointed out, is to reimagine what it even means for the legal profession. And what should be the goals of the legal industry in India? Now, we have very ambitious goals of being self-sufficient, of being a developed nation by 2047, of being a $5 trillion and then a $30 trillion economy. So for those objectives to be achieved, right, with a 130 or 140 crore population, which is where only 10% of the population actually accesses courts of law. Now imagine if we are able to actually start solving disputes in 6 months to a year. Imagine the kind of velocity of cases which will then be filed. Today only 10% of Indians or 90% of Indians don't have the courage or the money to go to a court of law. That's the reality. They stay away from it, they go to all kinds of shadow justice and behind the table justice forums to access justice. That's the reality of India today. There are many ways in which people get things done. 90% of people don't go to court. My belief is that if we are able to actually democratize justice and law by empowering lawyers and therefore bringing down the time and cost of justice and justice delivery in India, from 9 out of 10 people staying away from courts, that number can actually be reversed. All of us have problems in life, whether it's a consumer issue, or it's something at home, or it's something at work. All of us have issues in life. We choose not to go to courts today. In America, it's the opposite. They go to courts and they demand justice. The same in the Western world. We will change that dynamic when this happens. I genuinely believe that this will actually be the biggest benefit that the legal system has had in the last 80 odd years since independence, 75 plus years. Like Lenin said when the tanks rolled into the Red Square, he said sometimes decades take weeks and weeks take decades. The weeks have taken decades for us. It's taken 7, 8 decades for us to get to this place. But from here on, it is very possible if we are not going to take a tone of resisting change, but actually embracing change as it exists and pushing to the next level. I think in our industry, in the legal industry, in finance, accounting, compliance and tax, it's very realistic that decades will actually take weeks. We'll be able to do in a couple of years or in maximum half a decade what has taken us 75 years to do. So I'll walk you through some more things which are happening in the world over there. So this is actually a robot which was trained to talk like a human and answer queries about trademark application. I don't think I'll be able to share it because this is a secure link. But what this robot does is it actually knows trademark law, knows the basics of trademark law. And if the customer asks questions on trademark, it's actually able to listen, understand the customer's query and answer the questions. It's a self-training robot. Now this is again GPT 3.5. In GPT 4 and GPT 5, the robot can actually predict the question just the way a human can. So what's the difference between a human and a machine today? The difference is if you are a very highly experienced lawyer, even before the client asks you the next question, based on your knowledge of the client, the history of the case, you'll be able to predict what is the next question that's going to come and answer that question. Now what's happening in GPT 4 and GPT 5 is that's becoming the domain of the machine as well. So where we see this affecting and impacting advocacy in a very positive way is that the basics of client counseling, discussions with clients, answering routine queries can actually be done by the robot itself. A client, a lawyer, who has 5 juniors in office will have a 6th junior, and the junior will be a robot, answering all the basic queries, answering all the routine questions which clients may have. Right? Getting those answered. Whenever there's a complex question which the robot cannot answer, then the lawyer gets involved. So it's like having a junior available to you 24 hours a day, 365 days a year, who is constantly learning and training himself or herself. You can give this robot any personality. You can make it a 20-year-old man, you can make it an 80-year-old woman, and anywhere in between, any accent, any language, any dialect. It's completely language agnostic. So it can learn Swahili and can give advice on trademark law in India in Swahili to a customer in Kenya. It's very good. So this is more simple. I think this many of us have already seen. This is basically machine learning. So you can extract information from any document. So you give the PAN card of any individual, you give any other document, it will immediately extract. This is one of my colleagues. So you can, for example, Abdul Rahman Khan. So his entire data can be extracted in a second. Now this is very rudimentary today, so I won't dwell too much on this. So the last application which we have applied machine learning and AI in our organization is in routine automations. For example, if you want to file a trademark, if you want to incorporate a company, both of those get done in seconds. Now this is another area where I believe lawyers and lawyering particularly can take a big leap forward. An inordinate amount of time, both of the judges and the courts and us as lawyers is taken in repetitive routine tasks. All of us have seen that about 70-80% of time before a judge in court actually goes into any stuff other than the dispensation of justice. This can eliminate all of that. This is again basic. This is evolving every day as we speak. So processes like adjournments, passovers, right, listing of matters, calling, all of that can be replaced by AI. We do not need humans. We do not need to waste the court's time. We do not need to waste the litigant's time in that process. It can be completely done. Even matters in criminal law, like you want to see whether you want to bring a prisoner to court, that entire process can be done with augmented reality with the prisoner in jail. So you don't need to have the burden of transporting them. It's consumption of time and consumption of cost for the system. All of that can be done with simple implementation of machine learning tools. So let me come back to where I started this conversation. Sometimes weeks take decades and decades can take weeks. We need to look at, as a country, as a legal fraternity, as a system, finance, accounting, compliance and tax system, if our ambition is to keep up and in fact beat the pace of growth of this country in economic terms, if we have to become an advanced economy by 2047, we cannot enter into a first world with a third world legal system. The legal system cannot hold back the country anymore. The legal system has to in fact advance the country to the next level. If cases can be heard and disposed of in a matter of 6 months to a year, there are calculations by the Dutch Foundation which show that it will triple the number of people entering courts and it will add between 2 to 4 percentage points to the GDP. Adding 4 percentage points to the GDP literally means lifting 100 million people out of poverty. So that is the opportunity, and that is what, if we are to resist the introduction of technology, if we are to resist making the legal system faster, more efficient, more consumer friendly, and in this case the consumer is the client, the consumer is the litigant. If we are to resist that as members of this industry, this profession, then we are actually going to hold back 100 million people from escaping the clutches of poverty. And that blood will be on our hands. There was a very unfortunate judgment of the Madras High Court a couple of days ago, where the judge in very socialist tones pointed out that the legal industry is not a business, but it's a noble profession. Now, I have no dispute with the fact that the industry is very noble. We are doing something which is actually helping the common man get justice. But that something which is noble can also be a business. Something which is noble can also embrace technology. Something which is noble can also set moonshot goals for itself in terms of serving the purpose for which it was designed, serving the purpose for which it was built, and serving the purpose which it is meant to serve. So today, the unfortunate reality which we cannot escape is that because we have been resisting the implementation of technology, we have been resisting following best industry practices in our industry, we are the laggards as far as time, turnaround time, resolution time for a case. In all these areas, we are real laggards. See where, in our own country, see where food delivery has gone. Could you imagine 10 years ago that I could press a button and my groceries would be delivered in 7 minutes? Was it even imaginable for us? But if that same country can do such magic in other areas, why are we content with such abysmal rates of justice delivery in this department, which is in our control, which is in our purview? So the question I'm really leaving all of you with is that the technology is here and the ability for us to make change is here. The decision to make change lies in our hands, and how quickly we adopt it is really going to make the difference between whether we continue to let decades take decades or whether we can actually make decades take weeks. So with that, I'll take a pause. I'll let my next speaker take over. Thank you so much.
I now request Mr. Hemant to speak.
To my deck. I do a lot of these days, more than I expected to, and it's either meetings of technologists or lawyers. It's always funny because when I meet lawyers, they assume I'm a technologist, and when I meet technologists, they assume I'm a lawyer. And I get by pretending to be the other in either group, but the truth is I'm neither. And which might make you ask, what are you doing here? And they say failed mathematicians turn physicists, and failed physicists turn economists. So that's the long marks that I've taken to here, and I was a little concerned when Mr. Sridhar emailed me asking me for a paper, because among the other failures, I'm also a failed academic, which is why I have a startup and live in Bangalore these days. But it's also humbling, as Rishikesh pointed out, to be in a very eminent room. Right? I remember when I was working at the Gates Foundation, my mentor and boss was this lovely retired IAS officer who was the chief secretary of Bihar. And he loved giving me life advice, and one day he was telling me something about life and was like, take this as advice that's coming from someone in the position of your dad. Then he took a pause and he asked me, what is your age? And I sort of feebly let out 21. He thought about it for a long time and then said, okay, maybe take it as advice that's coming from a granddad. And I think maybe there's some reciprocation I can do there. And a little bit about why I do what I do, which is build legal AI, is back in the day I used to work with law and econ folks, so folks who are making quantitative research on the law, and we write those papers which are like, in the US, judges are more likely to grant a bail application post-lunch rather than pre-lunch, or asylum applicants can actually be processed without ever reading their case, and we can fairly accurately predict what the result of their asylum would be. Or we can look at criminal defendants, just their mugshot, and predict if they will be sentenced guilty or not, even before the trial starts. And it's from writing these kinds of papers that I then took on the other eminent trait of, I think, perhaps what history will remember me for is being one of the first 500 or 1,000 people in the world to cheat on a college exam assignment using ChatGPT. Back in the day when GPT wasn't publicly available, but was only available to developers and scientists who had to request access and submit resumes to get it. And when we started playing around with it, it was sort of immediately apparent that things had changed. What we thought of as language is something that is inherent to thinking and to articulation and to how humans exist, was suddenly something that the machine was playing around with. And when we realized that we can make talking computers, it sort of brought a bunch of my classmates and myself from Harvard to Bangalore, and we were in Chennai before that, and now we build legal AI. We can go a couple slides ahead. What I thought I'd do is, given that I'm neither an expert in the law or the technology, maybe go into what I can do, which is a little bit of the artificial intelligence, and talk from a very first principles point of view. Sometimes by first principles I mean lacking expertise, but that's a fresh eye to look at things with, because it helps us, look at things from a matter of their intent and from their design, rather than from where they happen to exist today. So I thought first I'd go over what is AI and why does AI work so well and why can it do all the things that it can do, and then think about what legal systems are and why they exist. And then maybe in these motivations for why both of these things exist, we can identify an intersection together. So when we started out building AI, it was in the 1950s, back when computer chips were not big enough to build the models we have today. But we looked at the synapse in the brain and we thought, hey, we can build a neuron like that in a machine that fires or doesn't fire when a particular input is given. So the same way when I see something, a part of a neuron that's attached to my vision system fires, and that allows me to process the image and build a sight out of it. The AI does something similar, and that was the invention of the neuron, a perceptron, as Rosenblatt called it in 1957. And it's funny that it works so well, because in some ways it's a parrot. And you might also want to get used to this format. I'm going to have a lot of slides with seemingly unrelated and nonsensical images. But in many ways, AI is a parrot, right? And it repeats what we say. And it does that by mashing together things that it heard from different places. But the funny thing is, so are humans. I remember this early article that came out in this wonderful AI blog back in the day when GPT-2 was released to scientists and researchers. And it was a machine learning researcher wrote to the author of this blog saying, AI is not really much. It is a stochastic parrot that mashes together a soup of the internet and pours it as a tasteless gravy into my plate. To which the author replied, well, your mother is also a stochastic parrot that mashes together everything on the internet and pours it as a gravy on your plate. And it's a crass joke, but it really explains how humans learn. And we again and again find these examples in early childhood development where humans who are simply exposed to more words, more sentences, or just watching and listening more things in the first few years of their life have lifelong gains in IQ, employment, achievement, attainment, and so on. And it's because perhaps the best way to imitate is to learn. So a couple of folks have talked about GPT-like models, and this is a little GPT auto-completion when I was writing the About page on our website, and I was writing about my colleague Pranav who's here, and I wanted to show how the AI works and why it fails the way it does and why it succeeds the way it does. And the truth is, the same thing that allows ChatGPT to write poetry is also the thing that allows it to invent cases and to take a petitioner from one famous case, a respondent from another famous case, an entirely different third date, and put it together and propose it as a solution to you. And it's because these models are trained on predicting what we call the next token, which is the next word or the next sentence in a given body of text. So really what the AI has been taught to do is to imitate humans so well that it's predictably always going to be believed as something a human wrote. And so when I started writing Pranav's name and started writing that he was going to start an LLM, it immediately wanted him to have gone to Harvard and before that to NLSI. And Pranav is an overachiever himself, but the pressure that AI puts on us is because, again, the most likely thing that you would believe if I told you someone went to an LLM at Harvard is perhaps then they went and did their BA LLB at NLS. So then I clarified the AI, I start typing LLM candidate, UC, and immediately now it's updated itself and it says, okay, he's probably going to UC Berkeley, then again picking the top University of California from a dozen options, and then still maintaining that Pranav should have gone to NLSIU. But it's this one magical trait wherein to finish a sentence, you start behaving the same way a human does, the same way a child repeats back words from its parents. But in the process, as you apply more and more parameters to the AI and give it more and more data and computations, as you burn energy onto it, it sort of realizes that the best way to pretend to be a human is to be the smartest human in the world. And it sort of realizes the best way to lie about topics is to actually know everything about them, and to say something plausible is more likely established when you say something true. And this is the world we exist in, right? When AI started out, right, in the 2000s, people used to say, if you're an artist or you're a programmer, you don't need to worry about AI, because programmers are going to be making the AI, and artists are going to be making art, and these are the things that AI is going to do last. Turns out that it was the first things that AI did. Today, 50% of lines of code written by all software companies are written without any human touch. And every artist, graphic designer, and other advertising agencies are threat. In fact, entire movie makers are under threat because we're developing models that when, as a client, I describe, say, a piece of art, it commissions it itself and produces it in a matter of seconds. And really the reason I wanted to show these two images is because they really show the edge of art. Maybe we'll do a show of hands thing. If someone can tell me, I'll first say left and then I'll say right. One of these is a work of Escher, who's one of the most famous contemporary artists in the world, and the other is generated by a machine. So maybe those who think the Escher is the one on the left can give me a set of hands. Okay, small minority. And what about the right one? Is that the winner? Okay. Another small minority as well, but we'll take it nonetheless. So the one on the left is a painting by Escher that was thought to be groundbreaking because it shifts perspective several times. So based on the axis of perspective you take, it is actually an entirely different art piece. And the work on the right has learned to do this. And we think, creation is something that is unique, that involves this sentience and this human application and exertion to produce. But really it's something that's a little bit more reducible. And the reason I'm droning about all of these different and radically, disparate use cases for AI, the reason why AI can do time series prediction at a finance company and trade algorithmically, and at the same time produce a piece of art that changes based on perspective, is because really we have succeeded at building good representations of everything in the simple art of linear algebra. So we can represent almost anything, and I think this room might particularly enjoy this. We can represent almost anything as a table. And really it turns out that it's true because by reducing everything from art to tables, we're able to train models that can predict the sequence such that that sequence might be a set of pixels finishing an image line by line, or it might be an entire work of art like Mr. Suresh was talking about, or it might be a legal brief, a citation, a piece of case law that it's read and is reproduced. And the concluding thought I want to have in this first AI segment of what I'm talking about is that, as Rishikesh was pointing out, this is not something to be worried about, but really something to look forward to and to be excited about. So obviously technologists are the earliest adopters of technology, and they're the first ones to adopt AI and use it in their practice as well. And in this world where a model like GitHub Copilot writes 40% of the lines of code that go into production, the biggest result for me, obviously, people say they're more productive, they're able to get more things done, they're able to do higher quality work, that the timelines are getting shorter and so on. But none of this stands out to me. The real thing that stands out to me in this graph is the thing towards the end. People report way less frustration with their work, way more life satisfaction, and that they actually enjoy going into work day by day after their workplaces get augmented with AI. And it's an equalizer at the same time. Similar study happens in I think it's at Bain, the consulting group, and they give a disparate set of consultants access to AI models and let them use it while producing the materials they're doing for clients. And it turns out that it's an equalizer because the really good consultants remained the really best consultants even after AI was introduced. They were still the first, second, and third best performers in their firm, but maybe they performed a little bit better. The real difference that the firm observed was the entire bottom half of their performers suddenly started competing a lot more with the top performers. And I think to the people in this room, that could be a little threatening in the sense that you've spent a lot of time ingesting case law, as Mr. Suresh was saying, such that, I can ask you for a particular piece of precedent and you will be able to give me the most decisive authority on it. And it's that skill that we're replicating and equalizing more and more, and that's what we do at Jana, my company, as well. Right? But I thought now that we have this groundwork that AI can really do most things because we can represent them as tables and numbers, and once it can, then it's getting better and bigger, and as it gets better and bigger, its capabilities and agency level, meaning how much it's human-like and can make decisions for itself, only improve. So then I thought maybe we could think of the motivation for a law or legal system in the first place, and think about why this exists at all. Right? I mean, there's this history that we broadly agree on in intro to jurisprudence. So we think about private societies having norms as a way to enforce things like debt obligations and to enforce criminality. And from there we have things like the Hammurabi Code, which again established the powers of a king. So law arises in a slightly shady manner where it is the source of authority for an autocrat. And it's established as a means of coercive violence against the population in the sense that it establishes a state that is controlled by some plutocrat or technocrat, and in that cleavage enjoys the benefit of the wealth and revenue of that society. But then with Magna Carta and then Locke and this idea of a social construct and this idea that there are natural rights, we get to a legal system we do have right now, which is meant for principals to freely interact with each other with protection. And I think this is where we've had the greatest stagnancy in terms of the evolution of the law, in the sense that for 200 or maybe 500 years since the Mughal courts, or longer since Magna Carta, we've built legal systems as a way for free principals who want to work with each other, who want to protect each other's rights, and who want to enter meaningful negotiations and relationships to do that. But history has made it difficult for a legal system to be, full of flowers and blossoms like that. And through centuries of fraud and malpractice, we increasingly produce more and more procedures so that everything could fall into a well-defined modus operandi. And we thought if we did that then we would be able to protect our clients from both current and potential adversity. But slowly and steadily, we see procedure becoming more and more an end of its own, right? When anytime there's a transaction, there are two parties that are doing due diligence for the longest time, and they construct materials for each other's due diligences and do the report on the other side. And these kinds of systems and solutions are built on a state of no trust, where we have to account for the fact that sometimes humans play zero-sum games rather than positive-sum games, and we have to control for humans who want to be free riders. And through this, we devise legal systems that become increasingly procedural, increasingly hectic, increasingly more paperwork, increasingly difficult to be a lawyer in. Right? And in this transition, we now see the law as a system and end of its own, absent of its origins, where we simply want to facilitate free principles to conduct transactions that are mutually gainful. And this is a paradigm that we can take back to the drawing board now, right? And I want to point out that we go back to the drawing board quite frequently in a justice system. And this is part of what Rishikesh was also saying about embracing change. But we do change legal systems and define them most recently 50, 30 years ago. We have systems that are judge versus jury systems. We have the Commonwealth being a common law system, and states like the US becoming increasingly civil law systems. We have, states like France or Germany that have inquisitorial criminal justice systems rather than an adversarial one. And these are the kinds of decisions and choices that govern how a court or a legal system is run. And I want to really point out that we have to make these choices for courts to exist, and for the law to function, and for the rule of law to be smooth and free-running. And we have to remind ourselves that we constantly make these design decisions, because we're going to have to make a lot of them, and some of the more radical ones, like Mr. Suresh was pointing out, about whether copyright has any natural origin anymore, given that everyone takes from the commons and gives back to it, and given the idea that no idea is an original idea, or questions like once we build an artificial general intelligence, what is the status of that entity? And when we think of these systems of law, we need to be open-minded enough that when we see these intersections, we can then design legal systems that embrace and predict change rather than resist it, right? So I want to point out that we're just getting started with AI. You might even check out our little kiosk outside, and we have some demos on some laptops where you can play with the AI. And what I'll tell you today openly is that the AI we have right now is the worst AI we're ever going to have. And if you come back tomorrow, the AI we'll have tomorrow is going to be the worst AI we're ever going to have, and so on and so forth. And we see this sort of early dance with this system of AI where everyone by now in this room knows what a hallucination is. And it's because models snowball and predict next tokens that they sometimes predict something that's more poetic and less factual. And we've seen this happen in legal systems already, right? There was a Brazilian city where the senator who produced a piece of law didn't tell anyone that it was end-to-end completely written by ChatGPT until after it was passed without any amendment by the city senate. Or similarly, a New York lawyer, the unfortunate fellow, was fined $10,000 and held in contempt because he produced a brief that was edited by ChatGPT and that included a couple of citations to case law that doesn't exist, right? But these things are going to change, and we've seen this change in other verticals and other industries. So food delivery, like Rishikesh was saying, but really the foundation of modern day capitalism, assembly lines, have changed from human labor, and that's a part of the transition in India as well, right, is that we're becoming a service economy, leapfrogging the whole manufacturing stage, where typically economists think of growth as an agrarian to manufacturing to service stage. So we have that habit of never finishing building 2G towers and just building 5G straight, and that's what we're doing with the economy as well, right? And we've seen Henry Ford's line become completely run by precision manufacturing robots that can have microns of accuracy, right? However, we also see that some things don't change. The chamber of the CJ at Madras High Court probably looks pretty much exactly the same as it did 50 years ago, except for maybe one important intervention, and this is perhaps the only technological disruption that's happened in the law in the last 80 years, is the introduction of Microsoft Word and the death of the typewriter, right? And it's something that's important to be resistant to change about as well, right? And I think I take a very different attitude to things like whether judges can become robots and settle things, or whether maybe Lok Adalats can be run by these automatic policy checkers that read facts from given sources and then just say, okay, I'm settling it this way. But I do think workflows are going to change. So access to legal information and research is one salient example, right? And we like to think of it at JANA as a rising tide lifts all boats. And that's why the legal industry, as Rishikesh was pointing out, is a noble business, and both of those words are important. And when the business does better, everyone does better because it has a noble intent. And a rising tide that improves the access of legal research and legal drafting or arguments that are produced in court improves everyone's quality of life. It improves rule of law, it improves the economy, it improves access to natural rights and justice, right? But I want to be a little bit more creative about what I think our AI future looks like, especially as we transition towards a world with artificial general intelligence, which is basically human with greater capacity plugged into the internet. So one example we've seen happening already, and this is already happening in more mature economies, is the negotiation of contracts. Everyone knows, if there's an in-house counsel in the room, you'd know that entering a negotiation is a fairly predictable process for you. You enter the template knowing that the other party will pick fault with these exact 5 things, and surely they pick the problems with those exact 5 things. You have an approved fallback that your CEO gave you 5 years ago that you go back to them with, and then you come back and go back and come back and go back, and 6 or 7 times of redlining later, you're done. Now imagine a future where negotiation or mediation, for example, was done by agents that are not legal agents, not human agents, but artificial intelligences, where a judge has to just come back in 30 minutes and see this report produced by 2 AI bots arguing against each other, each producing a comprehensive list of citations, of case law, of statute, of notifications, rules, regulations, and so on. And all that has to be done is to see, okay, all is well, this is what has happened as a resolution of it. And this is not something that's strange to us, right? Already, if you go to a lower court in India, we make fairly procedural arguments and then say your honor knows best, and the judge sits down and says, okay, the precedent for the petitioner is this, for the respondent is this, and I resolved it thusly, right? Which is a practice that we can fairly speed up if we have, say, two AI lawyers that are arguing with each other. The other thing, perhaps, is the role of a new associate or a junior is something that's up for grabs and now competitive, right? Because there are things that are more descriptive, more strategic, that experience and knowing the bar gets you. There are things that are more rote and more based on application of time and effort, which now a model can easily do. I can just upload my client's files, a set of facts, and I can have the AI pull up all the legal risk associated with it, any compliances that are missing, any enforceability issues in a contract, and it can do this red flagging for me and return a table. And that makes my work faster. It also makes it higher fidelity, right? Maybe I make errors 3% of the times, the AI makes errors 5% of the times, and there's an intersection there where we get closer to a 99 and a 99.9% in terms of fidelity. And I think these are some of the more exciting things, right? Nobody likes to find out in court that a precedent they cited has been overruled when the judge tells you so, right? Or when you have to produce a printout into the bench. And these are the kinds of things that we can catch earlier and faster. And I think this is already something that's happening for things that are allied to the practice, right? Justice Chandrachud is a proponent of AI. We've launched large campaigns trying to build translation tools, dictation tools, transcription tools, and so on that use models. But that's just the beginning, right? Because AI can do things like risk evaluation. It can do things like producing memos. And in revenue and tax right now, we have faceless audits taken care of by AI, where it can flag something as likely to be scrutinized or needs to be scrutinized, run a scrutiny itself, produce an audit report for me, and then as a human evaluator, I just need to sit there and look at the finished outputs of various AI auditors and decide which ones to take further actions on and which ones to pass on. And this is this evolving landscape we live in, right? And it's confusing because I think as humans, one thing we're very proud of is the right and ability to make our own mistakes and to learn from them, right? And that's why we believe in democratic systems and are strong proponents of democracies, even when they tread down, populist paths or fascistic paths. We'd rather make mistakes and learn from them rather than give away our agency and our right to make decisions for ourselves. So that's why, for example, governments like France have already banned AI from doing predictions of judgments. So in France, you're not allowed to build a model that can sit down and say, this judge is likely going to rule this way, because it erodes your ability to deliver justice in a manner where humans have agency and control over their own lives and the ability to self-determine the nature of their existence. But at the same time, I think some things are going to change. So maybe before you go to arbitration and before you have to spend 3-4 days even getting either client or either party to say what they really want and what they're willing to compromise on, each party can give a robot a list of things that they definitely want, a list of things that are ideal, and a list of things that are aspirational, sort of rank the different things that are under the dispute. And then the two agents can spend time negotiating with themselves and offer to the mediator 3 different compromise solutions that they predict will likely be accepted by both parties. And all I have to do is then make the awards that everyone agrees on from that given list of options. And I think in this changing world, we have to also be careful about alignment, because all said and done, we only understand the AI through metaphor. It's a black box and we can't look inside its brain. It's inscrutable, a lot like our brains, right? All we can do is take an MRI of a human brain and say, okay, when they do this part seems to light up, there's activity in this part of the brain. But that's about as much as we can do. We can't really explain how consciousness works, why it forms, or what makes it so special. And it's the same thing in AI as well, where all I can tell you is these synapses and these neurons are firing for these particular kinds of things. And this allows this concept to emerge where we have this incredibly strong and powerful actor that can do a lot by itself, but really something that we don't understand, right? And I think Richard Feynman said something along the lines of, if I don't understand it, I can't make it. But the problem is we've made it, and we still don't understand it. And he also said, to reinvent the wheel from scratch, you have to first invent the atom. And we've even succeeded at doing that. We just don't understand what we've done and how we've got there. So it's almost this religious process of black magic, right? Where we've raised something from the dead and we've, Nietzsche said we've killed God, but these technologists think we've made God and put it on a server in Hyderabad on an AWS computer, right? So when we deal with this inscrutable phenomena, the thing we have to be careful about
is that we have to build systems that ensure that its goals and actions are aligned with human values. And specifically in the justice system, where it's a high-stakes system, right? And it's not just in terms of the liability that as practitioners we take on, but in terms of the outcomes being literally often life or death. And in those situations, I think it's very important to be thoughtful about how AI is designed such that it's grounded in both alignment with human values as well as with reality and truth, so that it doesn't hallucinate, it doesn't invent its own precedent, but also importantly so that it doesn't reproduce biases that it often learns from humans themselves. And the AI you're using to review your contracts quite possibly was trained on Facebook, on Reddit, on Twitter. So it's read, 400,000 men in Tamil Nadu arguing about Vijay or Ajit, and that has trained it and produced its knowledge base as much as, reading 50 books by Mullah has. And you don't know which of those weights are going to fire when, and which knowledge from where is acting when you are working with it. And I think that's why the note I want to end on is we have to be ambitious but also aligned. We have to think big in terms of how legal systems are changing, and we might really have to go back to the drawing board and make decisions that are much more constitutional in nature, much more redesigning how justice systems and courtrooms work, what the procedure for evidence is, how evidence rooms are, or discovery rooms are scrutinized. We might have to change how negotiations occur and how much work humans really do. But in the process, I think we'll end up in a world where work is less frustrating, where people are much more happy to go to work, and we're only making the most intelligent use of our times. And at the same time, we should also be able to build AI models that really only want what we think is best for ourselves, where the we is well-defined and best is well-defined. So having sort of ended up at the latter end of two long and great speeches, I think I'll call it dibs there. Great. If you could just hold on to the previous slide. Yeah. I thought I'll end on these quotes, which are from the first page of Madhav Khosla's book, which is this lovely book called Our Founding Moment, a book about the writing of the Constitution and about the Constituent Assembly debates. And and I feel this is a recurring phenomena in that people give out condemnations of new things even before they've had time to breathe. Famously in 2004, the Nobel Prize-winning economist Paul Krugman wrote in the front page of the New York Times, "The internet is a fad. It has no impact on the economy." And I would say the majority of the economy in Chennai these days comes from internet and the businesses that arose out of the internet. And I think historically, when countries like India have built legal systems as well, it's been written off in the same way. And it might be because back in the day we thought legal systems are best held for men or for white men or for propertied men. And then maybe we thought legal systems are best run only by humans. And that's the juncture we're at. And just like, James Fitzjames-Stephen was proved radically wrong by the working of the Constituent Assembly, and this functional republic we've been able to build out of many countries, stitching them together under one constitution. I think this new world is also something that's going to happen, whether we like it or not. And that's part of what we try to do at JANA, is to be among the people building it so that we can build it in the design and reflection of what is the best of humanity rather than what is perhaps some of the more subliminal parts of it. So thank you so much for having me. It's been an absolute pleasure. And we have a little booth outside, and I'll be more than happy to talk to any of you and keep this conversation going. Thank you.
Thank you, sir. We will now have an exciting demo by Jana.ai. Please give us a few minutes to set it up, please. If any of you have any questions, please feel free to ask while we get the demo ready.
Okay, I'm glad I can show and tell as well. So a little bit about us is we're just about to launch publicly. So a lot of this is things that have been living in a cave for a long time and are now meeting human eyes for the first time often here. So I've just logged into Jhana, and you'll see here that I have two interfaces for the litigation part. The first is this search engine, and I'll show that to you in a second, that works quite similarly to how your Manupatra or your SEC or any of the other ones work, except that they're state of the art and use AI, and you can work with them by just describing a story-like thing in a paragraph or by uploading a file or doing both. But really the flagship feature is this paralegal tool we have. Let the Wi-Fi load for a second, but I'll talk over it. And it's listed right now in this chat-like interface. And what it does is it produces any kind of deliverable you need, be that a draft, a set of research memos, some ideas, brainstorming, strategy preparation, whatever it is, it produces that kind of deliverable. And it does so by querying these various tools that are experts in them each set or part of legal sources. And it does this in a human-like manner, the same way an associate might think, okay, to answer this, I must first learn about what the area of law is, then I should pull out that particular section from the act, then I should find the case law that affects that section, and then from learning about some of the case law, you learn, okay, actually there's this other thing that I need to figure out for this. Then maybe you look at some authorities, some textbooks, you look at some legal blogs and news, and you compose all of this information together to build a convincing repository of information. And that's exactly how it works, in that there's this iterative reflective agent that can constantly phone a friend almost and keep talking to these specialized bots and put together information that is specific and comprehensive. So anything that Jhana produces is quite unlike ChatGPT, for example, is tethered in reality. So it can only make claims that it has a quotation and a citation for. And everything it claims has an inline footnote that you can immediately click in to view the full file, or in the bottom here, when you open it, it'll tell you specifically which section of which act it's quoting and which paragraph from there you're being quoted, right? And you can just go in and look at the rules or some of the subordinates or look at the act itself. And we do this workflow across a number of different tools that you might want, right? So obviously we have statutes, we have judgments where it will pull out the citations you need from different case law. So here, for example, we're looking at PMLA cases, and it's telling you which pages of which criminal appeal with what bench and what court on what date is it looking at, and it will cite the paragraph it's coming from and even give you a confidence score so you can preemptively guess if it's a good source or not. And we simultaneously also allow you to work with your own files and folders, right? Let me just... give me a second. I have another account with some files uploaded that I can show you. And simultaneously, we allow you to work with your files and folders in the sense that you can compose them and figure out if there's something that's not enforceable or not compliant or not up to date with the letter of the law, or you can automatically have it evaluate risk and so on. I'll just let that load. So what I mean by that is the moment you upload a file onto Jhana, it takes it apart, analyzes it, understands what is a checklist of questions that it should ask to be able to answer a particular query, and it's able to go through that table and produce results that you require. Simultaneously, it's also able to compose that with the external parts of the law, where it can put together information from the web, where it can use the web like a human being, Googling something, clicking into a link, reading something in that link, and then clicking further and further in. And it works as a collaborator rather than a replacer, in the sense that it's a co-pilot and not an autopilot. So it works with your prior conversations. It'll pause sometimes and ask you for a clarification. It'll even cite textbooks, right? And here you can see, for example, this is MP Jain Constitutional Law, or Principles of Statutory Interpretation by Singh from page 238 that are being cited. And it's able to produce for whatever you need by analyzing the sources that are relevant to that particular case and that particular set of requirements, a final output for you. So here it's able to filter for Supreme Court, filter for a date, and give you a set of results that again come with citations, right? So maybe we can do some live ones. If somebody would like to give us a query to type in, and we'll click enter. The query will be like an instruction you might give to a junior to do some research. Okay. Totally natural language.
What if the assessing officer prepares the computation sheet on 21st November and then prepares the assessment order on 10th December?
Now immediately Jana is going to start thinking, and it's going to go through this loop where it will have a thought, it will phone a friend and ask for help, it will read the results it got. If it wasn't useful, it will tell you, oh, I made a mistake, so I'm going to change my approach in this way. Otherwise, it will tell you, now that I've learned this, the next thing I need to do is this. And so we keep it transparent and verifiable, because we always remember that the true expert in the room is you. So everything is one click away and immediately back checkable. So now it started by looking at statutes, which is a decision that it made. And it's going through various different tax-related acts, starting from your Sales Tax Acts to National Tax Tribunal Act and so on. There's the Interest Tax Act now. So it will go through a whole comprehensive set of documents and then tell you if any of that was useful. And then it will pick its next step. So now it's finished with the first step, and then for anything that's here, again, it comes with a citation for you to look up if you need it later. Now it's moved on. It said, let me look at textbooks and reputable web sources so that I can actually find the procedural information about the assessing officer preparing a computation sheet. So next it's decided to look at judgments. So it's pulling out a case, Sri Balaji Rice Mill Bellary versus State of Karnataka, for details regarding assessment and penalty. So for each of its particular cases, it's going to pull out what part of it is relevant to you and what is the implication from that case that you might want to take in mind. So it's done that now, concluding up for you, summarizing what it's learned from this particular tool. And now yet again it's going to have a thought. And I suspect that it's going to be disappointed with what it's found so far. So it says, I've found stuff about timely action by authorities, implications for failing to meet procedural requirements. However, none of the cases directly address the specific scenario of an assessing officer failing to meet procedural requirements. So it's decided, let's actually look at some textbooks instead. So again, what is it looking at? Principles of statutory interpretation is one. It's looking at the law and practice of income tax by Kanga and Palkiwala. It's looking at principles of administrative law. So for each area of the law, we have various textbooks that are authorities in them. And now it's pulled out a set of information about retrospective applications, retrospective taxing, assessment and reassessment procedure, and communications of orders. And it's made a conclusion about demand and recovery. So it's having a lengthy thought here, preparing to conclude, and it's finished up. So we'll just give it a second to reload. So the website is faster, if not for the Wi-Fi here. There we go. So that's our finished answer. So it's decided that the order of payment has a maximum time limit of 3 years from due date of filing annual return, and that for cases involving fraud, willful misstatement, or suppression of facts, the time limit extends to 5 years. But it wasn't able to answer the core procedural issue. So it's pulled out to you that, okay, these are the things that are the variables that affect it, and you should look at the state guidelines as well, And from reading textbooks and so on, it's at least able to tell me that notice under section 148 might be issued for making an assessment or reassessment and so on. So the thing that we work really hard on at Jana is getting answers while they're available is fairly easy. It's something that any AI company can do. Getting it to say, I don't know, when it hasn't found the right information is actually most of our proprietary work. So we work really hard on ensuring that it will, in the case where it can't find something, give you a follow-up question or suggest a different strategy rather than tell you something that isn't particularly useful for you. Perfect.
Hemant, I just had a point. I think the first query that he asked, that was not fine-tuned for income tax per se, right?
Yeah, so we work broadly across litigation, and we don't yet have a particular tax database, so things that are a bit more procedural tend to slip by, but we're always adding new data sets.
No, but I think that if the query had the income tax, it probably would have been easier to hone in on it, in a sense, instead of giving all the sales tax act, etc.
Right.
Query prompt engineering.
So we only said assessment.
Exactly.
Yeah.
So prompt engineering would have
it
helped.
found every piece of tax law that it could. Yeah.
Exactly. And if I may ask one more question, Hemant. If I may just have one more question, can you give your insights onto how you deal with hallucinations?
Yeah.
With respect to, like, for example, how do you make sure it doesn't come up with citations which aren't there, right?
Great.
Things like that.
So we have a 15 million database of legal documents ourselves, which includes every High Court judgment, Supreme Court judgment, daily orders, intermediate orders, and so on. We have every BAR Act, every piece of regulation, rules, schedules, notifications, anything that's been issued with relation to an act, and then a set of highly handpicked by librarians, law librarians, a set of textbooks that are authorities on the law on different issues. Along with it, it can use the web as a fallback if it's not able to find something in its own database. So along with all this careful work on data, what we do is we use a different sequence of models than GPT. And the way it works is rather than just predicting the next token, it has to use these classes of models called extractive summarizers. So extractive summarizers are models which, given a query, find the sentences in a document that are the most important to answering it. So everything it's producing is actually lifted from different parts of, say, a judgment or a piece of statute. And then it's compressing that and rewriting that in natural language using a model that is similar to GPT. So what we end up doing is building these tool experts, which are these white boxes that are appearing intermittently, which use an entirely different stack of models. Models that, as Hrishikesh was pointing out, for example, can pick things like entities. So who's the counsel on a case, who's the judge on a case, which court did it occur in. Models that can find the courts and can summarize cases thematically and so on. So as a result of using these sequences, they produce very raw sounding information, which is not very well written. And that's the first pass that we have. But each of that is directly attributable to a source in that we know this is the line that's being put together. And then once it's stitched together, all we do with generative AI is to just rewrite it such that it's skimmable, neatly formatted, much more well written and so on. So here it's listing out some of the cases. And again, each of those buttons that's coming up with the numbers, you can click on them and it will take you to the judgment itself. I'll give it a second to reload. Was there a second query? Yeah. we're doing the CBDT query now, and you can tell that it's a real demo because now my hands are off the keyboard, so I can no longer do my magic touch that makes it say the right answer. But yeah, I mean, as Mr. Vikram was pointing out, I mean, prompt engineering is this thing we call where you try to phrase prompts to an AI such that it's able to produce the best answers, right? And the AI is learned from humans, so prompt engineering can work in some funny ways. Because it's read a lot of customer support exchanges, if you make a fake promise to the AI that you'll give it a tip, you say, I'll give you 1,000 rupees if you give me a useful answer, it produces higher quality answers. Similarly, on Friday evenings, the AI realized that if it's asked for something that's a really long task, it should reply saying that I'll get back to you on Monday morning. And that's because in the little preamble it gets, we tell it what date and what time it is. And it's read email exchanges so many times that it's realized if someone asks you something long on Friday, you tell them, no, I'll give it to you on Monday. And so we have to do this little bit of, sort of summoning the devil, exorcism kind of thing, where we say the right magic words and then say the right spells, and then it responds better to when folks like me use it as a result, because we're very familiar with how it reads and writes and things. Yeah,
Hi.
so the question was whether if AI is going to be like another junior to me, and if I give it a assessment order and ask it to prepare the grounds, would it be able to do so? And these are very much the sort of emergent abilities that are getting better and better, and what we're working on as well, right? So here already it's produced a research memo for you in a full memo format. Anya's telling me that my dad's on the answer, but yeah. Yeah, just scroll a little up, let it keep going. So here what it's done, for example, is, So here, for example, it's put together the Madras High Court judgment, scroll down. And it's, okay, reload, it's okay, sorry. For technologists, we constantly run into tech support issues. Projectors are my worst nightmare these days. But yeah, here's a set of judgments it's put together. It's pulled out the analysis and the implications automatically. And it said the Madras High Court judgment struck down clause 5.2 of the CBDT circular as alleged made arbitrary and that which ultra-vires the Constitution of India. And then it has some other discussion on section 80G. And then each of those is a citation. And then in the bottom, it's put together. Yeah, so just go down, sorry, all the way to the bottom. Yeah. It's put together a final answer where it's given you, some background on the CBDT circular, what date was it, what was it for, what's the analysis of the judgment, what are the implications, what are the conclusions. So, yeah, that's okay. Yeah, should we wrap or? Okay, there's one more thing I'll show you, but it takes a couple minutes to run, so maybe if you want to join us at the booth. But the other thing we're working on is with automatic risk evaluation.
Hi, can I have one more question, please?
Yes, please.
Yeah, thank you. So, apart from what Vikram mentioned on the prompt engineering, the other one important factor, as far as all these AI databases is concerned, is the source from where it picks up information, right? So I just wanted to understand, especially in our litigation framework, wherein, jurisprudences are coming every minute as we speak. So how do we track that, and what is the source that goes behind this? Is it just open-ended and that's why the hallucination, or are there specific sources that go into the database?
So as Hemant was mentioning, we have a repository of over 15 million cases and proprietary legal data. I'm a lawyer, and so we've curated a list of all specific textbooks depending on the specific area of the law to kind of curate this database, and we're constantly updating our database as well. So we'll take the most important authorities on specific case laws and put it in. So for example, for statutory interpretation, we've put in GP Singh, we've put in MP Singh, we've put in all sorts of proprietary information, based on the leading authorities in that specific area. And that's kind of how we filter our sources. And we have a team of around 12 lawyers working to constantly update this database and make sure we get state-of-the-art information put onto this database.
Specifically about judgments, we maintain a system of machines on the internet that are constantly, it works exactly like how Google's index works. In that anytime new information arises on the web, it picks it up and indexes it. So the same way, anytime, as soon as the court copy of a judgment is ready and posted online, it will appear on Jana. And you'll have actually faster turnaround time on judgments being updated here than you have with your other typical providers, because those are done by hand, by typesetters sitting in a godown, sort of, getting the court copy from a court reporter and then typing it again. For us, everything is machine run. Cleaning is machine run, analysis is machine run, as well as actually picking up the judgment, the row of data around it, downloading it, and so on. So, basically the guarantee I can give is same day as judgments arise, it should be reflected on Jana.
Thank you.
We also have interim orders and data points that aren't normally existing in other sources, so that's a huge advantage I find when I use Jana for my work.
Hi, I am an academician. I teach at Chettinad School of Law. So this is mostly from an academician's point of view. So our Indian legal system already has a lot of systemic biases in place, and there is one line of thought that AI would in fact not just reiterate systemic biases, but it would also strengthen it further. So how are you planning to work with that, or is there any efforts made towards that? That's one question. And second question is also that with the recent rules in the Bar Council, we are required to teach students subjects like artificial intelligence and law, as well as blockchain and law. But I'm finding it very difficult as an academician as to how to, teach young law students with respect to these new emerging areas. Would you have some suggestions for that?
Yeah, absolutely. Those are both great questions. Remind me of the first one. First question was biases. Yeah. No, so we take bias very seriously. So a little bit about our organization as well is that we're a mixed sort of for-profit, non-profit venture. And we do a lot of very transparent reporting. So even on this website, you can go to a service status page and it will tell you all the AI failures that occurred. If there was any critical failure, we maintain a transparent list of it that any user can check in on a weekly rolling average of at any time. Besides that, the main thing that the lawyers on our team do is we build internal benchmarks. So benchmarks are when an expert curates a question and says these are the things that should be in a good answer for this. And these benchmarks include measures of bias, measures of success, correctness, relevance, and so on. So any model we deploy is tested on our internal benchmarks as well as extensively hand tested by our team of lawyers. So we're very careful about it. We take reporting bias openly, very seriously, and we think it's very important as a industry standard that we should. No, I don't think anyone can claim that we have models that don't hallucinate or don't have bias. The best we can do is be transparent about what rates our tests suggest, and constantly work on improving it as an important goal besides our fiduciary obligations. So that's why we have, even as an entity, we are of this mixed structure where we have the simultaneous dance between for-profit and non-profit interests. About teaching AI, I think even as an AI practitioner, I spend most of my days building talking computers, and I'm still constantly out of touch with what has happened because so much happens and so fast. So I sympathize with that a lot. I think the one good thing is I think the students are already using AI probably, and they will have the exposure and sort of familiarity with it that maybe my generation had with laptops and the generation after me had with smartphones growing up. And we see, for example, ChatGPT has 230 million users. as a AI provider called Characters AI, where you talk to, a star or a cartoon character whose persona has been made into an AI, and that gets more hits per day than Google does today. And that's mostly teenagers and young people, right? Talking to a character from a movie or a set of novels that they like. So I think that familiarity will pre-exist, and really all we have to think about is questions like the ones you're asking, which is how are these systems aligned to human values? How are they biased? How do we de-bias them? And just being transparent about the fact that the AI you're seeing today is the worst AI you'll ever see, and it will make mistakes, but it will also keep getting better faster and faster. Yeah. That's a lot of time for me, so apologies and thanks.
Yeah, I had a question to Rishikesh, possible. Yeah, hi. So I just wanted to know, are you seeing AI in the contract space? Because a lot of this is now the reviewing of contracts and the clauses, etc. There are a bunch of AI startups in that. Have you been able to incorporate it, and are you seeing that in the Indian context at all?
Absolutely. So I think, like you said, smart contracting was one of the first areas where before even AI came in, it was more machine learning and blockchain that really came into smart contracting. So this is maybe 2-3 years ago, which in this era is a lifetime. So yes, we do. Very few contracts today are actually drafted from scratch by hand. And not just by us, I think by any lawyer today, very few contracts are drafted by hand. Most of it is smart contracted to a different extent because we're sort of in a hybrid between a technology company and a law company. We do a little more of using of smart contracts, but I think that's become the norm. I don't think anyone in this room is not using some degree of smart contracting.
Thank you, sir. Thank you. We will now move on to the closing remarks by the chairperson of this session, Mr. Kalpathy S. Suresh.
I think this was a very, very interesting lecture, both of them. In one of our businesses, one of the things that we actually teach is AI as to what are the top 10 essential tools that a lawyer can use in AI. And this is one of the programs that we actually teach. We do that to many of the leading law firms because, like one of the persons in the audience mentioned, that it's moving so fast that people are not able to adapt at the speed at which it is changing. Two great lectures. What I wanted to add in closing remarks, and you would have seen at the speed at which things have moved, how it's able to look at repository, pull out data, present. Again, couple of very fundamental thoughts is before, when people looked at plagiarism, and I think even today, in many of the content that we ourselves publish, we look for continuous words being repeated or paragraphs being repeated. We don't look at plagiarisms as the essence and the thought being replicated. I think the AI coming, it's already come into many cases. Today, royalty is being charged based on the data that it is based on. And the source of data, source of books, source of knowledge is being paid royalty. This has already come in some of the creative arts fields, and leading judgments have already passed a few months ago. The second one is, as we see all of this progress that is coming, and the key question that always plays in my mind, and I'm sure for people who have and might not have articulated, is what is the end game with the pace at which it is going? I think fundamentally we need to ask ourselves as to what humans do. Right? We are really made up of two parts. One is the thinking part, one is the doing part. And artificial general intelligence, when it comes, will replace the thinking part in full. And today there are some countries in Lapland which are experimenting as to, so what does the human thinking person do when he is completely replaced or completely left behind by an artificial super intelligence, which moves at 10,000 times faster. And humans have no place to play. And as far as the thinking part is concerned, it's not just the legal profession, but it's in all professions. People who teach, we had seen it with ChatGPT 4.0, which was eye-opening when Khan Academy founder took a lesson with his son. Right? It is moving at that speed. And so they are experimenting by crediting 5,000, 4,000 euros as free money by the country to people, and humans are being asked to participate in the economy by just spending the money. And that's all is expected from humans, to be able to spend the money, engage in activities that give them the pleasure and whatever pursuit that they might want, and that's all the expectation from the human. And this is already being experimented for the last 1 year in one of the Lapland countries. So an artificial super intelligence will replace the thinking part of people completely. All the biases, all the hallucinations will go away. And today hallucinations are being detected by AI themselves. Another AI actually works to detect the bias and the hallucination that is happening and alert before it goes out. The second part is the doing part of it, and that's about the humanoids and the robots that are already in play. And when that gets replaced, then we might probably be sitting here deliberating the same way that the apes must have done before they were taken over by the humans. And those days are not too far away. And with that, I'll close this. Thank you very much for the opportunity. Thanks for both of them on the podium to a great lecture. Thank you.
Thank you, sir. I now request Mr. Marudu Pandian, Commissioner of Income Tax Exemptions, Chennai, to present a memento to the chairperson of this session. I now request Mr. Marudu Pandian to hand over a memento to the first speaker, Mr. Rishikesh Dattar. I now request Mr. Marudu Pandian to hand over a memento to the second speaker, Mr. Hemant Bharta Chakravarti. Thank you. Thank you. We will now break for a lunch break for about an hour. We have curated special no onion, no garlic menu for you all. Please join us for the next session, which will begin at 1:30 p.m. Thank you.
Journal, both as an editor and joint editor from 2005 to 10. He remains an active member of its editorial board. Additionally, Mr. Nayak has been involved in the IMC Chamber of Commerce and Industry and chairs its non-profit organization committee since August 2023. His previous roles include co-chairman of the Direct Taxation Committee and chairman of the Taxation Committee at the BCAS. Mr. Nayak has made substantial contributions in the field of taxation through his publications and articles. He co-authored 4 editions of Transactions in Shares and Securities, Taxation Accounting, and the Taxation of Charitable Trusts. For nearly 3 decades, he has spent a monthly column on controversy for the BCA Journal and fortnightly column on personal taxation for financial newspaper Mint. His writing extends to other notable publications like Economic Times, Outlook, Money, and other magazines. He's a sought-after speaker, presenting talks and papers at numerous seminars, conferences, and corporate training programs organized by prestigious institutions. He frequently appears on CNBC, CNN, and Bloomberg, where he's a panelist on taxation and audit issues. Sir, thank you for coming all the way from Bombay to address us. With this, I'd like to start the session, and I'd like to ask the chairman to give the opening remarks. Thank you.
President of the Revenue Bar Association, Chairman of the Conference Committee, Office Bearers of the Revenue Bar Association, advocates, auditors, cost accountants, and friends. It's a privilege for me to be here in the august and erudite gathering. At the outset, I must make a confession. When the President of the Revenue Bar Association called me, or rather invited me to preside over this particular session, I asked him, why me? I am one of the very many students who gave a slip to income tax and anything concerned with taxation in law college and even in the beginning stages of our profession. Of course, as a senior counsel, you definitely argue cases. When it ultimately boils down to a question of law or interpretation of a particular provision, it is much easier. But to deliver a lecture on taxation, on the legal aspects, the amendments, etc., you really need to go into it in great depth. So his retort was, no, it's just not taxation, it's the impact of taxation on real estate transaction. You are really an expert in the area of real estate. You have been dealing with land disputes, etc. Anyway, I decided to accept the invitation as it was an opportunity for me to listen to the experts like our friend here in the field of taxation, which is such a competitive and complex subject today. Let me now just go back into history. In the earlier days, in the late 70s, land transactions were very simple. It was either a sale of land or a sale of land and building. No doubt the capital gains tax was introduced even in the year 1947. So it was just a very simple issue. You had only thing that you needed to verify was whether there was any revenue attachment over a property, and that was one part of the due diligence, which was quite easy. In the 70s, the concept of residential apartments and a little later the concept of commercial spaces being built in a piece of land where there are going to be several owners evolved. And that made a difference. And then the question of what should be the undivided share for the purchasers. And in fact, I have seen in the 80s, the proportion of undivided share was not in proportion to the area of superstructure that the person was buying. It was also unorganized and unprofessional. And the builders used to retain 20% or 30% of the undivided share for them to ultimately put up a construction over and beyond the sanctioned limit, and they will try to pocket the. Then it evolved, and scientific methods of working out the undivided share, looking into the approval given by the CMDA, which was CMDA, and then things settled down. This is how, and practically it was not a very difficult situation. Even once question of capital gains, the formula again was very, very simple, and even a non-tax lawyer could ultimately say that this would be the capital gains tax that one has to pay. Now, today things are very complex. The concepts have changed. Joint development agreements in the scale of 1,000 apartments or 1,000 commercial spaces with common areas for facilities for. It's really very, very complex. Even drafting out a joint development agreement is a very tough assignment. But ultimately, many of us, or rather not me, because I am out of regular practice from 2008 as a senior advocate, it becomes just copying one template without applying one's mind. And this is the reason why you find that there is a lot of litigation based on joint development agreements. They don't apply their mind to the facts of that particular development, what is the background. It's just cut and copy, paste, and then give a draft to the developer, which is ultimately thrust upon the house owners and commercial space owners. Now, once this is done, now let me come to the tax angle. Now, there are two areas when the tax liability of the developer is one aspect, and what could be the tax liability or impact on the consumer or the house owner is another thing. Both these things have to be taken into consideration while tax planning is done. And basically, the huge tax, GST has also now come in. GST is yet another new concept which is still developing. And therefore, at the start of a real estate project, the developer must work out what would be the impact of taxation on him as well as on the purchasers. And this is very, very important so that one would understand, and the purchaser also should be consulting an auditor or a tax lawyer as to what would be his liability with respect to taxation angle. And that is where I think my friend the expert speaker is going to give you an elaborate lecture on the aspects of tax planning. And all of you know, between tax planning is perfectly legal. It is something that you do beforehand. You look at the provisions which prevails on a particular date, and then plan out your tax liability. Then tax avoidance, and there is always a difference of opinion in this, whether a tax avoidance is legal or it is illegal. According to me, tax avoidance could be legal also if you are making use of certain provisions of the tax, whether it is income tax or GST, you make use of that provision, find a loophole, and then advise the client, well, it is not illegal. But tax evasion, all of you know, is illegal, and fortunately or unfortunately, that seems to be the thing that is happening in today's society. It is neither tax plan, yes, tax planning is there, tax avoidance is also there, but tax evasion is more rampant. With this, I would invite my friend to enlighten us with all the knowledge that he has acquired. Thank you.
Chairman of the session, Mr. Krishnan, President and office bearers of the association, and my dear friends. It's a pleasure to be here with you today to discuss the subject of tax implication in the real estate sector. One of the things which, of course, which Mr. Krishnan also mentioned was that the law was simple in the older days, and today I think it's much more complex. It has reached such a stage where one is really, trying to leave alone planning. I think one is trying to first figure out what is the law, because you have a variety of decisions giving you different aspects from a different perspectives. And, say for instance, when you come to this date of transfer, you'll see that in the context 247, there's one view. In the context of exemption under 54, there's a different view, etc. How does one reconcile those decisions, etc. And what is the view which one has to take, how one has to understand those decisions. And that's where I think we need perhaps the advice of senior lawyers like Mr. Krishnan. I think because very often, we see the Supreme Court taking one view, another bench of the Supreme Court taking a different view, and which we'll come across during the. So what I will try to do is, list out some of the most controversial issues. There have been other issues, like for instance, taxation of real estate developers, whether completed contract or percentage of completion method. Now it's driven more by if your Ind AS 115 applies, therefore you can follow complete contract. Supreme Court also was there, of course, saying that complete contract was permissible, but others have to, whether we're following the institute guidance note, etc., where the percentage of completion method has to be followed. So that's more or less, I think, now settling down in a sense. Similarly, there have been various issues on exemption in 54 and 54F. I've tried to take one or two of those controversies, not everything on that, because there are too many controversies on that. But what I've tried to do is, over the next little over an hour, I'll try and deal with the various issues. Yeah, this presentation. So these are the issues which I'll be dealing with, and let's go to the first issue, and that is relating to the date of acquisition for computation of holding period for capital gains in case of an under construction property. Now what happens is that when you book an under construction property, there is typically, you would pay some token amount, a letter of allotment would be issued to you, and thereafter you would make payment in installments, because as per RERA, you've got to make payment as per the stage of construction, and ultimately you get possession of the property. In between, the registration of the agreement may take place in between. That's the way it typically happens. Now, the question is, what is the date of acquisition? So, in the context of selling of an under construction property, say suppose you booked a property and you sell it, within a year or so, before the construction is complete, there have been decisions saying that the right to acquire a property is also a capital asset. Bombay High Court in Tata Services, for instance, said that. The question is, does that change? So, when you take possession? Okay. Sure. Yeah. Okay. So, the question is, what is it that you look at in this situation? Do you see the date of allotment, or does it change on possession, or does it change because of the registered agreement? The tax authorities have been trying to say that, no, it's your date of your registered agreement which matters, or the date of possession which matters. Can one say that that right to acquire a capital asset, right to acquire a property, has got converted into an immobile property only when you got possession? So those have been the issues which have been there. And there we had, fortunately, I think, Bombay High Court decision in the case of Vembu Vaidyanathan, where the Bombay High Court took a view that it's the date of allotment which would be the relevant date for that purpose. And that's the date on which the purchaser can be said to have acquired the property. And the SLP against this has been dismissed by the Supreme Court. So the facts, what you have to remember there is that the facts were that the property was identified, the area was identified, the consideration was identified with the letter of allotment. So not just a letter of allotment per se, but a letter of allotment which spells out all the terms of the contract. And therefore it was in that facts that the Bombay High Court has taken a view that yes, that was the date of acquisition, because that was the date on which really you acquired that right in the property. That was, and various other high courts had also taken similar views. There was a controversy on this because the department had, there was one Delhi High Court decision which was against. That was the view. But I think to a great extent now, this controversy has got settled by the decision of Vembu Vaidyanathan, where now, interestingly, what would happen, you understand from this perspective, when do you get indexation of cost? The indexation of cost, and which we'll see in a later this thing, is that the next slide. Yeah. So, sorry, 1 second. Yeah. So then, what would be an indexation of cost? Because if you see the concept of index cost, it says that amount which bears to the cost inflation index in the year of acquisition, in the year in which the property was first held. So if you say that the date of acquisition, because of Vembu Vaidyanathan, you say that the date of acquisition was the date of the allotment letter, then your indexation would be available right from that date for the entire cost, because there is no concept where if you pay cost in stages, it does not mean that you are entitled to, that's one view which is, so, but unfortunately, there have been, of course, tribunal decisions which have taken the view that yes, it will be, the entire cost will be indexed from that date of acquisition. But there have been one Allahabad High Court decision which I would like to just draw your attention to, and which Of course, that decision, unfortunately, the tribunal decision is not there and is not readily available, because this was at a point of time when all those decisions were not online, and where the Allahabad High Court has just made observations, and they have followed a particular CBDT circular. The CBDT circular was in the context of booking of premises under construction with the Delhi Development Authority. That was Circular 471, where the view which had been taken was that it is the date of allotment which matters over there, because based on the scheme which the DDA has, that you are really become the owner when the plot is allotted to you. The construction happens over a period of time, but the date of acquisition is the date of allotment. That was the view which was taken by the CBDT at that. So relying on that, but they have arrived at a contrary view, saying that you will get indexation for whenever you pay the installments. Now this, frankly speaking, I think is not supported by the language of the section. And if you look at the various tribunals, I think which have taken a contrary view, in fact, there have been almost, so many tribunal decisions, the Mumbai Tribunal as well as it's been primarily, of course, the Mumbai Tribunal, but there have been other decisions also where all of the tribunals have taken a view that your date of acquisition is one, and that is the date from which the asset is first held. So your indexation of cost should be available to you from that date and not from time to time when you pay the cost installments. And this would apply in various other situations also. Look at a state where you acquire a share. The share is allotted to you, but suppose the money is taken by the company in calls. Say for instance, Bharti Airtel, they issued these, you had to pay the money in calls. So what is the date? Now even if you pay the call at a later point of time, the date relates back to the original date of acquisition. And that's the view, I think, which one will have to take. So all these tribunals have taken this view, but I think this is one thing which you need to keep in mind, that this Allahabad High Court decision. But as I said, the Allahabad High Court decision, the logic which is given does not seem to appeal, because they have based it on that DDA circular, and that DDA circular in fact does not say that you will get indexation from this. So that is one of the aspects which one has to keep in mind. Now the biggest controversy which has been there now for the last I would say almost 30 years, one is looking at this. You had this provision which came in the 1980s, that clause 5 and clause 6 were added to the definition of transfer under section 247. And what is this clause 5? It says, a transaction allowing the possession of any immovable property to be taken or retained in part performance of a contract of the nature referred to in section 53A of the Transfer of Property Act. Now, so therefore, what is this part performance of a contract under 53A of the Transfer Property Act, and when does 53A of the Transfer Property Act apply? So let's look at that. 53 of the Transfer Property Act says, where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf, from which terms necessary to constitute transfer can be ascertained with reasonable certainty, and transferee has, in part performance of the contract, taken possession of the property or any part thereof, or the transferee being already in possession continues in possession or in part performance of the contract and has done some act in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract, then the transferor or any person claiming under him shall be debarred from enforcing against the transferee and persons claiming under him any right in respect of the property, other than a right expressly provided by the terms of the contract. So what does it mean in short? It means that where you have an agreement in writing by the owner of the property, agreeing to sell the property for consideration, and the terms of that contract have been spelled out in that agreement, possession is given in part performance of the contract, and the transferee is willing to perform the requirements of the contract, then in that situation, once the transferee has been put in possession, he can claim a right against the transferor, saying that no, effectively he has created a right in his favor. That is the view. Now, the Income Tax Department, what was happening is that properties were being transferred under an agreement for sale, and a conveyance deed was not being executed. A conveyance or a sale deed was not being executed finally, and therefore the title was not being transferred, but people used to just carry on and not pay capital gains tax for years together. That was the problem which was sought to be plugged by this amendment. Now the question here is that how does this apply vis-a-vis development agreements? Development agreements is one way of development of the property. So what exactly is a development agreement? Let's try and understand. And there we have the Supreme Court decision in the case of Sushil Kumar Agarwal versus Meenakshi Sadhu, where Justice Dhananjay Chandrachud incidentally is the author of this judgment, where he said that this has not been defined statutorily. A development agreement has not been defined statutorily. It's a catch-all nomenclature used to describe a wide range of agreements which an owner of a property may enter into for development of immovable property. It includes pure construction agreements, grant of rights to a developer to carry on development for monetary consideration payable by the developer. So I entered into agreement with the developer saying that, okay, you construct and you give me money for the construction, for giving you the right to construct. Second, the next is grant of rights to a developer to carry on development in exchange for part of constructed area. So where the owner enters into agreement with the developer saying that, okay, you construct on that and 45% of the constructed area you give me, 55% you're free to sell. So that's the other category. And development of immovable property occupied by tenants or other right holders where the developer takes on the responsibility to settle with tenants and carry out construction. So I may have a property which is occupied by tenants or by slum dwellers, and I may say that, okay, you know, you develop the property, you take over this, and give me X amount. That's the other. And the last category which the Supreme Court discussed was the development of land occupied by slums, where the developer rehabilitates occupants and shares the saleable reconstructed area with the owner. Now this is, I think, something which we're seeing happening because in Bombay, for instance, we see that on slum redevelopment, there's a FSI allowed of 4 times the area of the plot, and therefore this has become an extremely lucrative thing for builders. So they do enter into such agreements for slum rehabilitation, slum redevelopment agreements. That's very category. And there the Supreme Court then went on to say that in category of development agreements, other than pure construction contracts, the developer may have acquired a valuable right either in the property or constructed area. Then the Supreme Court goes on to say, ownership consists of a complex of rights, which are rights in rem. That is, these are rights against the whole world. So this concept of bundle of rights theory, Supreme Court also in A.R. Krishnamurthy's case, in 176 ITR said that land is a bundle of rights. So similarly, your ownership, Supreme Court has said, is a complex of rights. And essential element of ownership of land is the right to exploit the development potential, to construct and deal with the developed area. And in some situations, under a development agreement, an owner may part with such rights to a developer. So what they're saying is that these development rights is one of those bundle of rights in the land which you're parting with. And that the Supreme Court has said, this in essence is a parting of some of the incidents of ownership of the immovable property. So effectively, you're parting with immovable property by granting these development rights. That's this. Now, looking at it from this context, now let's go on to, from the income tax perspective, what have been the decisions. And the first decision, now the question is, typically in a development agreement, you have a situation where the owner will grant a license to develop the land to the developer. And he will granted a license for the purpose of development to enter upon the land, etc., and carry out the development. Now, whether such a grant of license to enter upon the property for purpose of development amounts to a transfer. That's the question which arises. And there we had for many years this decision of the Bombay High Court which held the fort in Chaturbhuj Dwarkadas Kapade's case. This was the decision in 2003, so which was for almost 20 years, and it's been, and there this Bombay High Court, if you looked at the observations, some of the observations which the Bombay High Court made, they said in such cases of development agreements, one could not go by substantial performance of a contract. In such cases, the year of chargeability is the year in which the contract is executed. This is in view of section 247(5). The agreement was a development agreement, and the test to be applied to decide the year of chargeability was the year in which the transaction had been entered into. That view was taken for the reason that the development agreement does not transfer interest in the property to the developer in general law, and therefore section 247(5) had been enacted. And in such cases, even entering into such a contract could amount to transfer from the date of agreement. And so what the Bombay High Court has elaborated there is that the agreement in question is a development agreement. Such development agreements do not constitute to transfer in general law. They've said that. But they are spread over a period of time, they contemplate various stages. The Bombay High Court in various judgments has taken the view in several matters that the object of entering into development agreement is to enable a professional builder or a contractor to make profits by completing the building and selling the profits at a profit. That the aim of these professional contractors was only to make profit by completing the building, and therefore no interest in the said lands can be created in their favor under such agreements. That such agreements are only a mode of remunerating builder for service of constructing the building. It is precisely for this reason that 247.5 was there. And then they said that in this case, the department has not applied this test of 247.5, why the 247.5 was there. And there they say that one cannot go by substantial performance. See, what was the view earlier which people were taking is that in substance, has substantial performance of the contract been taken place? And if so, then only one would say that there is a transfer. The mere fact that I have given a license, that license would not amount to a transfer. That was the view before Chaturbhuj Dwarkadas Kapadia. Now, in Chaturbhuj Dwarkadas Kapadia, I think the Bombay High Court has, of course, the facts of the case were such that the case was decided in favor of the SSE in this case because of the fact that the possession was given in a particular different year, and that's where the Bombay High Court in this, or the facts of that case, took a view that no, it would not be taxable in the particular year which was at issue before them. But the problem here really is this, that suppose you enter into a development agreement today, and every development agreement will have a situation where you have to give a license to the developer to enter upon the property for the purpose of development. Without that, how is it possible to carry out the development? It's not possible. And typically also in some cases you give a power of attorney to interact with the municipal authority to get the plans approved, etc. So that's also something which is there. The question really is that if one applies the ratio of the Bombay High Court decision, though I might be getting the consideration much in the future, though the construction may not have started, though the approvals may not have come, municipal approvals may not have come, even in such a case, one was having to pay the tax in this. That was the view which the department was taking following Chaturbhuj Dwarkadas Kapadia. And that was unfortunately the view which I think in many cases that was the view which was being taken. So for a long time we had Chaturbhuj Dwarkadas Kapadia right from 2003 till 2017. In 2017 we had a Supreme Court decision which diluted Chaturbhuj Dwarkadas Kapadia to some extent. And interestingly, this was a case where there was an agreement to transfer land, and this was an agreement which said that it should be done in stages. The development would be done in stages. Approval would come in stages. At each stage when the approval came, then the money would be paid, etc. That was but that agreement was not registered. As and when the approvals were coming, then certain part of the land was being transferred. And there the department said, see, Chaturbhuj Dwarkadas Kapadia says, when you enter into a development agreement, you are liable to pay tax. So therefore they sought to pay tax the SSE in that case. But in that case, the agreement was not registered. The development agreement was not registered. And there the Supreme Court looked at the provisions of the Registration Act in that this thing. In that case, the Registration Act was amended in 2001, where such transactions related to immovable affect no document shall affect any immovable property also. So 17(1)(a) says that documents containing contracts to transfer for consideration any immovable property for the purpose of 53 of the Transfer of Property Act shall be registered if they have been executed on or date after the commencement of this Amendment Act of 2001. So that was what the Supreme Court looked at, and they said that they looked at the provisions of Section 53A, and they said that you look at what is 53A, what are the essential elements as have been held by the Supreme Court in another decision in Srivansh Shamrao Suryavansh. What is the view? There must be a contract for consideration of immovable property. The contract must be in writing, signed by the transferor or by someone on his behalf. The writing must be in such words from which the terms necessary to constitute the transfer can be ascertained. The transferee must, in part performance, take possession of the property or any part thereof. The transferee must have done some act in furtherance of the contract, and the transferee must have performed or be willing to perform his part of the contract. So the fact they said that after the Amendment Act of 2001, the contract, the written contract should have been registered. Since it was not registered, it ceases to have effect. And therefore 53 of the Transfer of Property Act will not apply in this situation. And therefore, they have said that in order to qualify the transfer, there must be a contract which can be enforced in law under 53 of the Transfer of Property Act. And a reading of section 17(1)(a) of the and 49 of the Registration Act shows that in eyes of law, there is no contract which will be taken cognizance of for the purpose of specified in 53A. So therefore, unregistered development agreements therefore went out of the picture, and therefore they said that, okay, unregistered development agreements will not constitute a transfer in such cases. Then we have, and they said the object of 247, the question is, department said, what about clause 6? That any transaction which has the, this of enabling enjoyment of a property. And they said that what is sought to be covered by clause 6 is that not a de facto transfer of immovable property. Enabling the enjoyment of takes color from the expression transferring, so that any transaction which enables the enjoyment of immovable property must be enjoyment as an owner thereof. So it should be enjoyment as an owner and not just enjoyment of the property per se. That's the view. And the idea is that transactions which, though not transferring the title, in substance it amounts to a transfer of title, is the view that the Supreme Court has taken in Balbir Singh Maini's case. Then we fortunately, I think, had the Supreme Court decision in Seshasai Steels Limited. Now, Seshasai Steels Limited was a case where there was a development agreement entered into, there was some disputes and nothing was happening. After 10 or 15 years, finally the transaction went through, and then they paid tax in that year, saying that the development has happened now, and we've executed the documents, etc. And there the Supreme Court examined this fact about giving of a license. And they said that a license was given in Seshasai Steels. They said a license was given for the purpose of developing the land into flats and selling the same. Such license cannot be said to be possession within the meaning of 53A, which denotes control over the land and not actual physical occupation. This being a case, 53A will not be attracted in this case. Enabling the enjoyment of, again, they said, must take color from the transferring, and therefore there was no transfer of the immovable property. So this was what Seshasai Steels therefore has diluted Chaturbhuj Dwarkadas Kapadia's case. It has been diluted substantially to say that just mere giving of a license is not transferring of possession. You have to look at, is really possession which enables him to enjoy it as an owner, has that been effectively transferred? It's only then. And then now the various high courts have come into the picture, and we have the Bombay High Court in Bharat Jayantilal Patel, where they said that 53A of the Transfer Property Act is not attracted where license is given for purpose of development and selling the same. Granting such a license could not be said to be granting possession and for the purpose of 53A. Development agreement permitted construction only as a licensee, which did not have the effect of transmitting possession. And again followed by Bombay High Court and Darshana Anand Damle. We have Calcutta High Court also in the case of Emporus Properties in 458 ITR 68, where the Calcutta High Court has said, they looked at the agreement again, they diluted it further. They said that, look at this, there is a termination clause. That termination clause says that an owner can terminate and pay the developer whatever he has spent on it, he can terminate the agreement. So that indicates that the ownership has not passed. So therefore they said, look at the substance of it. In substance, has ownership passed, and at what point of time has the ownership passed? That was the way that they looked at it. And we also have another similar decision of the Karnataka High Court in Sri Sai Lakshmi in 458 ITR, where the similar view has been taken. I would just like to draw your attention to the Madras High Court decision in P. Madhusudan, which was, of course, before Seshasai Steel and in 419 ITR, where the admitted facts of that case were that their possession had been granted, was the thing, and therefore on those facts, this Madras High Court had held, because there the parties filed an affidavit saying that we have given possession to the developer. Now that was the facts of that case, and therefore on that facts it was held that yes, this was an agreement to transfer and which they have given the possession, and therefore on that. So there is also a Calcutta High Court decision again in context in Infinity Infotech Parks, a recent decision again. Not a very recent, but sorry, in 2018, where they said that the type of possession is, what is anticipated under the Section 53 of the Transfer of Property, what is covered by Section 53 of the Transfer of Property Act. It's not every handing over of possession which is to be covered. And they said that when the owner of a land enters into an agreement for the purpose of developing, terms of the contract would indicate when the transfer would take place. There could be rare situation where transfer may be simultaneous with the execution of the agreement, where the owner retains any right in the construction area in the future. It would scarcely be a case of transfer taking place. So when you're getting a percentage of the constructed area, they're saying that no, that will be only at the point of time when it is determined the share, what is the builder's developer share, which is the property which comes to the share of the developer, which is the property which comes to the share of the owner. It's only at that stage that the transfer could be said to have taken place, and 53 of the transfer have property. What they said there is that when you give a license, that license is only to construct. When there's a bifurcation of the areas, then the developer can claim that provision 53 of the Transfer Property Act, because it's only that area which is supposed to come to the developer, where if he has, where he can claim 53A of the Transfer Property Act, because that is the only area which is to be transferred to the developer in that situation. So, the other, this is that now also for individuals and HUFs, fortunately, this concept of development has got diluted to a great extent. You have a section 45(4), which has been inserted, which is applicable from assessment year 2018-19. And there this question had come up whether it is retrospective in operation or prospective. And most of the tribunals have taken the view that it is prospective in operation and would not apply to past transaction. Now, what does 45(4) say, 45(5)(a) say? It says that when you have a person, when you enter into a specified contract, when there is a specified contract, in that situation, when an individual HUF enters into a specified contract, in that situation, the capital gains will be chargeable to tax in the year in which the completion certificate is received. And what is this specified contract? They said a specified contract is a contract in which the owner of the land enters into for development of that, or for removed property enters into agreement for development, and in exchange he will get a portion of the constructed area, and he may get also money in also along with that. So therefore, what they have covered is a development agreement which is not purely for money, but a development agreement where the owner will get some area also in exchange. So he may get money also, but he will definitely be getting some area. So where, for instance, today you have a development agreement where 100 flats are sought to be constructed, and the owner is going to get 1 flat, it would apply. Where the owner is going to get 50 flats also, it would apply. So it would apply in both situations. So, but he should be getting some area in that. And what further it goes on to say that if there is a transfer of that area which is coming to the owner before the completion certificate is received, then the capital gains will be chargeable to tax in the year of such transfer. Now, what is the meaning of such transfer? Which would mean that the year of the, so when there's a transfer of share, so the question here is now under 45(5)(a). So you have the transfer is postponed to the year in which, rather capital gains liability is postponed to the year in which you get the completion certificate. In cities like Mumbai, where the completion certificate takes decades, but you get the, what they call as the occupancy certificate, it's been interpreted that yes, the occupancy certificate would be the relevant date when it is completed. The property can be said to be completed. It would be either that date in which the capital gains is chargeable to tax, or it would be, if I transfer that area which I'm supposed to get, I transfer it earlier, then it would be that date which would. The question is, what is the date indexation of cost which I will get till which year? I think if you look at it, the language does seem to indicate that you will get indexation of cost right up to the year in which it is chargeable to tax. Unlike section 45(2), where you convert a capital asset into stock in trade, where the capital gains is deemed to accrue in the year of conversion, but taxation is postponed. In this case, in case of 45(5)(a), according to me, it would be tax. You can claim indexation up to the year of the completion certificate. The second is, what is the date of transfer for the purpose of section 54 and 54 EC? Again, here, if logically the capital gains is chargeable to tax in that year, so it should be in that year that, from that year, the 3 years time limit should be counted from that date of completion certificate, that the 3-year time period should be for the claiming the exemption for reinvestment in a residential house or for reinvestment in capital gains bonds. Now, so far as transfer of share in the project is concerned, when I transfer it, is taxable in which year? Does it say, because it says, and the provision of this subsection shall not apply. Does it mean it goes back to the original year in which, say, the development agreement is entered into and in substance the property is transferred? Or would it mean that the year on which I transfer that area which is supposed to come to me? The view is that it would be the area, when I transfer that area which is supposed to come to me, that it is be from that year. And then indexation also, etc. will happen till that year. That's this. And when I say, one of the things in 45(5)(a) says how do you calculate the capital gains? They say that you take the stamp duty valuation, whatever is the valuation as per the stamp duty purposes, on that date of completion certificate, that is to be taken as the value of the property, plus the monetary consideration, that is your total consideration. So in this case, suppose you transfer the property earlier, then whatever is the stamp duty valuation in that year, that will have to be taken as the consideration so far as that is concerned. Now the question is, and if you see the explanatory memorandum, they've clearly brought out this. The question is that when I transfer, suppose a part of the share, suppose I'm entitled to 40 flats in the completed project, and I transfer, say, 2 flats out of that, those 40 flats. What would be taxable? Would the entire capital gains be taxable in that year, or would it be pro rata? That's the question which arises, because the language is not very clear, unfortunately. It just says that the subsection shall not apply. Is it vis-a-vis only that portion? So therefore, 2/40th of that, so 1/20th effectively is what is that the way you look at it? And there, unfortunately, I think if you look at the explanatory memorandum also, it's not very clear. It says the benefit of this proposed regime shall not apply to an assessee who transfers his share in the project to any other person on or before the date of issue of such certificate of completion. It is also provided that in such a situation, the capital gain is determined under general provision of the act shall deemed to be income of the previous year in which such transfer took place, and shall be computed as per provision of the act without taking into account this proposed provision. Now, this seems to indicate that no, you then look at it in general terms, don't go look at this year also, not the year of transfer, but the language of the section says the year of such transfer, and therefore the view is that yes, it will be that such transfer, but this is a problem, and there could be some litigation on this again in the future. Unfortunately, I think the way the laws are drafted, the tax laws, unlike the real estate laws where there is a lot more certainty, the tax laws leave a lot of room for interpretation. The way it's drafted, it says that this section shall not apply, this subsection shall not apply, which seems to indicate that the entire gains will be taxable in that, even if I transfer a part of the share. That's the whole. The other thing which we are seeing of late happening and is redevelopment of commercial properties. And these commercial properties may be depreciable assets, which forms part of a block of assets, or they may be non-depreciable assets. If they are non-depreciable assets, obviously you will get indexation of costs, and there will be no capital gains exemption. You can't claim 54 or 54F in those cases. So that is. But when you have a depreciable asset, it is part of a block of assets. Now, if you receive a new commercial property in the lieu of the existing commercial property, the question is there any exit or entry from the block of assets? Now, if you look at the exit from the block of assets, when do you have an exit from the block of assets? When you receive a consideration, or that block becomes zero because of the consideration which is credited to that block of assets. That is the concept. So the question here is, suppose if that asset is the only asset in that block of assets, then that block of assets ceases to exist also. Say for instance, you have land on which you have a building. Now, what you have done is you entered into a development agreement whereby that building is demolished, it ceases to exist, and after 3 years you will get a new building over there, of which 50% will come to you, and 50% the developer will sell to the outsiders. The question is, what happens to the block of assets? If that asset, this is the only asset in that block of assets, this commercial building is, you have the block of non-residential buildings. So if this is the only asset in that block of assets, these non-residential buildings, then in that situation your block of assets ceases to exist, and therefore you will claim a capital loss in that year. And when you get the commercial assets which are developed, at that point of time, when you start using it for the purpose of a business, it will enter into the block of assets, and thereafter you will be able to claim depreciation on those assets. That is the way that it would work so far if it was the only asset in that block of assets. But if it was not the only asset, say for instance you had 3 commercial buildings out of which only 1 is being redeveloped, so 2 commercial buildings still continue within that block of assets. Now, when those 2 commercial buildings have continued within the block of assets, that block does not, there is no change in that block which is happening. Now, what is happening is the developer is giving you constructed area of X square feet, he's giving you when he's reconstructing. Does that enter into the block of assets? What happens to so far as this is concerned? That is an area which he's constructing and giving you, and therefore, in my view, that when you get the possession at that point of time, that would also enter into the block of asset. The cost of construction of that new building, to that extent of the area that you're getting, would form part of your block of assets, and you would be able to claim depreciation in. Now, the same law, so far as if you're getting a residential property in lieu of a commercial property, again, as you know, 54 does not apply because you're not transferring a residential property. So far as 54F is concerned, you may be able to this. The question is, when it's a depreciable thing, again, when is the exit and when is the entry? Now there will be, entry will be into a different block of assets, what you have to remember. Exit, this block of assets, if you have other commercial buildings, will continue, and you'll continue to claim depreciation. But so far as the new residential building is concerned, residential buildings is a different block from non-residential buildings, and therefore you will have a different block of assets on which, when you get the possession of the residential building. One interesting thing which I wanted to point out is, you have now section 28(6)(a), which has been introduced a few years back, where they said that, you had, of course, 45(2) when you convert investment into stock in trade, or capital asset is converted into stock in trade, which has been there for many years now. But 28(6)(a) came in just a few years back, and 2 or 3 years back, and 28(6)(a) says that the gain on the date of conversion of inventory into capital asset, whatever is the gain is taxable as business income. So when you convert your stock in trade into a capital asset, that gain is taxable as business income. Now, very often what happens is that I have, say, a property. I choose to carry out the activity of development on that property. Say it was, my factory building was there. It was definitely a capital asset. What I have decided is that I will redevelop that, and I will put up a multi-story, say maybe a mall I might put up, and I will put up a multiplex and a mall on that property. I will also have office buildings in that, and which I will sell off the office building and I will retain the mall. Now, very often what happens is that the SSE converts his capital asset into stock in trade by carrying out that activity of redevelopment. So therefore, 45(2) applies. Now, what does 45(2) say? That the capital gains will be computed up to the year of conversion, but the gains will be chargeable to tax in the year of actual transfer of the stock in trade. Now, when I complete the construction, I'm selling off the office buildings, so therefore that is business profits, no problem. But so far as the mall which I'm retaining is concerned, now that mall becomes my capital asset, so I'm converting my stock in trade back into a capital asset. The question here is, 28(6)(a) will apply. 28(6)(a) says that when my stock in trade is converted into capital asset, whatever is the gain, whatever is the stamp duty valuation, and this will be taxable as my gain in that year. But the question here which arises is, what about 45(2), which was postponed to the year of transfer? I have not transferred the mall. I have retained it. 28(6)(a) does not say that it does not deem a transfer, unlike 45(2), where it's been held to be a deemed transfer. 28(6)(a) does not talk about a transfer in that sense. It only talks about conversion of a stock in trade into a capital asset. And therefore, perhaps 45(2) may not be taxable at this juncture at all. 45(2) may become taxable only when I ultimately sell that mall in some point of time in the future. So that is one of the aspects which I wanted to bring to your notice. The next issue is on 50C and transfer of leasehold rights. As you know, the provision section 50C says that when you transfer an immovable property, you compare what is the stamp duty valuation of that property with the actual consideration, and whichever is the higher will be taken to be the consideration of the transfer of the property. Now, there the language is transfer of immovable property being land and building, or both. The question is leasehold rights land or building or both? That is the question which has arisen before the courts. And we had the Bombay Tribunal decision in the case of Atul Puranik in 132 ITD, where the tribunal said, no, it does not. It applies only to land or building. It does not apply to rights in land or building. That was the view which the Bombay Tribunal took. And when a similar matter went up to the Bombay High Court in the case of Greenfield Hotels and Estates, the Bombay High Court said that the revenue has not preferred any appeal against the decision of the tribunal in the case of Atul Puranik. Therefore, it can be inferred that that has been accepted. Whether revenue has accepted the decision of the court or tribunal on an issue of law and not challenged it in appeal, then a subsequent decision following the earlier decision cannot be challenged. That was the view which the Bombay High Court took in that case. In Heatex products, again, the same view was taken. They said that we followed Greenfield Hotels and Estates. When the matter came up again in Cancast Private Limited, on the same issue, the substantial question of law was admitted by the High Court in this case. They said that, the substantial question was, the question before the High Court was, whether on facts and circumstances of the case and in law, tribunal was justified in holding the provision of 50C does not come into operation where leasehold rights are transferred. The Bombay High Court looked at this and they said that when both these aforesaid decisions, Greenfield Hotel and Estate and Heatex products were not entertained by this court, the decision of the court in Pradeep Steel Re-Rolling Mills admitting the appeal on this very question was not brought to our notice, and therefore that was the thing, and therefore we are admitting this question of law. So therefore Bombay High Court has really not decided the matter in a sense if you look at it. There is a Rajasthan High Court decision in Ramjilal Meena where there they said that the Rajasthan High Court decision again is a very not very well reasoned decision, but it says that the bare perusal of 50C does not show that transfer of capital asset should be other than of leasehold property or khatedari land. The court cannot rewrite the provision. If analogy taken by the Bombay High Court in Greenfield Hotels case is applied in general, then 50C would not be applied in majority of the cases as it is not allowed for leasehold property. 50C is applicable to transfer capital assets for consideration. Bombay High Court has not referred as to how the land was in the balance sheet as a capital asset or not. Thus, we are unable to apply judgment of Bombay High Court in case of Greenfield Hotels. So, not a very well-reasoned judgment in this case. So, that was the... then, now we have the Karnataka High Court decision in the case of V.S. Chandrasekhar, where they have said that the expression 1 to section 247 uses the term immobile property, whereas 50C uses the expression land instead of immobile property. Wherever the legislature intended to expand the meaning of land to include rights or interest in land, it has said so specifically. 35(1)A, 54G, they've given examples. And the SSE had certain rights under the agreement. However, from the clear, plain and unambiguous language employed in 50C, it is evident that the same does not apply to rights in land. So they said that development rights in land also it does not apply, leasehold rights it does not apply. That was the view which the Karnataka High Court took. And we also have a Bombay High Court decision which did not consider all these judgments, but where this was a case where a society was redeveloping its building, and they said that the society was only the lessee of the land, and what was transferred to the developer is development rights and not land or building. No authority is required to hold that terms land or building or both do not include development rights, and then that in the case before us, there was transfer of such rights only. And the facts, then they referred of course to an earlier Bombay High Court decision in the case of another cooperative society, and there that was held that it was transfer of development rights. When you enter into a development agreement, it was a transfer of development rights. And therefore, they said that in this case also, the Bombay High Court has taken a view that this would not apply, 50C would not apply to transfer of leasehold rights. That's the view which they've taken. Then the next issue is, what about 50C? Does it apply to sale by a bank in auction? Now, very often what happens is when there's a sale by a bank in auction, now say the bank attaches a property because the loan has not been repaid, and they auction the property. The sale proceeds of the property are adjusted against the amount due to the bank, and balance, if any, is given to the owner. If it is less, then obviously they proceed against the owner to try and recover the rest, but they adjust this against the loan. But nevertheless, the owner of the property is liable to capital gains tax when the property is sold, whether it is by auction by the bank or by himself. In either situation, the question is, typically in an auction, because of the fact that there have been a dispute between the bank and there could be possible litigation. So there is always the price is depressed. So if the stamp duty valuation is 100, the property will be sold for 75 or 60 also at times. We've seen transactions happening like this. And therefore the question is that does this apply, 50C, provision of 50C, that if the property is sold at 60, does this owner still have to pay capital gains tax assuming that the sale price is 100? And there we have this interesting decision in the case of Mahavir Enterprises, where they said that the consideration stated in the sale deed pursuant to the public auction is to be considered as a fair market value. And for that, they relied on, of course, there was a circular of the state government of Maharashtra where they said that when there is an auction, then the price mentioned in that price fetched in the auction is really a fair market value. And therefore, that would be the stamp duty valuation, that would be the value. But they also referred to a Supreme Court decision in the case of ASL Vyapar Private Limited, and which was in the context of the West Bengal Stamp Act, this was. And there the Supreme Court has said, we have not the slightest hesitation in upholding the view that the provisions of Section 47A cannot be, of that Stamp Act cannot be said to have any application to public action carried out through court process or receiver, as that is the most transparent manner of obtaining the correct market value of the property. So what they have said, that is the correct market value, not their artificial stamp duty valuation, that is the correct market value. And in case of a public auction monitored by the court, the discretion would not be available to the registering authority there under Section 47A to refuse registration. That was in that context. Then the question is, what about cases of compulsory acquisition? So there also, compulsory acquisition, if the government acquires it for less than the stamp duty valuation, what is this tax liability? And there, the Calcutta High Court has rightly said that the question of payment of stamp duty for effecting such transfer does not arise. Why has 50C been brought in? 50C has been brought in to ensure that there is no evasion of taxes by transferring at a lower consideration. And therefore, in this case, the government is acquiring it. And where is the question of understatement of the consideration? And therefore, in this case, it will be the actual capital, the consideration which will be taken, and not the stamp duty valuation. Then the question, of course, is, does 50C apply to gifts of property? And typically, the question is, gifts of property are normally exempt under Section 47. When there's an individual, you say it's out of natural love and affection. But what if there's a gift by a company? Would Section 50C apply? Can you say that a company is incapable of gifting? Can you say that? Of course, the articles of association of the company have to permit a gift. That's one thing. But there are a number of tribunal judgments which I've reproduced here, where they've said that a gift is not only out of natural love and affection. Any transfer without consideration could be a gift. But, so therefore, it could be, even a company could make a gift in such situations, is what they've said. Of course, the recipient may be liable to pay tax under Section 56 to 10. That's a separate thing. But the provisions of Section 47, which say that exemption for a gift, that will continue to apply. Since it is an exempt transfer, the provisions of Section 50C will not apply in this situation. So that is the view which we have the Bombay Tribunal, the Chennai Tribunal, as well as the Ahmedabad Tribunal, all have taken the view. And they've said that, yes, the question there really was, can a company make a gift? In Reddington, India, the Chennai Tribunal looked at it and they said, when you look at the provisions of law contained in Section 5 and 122 of the Transfer of Property Act, a company being a living person can transfer property by way of a gift. So therefore, that is the view which has been taken, and therefore, Section 47 exemption should be available over there in that situation. What about the 54F exemption? Under Section 54F, when provisions of 50C apply, what is the consideration, because it is the net consideration which has to be invested into a residential house. What is that consideration? Is it the stamp duty valuation or is it the actual sale consideration? And there they have earlier decisions which took a view that, it will have to be only the stamp duty valuation. One Jaipur tribunal decision was there, but then I think now the provision is more or less, I think almost all the tribunals, including the Visakhapatnam tribunal in Mallikarjun Rao's case, they said that the difference, if the assessee invests the net sale consideration, it's eligible for exemption, even though the full sale value, of consideration is more than the result as a result of transfer. The deeming fiction of 50C in respect to the words full value of consideration is to be applied only to Section 48. You can't apply that deeming fiction to the provisions of Section 54F. For 54F, it is the actual consideration which has to be considered. Now, the only difficulty in this is, of course, there is one Karnataka High Court decision. There was a Bangalore Tribunal decision in case of Gauli Mahadev Papa, where they had taken a view that it is the full value of consideration would mean for 54F also you have to take that as this. But the Karnataka High Court, when it went to Karnataka High Court, it was partly affirmed, and they said when the capital gain is assessed on notional basis, whatever amount is invested in new residential house within the prescribed period, entire amount should get the benefit, irrespective of funds from other sources. So they decided on this issue. But on the major issue of this, it does not seem to have decided that. And that is where I think there could be some litigation on this, because as I said, the Bangalore Tribunal had taken a contrary view. But it's practically impossible. If I have sold a property for 100 and the stamp duty valuation is 150, my capital gains will be calculated on 150. But how can I possibly invest 150 in a situation where genuinely, and I know for a fact that in some places, for instance, when I had gone to Guwahati to give a talk, many chartered accountants told me, sir, that in most of the cases, the stamp duty valuation is higher than the actual sale price. You can't sell a property for that price, the stamp duty valuation. Those prices are just unrealistic because the government wants stamp duty, and that's where but this is, I think, a serious problem in that sense that yes, there has been, but how will you, in such cases, how will you even interest to get the benefit of 54F? That's the real problem which is there. And I think something which is impossible of performance will have to be read down, and therefore it will have to be the actual consideration. And as rightly said by the tribunal here, that full value of consideration only modifies the provisions of section 48. That is only for calculating the capital gains and not for the purpose of exemption under section 54F. Then the one issue, and where this question is, there have been 2 or 3 decisions of late, one decision of late rather, which has been a Hyderabad tribunal decision in the case of Rachit Shah, and where there's a little bit of tax planning which the chairman referred to. When one does tax planning, I think one has to remember that tax planning has to be within certain limits. It has to have a certain commercial purpose. And the question has been, you have, say for instance, today, this was a situation where, say you own 3 properties or 2 properties you own, and you're selling another asset, you're selling shares, and you want the benefit of section 54F exemption. Now, as you know, the benefit of section 54F exemption is available only if you own not more than one other residential house on the date of transfer of the asset. On transfer of the shares, I should own not more than one other residential. Because I'm owning 2 houses, so before sale of the shares, what I do is I gift one property to my wife or to my father or mother, and then say that I have only one property. That is the fact pattern in this case. And there, of course, one needs to keep in mind that today you have the provisions of GAR, the General Anti-Avoidance Rules. The General Anti-Avoidance Rules say that if one of the purposes of the transaction is tax avoidance, then the transaction could be declared to be sham. The question is it commercially something different? And that's what needs to be brought out. In this case, before the Hyderabad tribunal, they said it's merely a paper gift as it was not covered with the transfer of possession, and it was not executed on account of law of action, but only for the purpose of taking undue benefit of the provisions of law. Admittedly, even after executing the gift deed, SSC continued to live in the same property with his father. From the conduct of the SSC and view of the circumstances prevailing at the time of agreement for sale, more particularly giving gift to his father just before the date of agreement, it is clear that the SSC, act of the SSC to give the house is nothing but a concerted effort to avoid the due payment of taxes to the government. Act of the SSC was pre-arranged step for execution and served no commercial purpose, but was motivated to avoid paying taxes. So though GAR was not invoked in this case because the amount was less than 3 crore, because GAR applies only where the tax benefit is 3 crore or more. So in that case, but still, nevertheless, this seems to be a judicial GAR which seems to have been applied to say that no, this is a sham transaction. But this decision has not considered various other decisions where a contrary view had been taken. The Bombay Tribunal, in the case of Maya Ajwani, where the Maya Ajwani had gifted the property to her husband before the sale of the asset. And there the tribunal said that the law does not oblige a person to pay maximum taxes authorized disregarding a lawful transaction if it has the effect of reducing his tax liability. The transfer is by no means sham or bogus, notwithstanding that the SSC would continue to reside with the family, including a husband in the house, both before and after the gift. Similar, again in Samir Jasusa's case, the Delhi tribunal has taken a view that even after execution of a registered gift deed in favor of his wife, it cannot be resumed that the SSC is the owner of the house. He will get the benefit of 54F. And in fact, the Bangalore tribunal went a step further. Bangalore tribunal was a case of a Mohammedan who, by oral gift, hiba, he gifted it to his spouse. And the Bangalore tribunal said that it has been recorded through an affidavit and therefore it would amount to a valid gift. And Mohammedan law, oral gift is also a valid gift. So that is the view which is there. I think the point which I wanted to bring out is that one has to develop and bring out what is the commercial substance behind this. What is the justification for giving the gift? Now, there could be a situation where you're gifting to the spouse because the spouse does not have any assets, and you feel that there is some sort of insecurity in the spouse that there is nothing, all property in the husband's name and nothing in the spouse's name. And that was one of the reasons, could be one of the reasons. So one has to develop and see that what is the logic. Because today, I think one sees, I think the position was quite different maybe 20, 25 years back when the courts used to take 90% of the cases was being strictly going on the interpretation. But today, I think, unfortunately, we're seeing even at the Supreme Court level that the judges are looking at the situation that, is there, some this thing, what is a person trying to avoid the tax? What is this? And on that basis, the decisions are being coming. As I said, sometimes bad facts make for bad laws. So therefore, sometimes one needs to be a little careful when one does such a planning. And the last issue which I would want to deal with is on the provision of section 194 IC. And that is, where this has come in for TDS on payments under a specified agreement, which is referred to in 45(5)(a). What is 45(5)(a)? As we saw, it is an agreement of a development of a property, immovable property, where the owner is entitled to certain share in that of the constructed area. Now, 45(5)(a) applies only to individuals or HUFs. But if you see now the specified agreement, it says specified agreement referred to in 45(5)(a). Now, 194 IC came in the same year in which 45(5)(a) was also introduced. And as part of the same explanatory memorandum, they said that it's also proposed to insert a new section 194 IC so as to provide that in case any monetary consideration payable, tax at the rate of 10% shall be deductible from such payment. So they have brought in over there that yes, on the monetary consideration you deduct 10% on so far as this is concerned. Now the question here is, so because the rate is 10%, what if it's a company or a partnership firm which is entered into this development agreement? Would the provisions of 194 IC apply? Would the developer have to deduct tax at the rate of 10%? I think if one looks at the way in which the provisions have been inserted and the objective was to cover only those agreements which are covered by 45(5)(a). And therefore, in that situation, 194 IC would not apply. Then the question is, would 194 IA apply? Would it amount to an agreement to transfer, to purchase property, etc.? That's the question which would arise. And therefore, then the question is, should one, and here what happens is, unfortunately, very often the developer tends to take a safer view, says that no, the provisions will apply. In this case, that's this. But the problem, of course, is also in development agreements. What happens is, when a company enters into the development agreement, 45(5)(a) does not apply. So the capital gains is payable maybe at a time of substantial compliance, so when maybe the areas are bifurcated between the two. But the sale of the properties, if there is entitled to a certain percentage of the sale proceeds, and the sale proceeds are received at a later point of time, therefore there is always a TDS credit mismatch. Now, fortunately, there is an amendment of section 155, you have subsection 20 which is inserted, that you will have, where the TDS is deducted at a later point of time, you can claim TDS credit for the earlier year in which the income is offered to tax, even though the TDS is deducted at a later point of time. So therefore, here you will have that mismatch because the TDS may be deducted at, say, payment which is paid at time of execution of the development agreement, some payment would have been made. If TDS is deducted at that point of time and your capital gains arises only when the areas are bifurcated, then in that situation there would be a mismatch, as I said, and therefore the TDS credit or vice versa, in a situation where you pay the tax in the year of completion certificate or when you get your area of land, but the sale happens at a later point of time when you get certain part of the proceeds, there would be a mismatch, but you can today get this credit under section 155, subsection 20. Well, I think that covered the topics which I wanted to take today. Thank you, all of you.
Thank you, sir. I now request our chairperson to give his concluding remarks.
It was a very extensive preparation covering various sections of the Income Tax Act, and it was very educative. In fact, one of the judgments which he had cited, where a gift was made in anticipation of an agreement having been entered into, the tribunal ultimately rejects, saying that the gift deed is sham and nominal, and he has to pay the tax as though the gift deed was not in existence. In fact, my first question that I am going to put to him is this. See, in the eye of law, a tribunal cannot set aside or annul a sale deed or a gift deed. Now they have disregarded the gift deed and say you pay the tax that is required to be paid. Oh, what happens? Well, fine. Ultimately, they are possibly entitled to levy the tax ignoring the gift deed. But over the period, under the Transfer of Property Act, there is no transfer of, there has been a transfer of property under the gift deed which has not been annulled by a civil court. What happens? Will this property be continued to treat as the property of the donor for the subsequent years. Something which I thought so there will be a dichotomy. The owner will still be in law under the Transfer of Property Act. So it was very extensive and very educative. The audience is free to put questions to him on whatever he has now taken us through. Any questions?
Good afternoon, sir. This is Ramakrishnan, Chartered Accountant. In the slides relating to the gift of shares by a company, you had referred to the Madras High Court decision, Madras Tribunal decision in the case of Reddington. Actually, it has been reversed by the Madras High Court, holding the gift as not genuine.
Oh, okay. So that brings out, I think, the risk in this, where genuineness, etc.
Genuineness is because when looked from a tax evasion or a tax planning angle, all these are considered as premeditated actions to reduce tax and not planning in the planning sense.
Correct.
Any questions? Good evening, sir. This is Muthu Abhirami. Sir, when owners are giving away their land with building to the developers, builders subsequently demolish that. But the license for demolishing and everything is taken only in the name of the owner. In such cases, whether they would still be eligible to claim 54 deduction. In these cases, mostly the courts may come and say that you are only eligible for 54F deduction because the land was demolished by you, though the intention was to give the land for development. Some thoughts on that, sir?
Yeah. So typically, what one would try to do in such situations is that, say that the development is of the immovable property, which consists of the land and building, is what one would try and this thing. But yes, there have been tribunal decisions also, I think, where they've said that really, in substance, what you have transferred is only the land and really, not the building, because the building got demolished as a part of this process. But if today one says that all the plans, etc., are by the developer, suppose if the developer is able to get the plan sanctioned in his name, and the demolition is carried out by the developer, then perhaps one can take a view that there is a transfer. So therefore, it's, I think, in the contract stage itself, one has to therefore see that, and as I said, if you look at these decisions in the context of 247 also, so one has to build it into the development agreement to see that the owner has this thing, whether it's the owner or not, or what is the, so therefore what was one want to achieve by that, one has to be very clear from at the initial stage itself. Yeah, okay. No, then I think, yes, there could be possible difficulty. But as I said, there are tribal decisions on both sides. They have taken.
You see, the question is, ownership has not been transferred by the landowner or the house owner in favor of the developer. Obviously, that's not very economical. And the fact remains that at that point of time, it is only the owner who can apply for demolition, right? So therefore, he applies for demolition. That, I think, is merely a procedural act. And as the transfer takes place over a period of time, say 2 or 3 years in terms of undivided share being sold to prospective purchasers. So therefore, it's a very interesting question. And ultimately, that doesn't make the developer the owner of the property.
Yeah, this is Sridhar, Chartered Accountant. Here, sir.
Yeah.
This is with regard to the condition that the joint development agreement should have been registered under 45(a). In practical sense, more often than not, we see small timers developing 4 or 5 flats by way of a joint development. The family gives the property and practically they don't register it. My question is, at the hindsight, when it is offered for the taxation at the fag end as per 45(a), is there a chance that an enterprising officer will go back to the earlier period and start? doing that?
No, there I think you're clearly supported by the Supreme Court decision in Balbir Singh Maini's case, where Supreme Court has said that an unregistered development agreement is not a valid contract at all.
Yeah, that is true.
So
but in
therefore-
practical sense, for small timers, like they go for a JDA and they never register it. So my question is to us in whether there is a possibility that the enterprising officer will go back and ask the tax to be paid 2 years before when the JDA was entered.
No, I don't think so. See, if you look at it, firstly, as an individual or an HUF, very clearly you are entitled to 45(5)(a). Secondly, even otherwise, because the agreement is not registered, the Supreme Court says that you can't be taxed in the year of development agreement. That very clearly, it does not give rise to any transfer, is what the Supreme Court has said. So it will be rise only when you have the registered documents. It's at that stage that the transfer would take place.
So other question is now in the case of displacement of the owners, they give rent in lieu of their displacement, and the developers deduct tax at 194 IC, whereas the agreement is between the landlord and the tenant, that is the displaced owner. So how does it go well? Whether it's a part of consideration is one thing.
Yeah. So here there is a recent, around a month back, there was a Bombay High Court decision in the case of Sarfraz S Furniture Wala, where the Bombay High Court has taken a view that in such a case, in fact, this question was whether TDS should be deducted by the developer or not, and that was disputed by the owner, saying that no, because this is no TDS should be deducted. This was, of course, for a period prior to 194 IC. That was the thing, where they said that rent is not taxable. The Bombay High Court agreed with the, there were two tribunal decisions which they referred to, Mansuka, I think Dilaila Mansukani and one more decision, two decisions they referred to. And they said that in those cases we have taken the view that it is not taxable, and we agree, the tribunal has taken the view that it is not taxable, and we agree with those decisions. So therefore, firstly, it is not taxable, but 194 IC, the problem really is that any amount in which is a consideration for the as per the 45(5)(a) agreement, and that's where I think the problem is developers have been resorting to deduction at source because they regard this as part of the consideration which is flowing. So whatever monetary payments are being made, they are deducting TDS, and I think that's the safer thing so far as the developer is concerned. If I were so far as the taxpayer is concerned, they could, of course, file the return, claim exemption, and claim a refund of the TDS is the way I would look at it.
No, but in case when rent is paid more than the threshold limit, the deemed gift will be affected. No, because it is from a third party, the rent is being paid, and it is more than 50,000 rupees, obviously. So there should be a provision where it should be taxed. That's my view.
No, the gift in what context you're saying?
No, because the tenant, the owner, the developer is paying the
tenant, original tenant.
It is not taxed as a consideration of JDA also. It is not also taxed under 56 in the case of this thing.
Yeah, because see, you cannot say it is without consideration. So 56 to 10 will not apply there. So what the courts have taken, the tribunals have taken a view that this is a capital receipt. It is for a personal inconvenience and therefore not taxable. That was the view with the tribunals. That was the basis for.
But once TDS is directed, it's mapped, and obviously.
Obviously there will be litigation. I think, but that's something which is unavoidable, frankly.
Sir, agricultural land, which is situated about 3 kilometers away from a place where the population is less than 50,000, the government has converted it as commercial land, though only agriculture is being carried on because it's a flood-prone area. When the landlord tried to sell the property at the value really existed in that area, they said you have to pay stamp duty as per the converted commercial land. Then he offered the property to government to purchase that land at the price of the commercial conversion rate. Government is refusing to buy. What's the solution for this landlord?
So you're saying that this is more of a stamp duty issue rather than an income tax issue is what I understand. that the stamp duty is having, the government is insisting that you pay tax on the basis of the commercial rate.
Yeah.
Now, that I think it's depends on the facts. You'll have to show that the facts are that this is agricultural land, which is classified as agricultural land in the revenue records.
No, they converted it, sir.
They converted it, okay.
Government has converted it as commercial land.
I see.
It is situated 3 kilometers away and it's a wetland, irrigated under a canal system, delta land. So the government just converted it for reasons best known to them. But he could not sell it for more than the agricultural land value. But the government is refusing to register at that value. This man said, better you acquire the property and pay me the money, guideline value, I will accept it. Government is refusing to take that land.
I think the only solution in such cases is to file a writ maybe and say that, this is the facts, etc. That's, I don't see any other solution to this.
Okay, sir.
Sir, from what I understand, in Balbir Singh's case, the Supreme Court emphasized on aspect of registration and allowed the benefit to the assessee, treating that it is not a transfer at all. But on the other hand, when you cited a case of oral hiba, oral gift by a Muslim, you cited a case. The tribunal had said that although it is oral, it is deemed to be a transfer so as to count the number of assets. So the same aspect of procedure, one side it is deemed as a transfer, other side it is not deemed to be a transfer. But in both cases, revenue is at benefit. Assessee, it has been interpreted in favor of the assessee. Although as practitioners, we might benefit out of that.
Correct.
But is it fair, sir?
No, see, what happens is the tribunal looked at Mohammedan law and they said that Mohammedan law would override the provisions of the Registration Act, etc. in that case. And that's how they decided the matter, if you look at that decision, so that's.
Vikram here. No, I just wanted to know if you have seen any cases where both 50C and 56.210 have been invoked in the transaction, because it is possible. In as much as 50C says that the guideline value has to be done, you've done lesser, and 56.210 he has got a benefit without paying for the same.
So you're right that technically it can be invoked, but I have not practically come across a situation so far. But see, there are actually, if you look at it, there are two different aspects of the transaction. Under 56.210, they presume that you have paid some money under the table, and that's why you got the property at a low rate. So therefore, it is your unaccounted money that they're trying to tax. Under 50C, they're saying that your capital gains, you have understated the consideration to pay lower capital gains tax, and therefore we are charging you on the higher capital gains tax. So in one case, they're charging the untaxed capital gains. In the other case, they're taxing the so-called black money which you may have paid to acquire the property. So therefore, there are two different aspects is the way I look at it.
I think with that we can close this technical session. I now request Ms. Vandana Sagar, Principal Commissioner of Income Tax, to present a memento to our chairperson. Thank you, ma'am. I now request Mr. Nandakumar, CITDR, to present a memento to the speaker. We will now begin the third technical session, which is attacking the source, tackling the conundrum of deeming fictions under sections 56 and 68 to 69C. We call upon the chairperson, Mr. Mahavir Singh, Honorable Vice President of the Income Tax Appellate Tribunal, Chennai Zone, and Mr. T. Banashekar, the speaker for this session. On stage, please. Cash as deposits, investments, and expenditure, and its exigibility to tax has been a much debated topic for a long time now, especially post demonetization. So for this session, we have Honorable Vice President of Income Tax Appellate Tribunal, Chennai Zone, Mr. Mahavir Singh as the chairperson, and Advocate T. Banashekar as our speaker. I now invite Advocate Vikram Vijayaraghavan to introduce the chairperson and speaker and give a brief overview of the session.
Thank you. So we start a third session, and it's on tackling the conundrum of deeming fictions under 56, 68 to 69C. We look forward in this session to understanding through this esteemed speaker one of the current hot topics of income tax litigation, being firstly the deeming fiction under 56. It has a checkered history and been subject to many amendments in the last decade or so, giving rise to many open issues. I could go on with many examples, such as the applicability of 56(2)(10) to fresh issue of shares or bonus issues or buybacks, and whether the property definition is inclusive or not. The transfer of properties of partnership is subject to scrutiny under 56(2)(10). There are various nuances that we hope that the expert speakers will be able to shed light on. Further, credits, money, investment, expenditure, etc. that are added under section 68 to 69D are also the result of deeming fictions, which have been vexatious issues for long, especially since post-demonetization. Today's session, no doubt, will throw light on the myriad contours of these sections. To chair this important session, it is indeed our privilege to have here the Honorable Vice President of the Chennai Zone of the Income Tax Appellate Tribunal, Shri Mahavir Singh, as the chairperson. Thank you, sir, for gracing this occasion. Lordship doesn't need an introduction, but I will make a formal one anyhow. Lordship was born on 2nd March 1965 in Hanumangarh, Rajasthan, and did his BA and LLB from Punjab University in 1989. Shri Mahavir Singh joined the government service in August 2003. Shri Mahavir Singh, prior to his government service, practiced as an advocate from September 1989 to July 2003 in Chandigarh. Lordship's wisdom, acumen, sharpness, and judgments par excellence as a judicial member of the Honorable Income Tax Appellate Tribunal is known to one and all. His leadership and administrative skills as the Vice President of the Chennai Zone since 2020 has set a very high bar and a worthy example to follow. We are privileged here, sir, to have you as a chairperson. Thank you. Mr. T. Banashekar also does not require an introduction to us all, but I will provide a formal one nonetheless. He is a distinguished professional with a strong background in finance, law, and taxation. He became a chartered accountant in 1994 and subsequently an advocate enrolled with the Bar Council of Tamil Nadu and Puducherry. Additionally, he is an associate member of the Institute of Cost Accountants of India, and he has made significant contributions to the field through his writings, including numerous articles on direct taxes and international taxation for prominent tax journals, as well as authoring books on income tax search procedures and assessment procedures. His wide-ranging legal practice includes arguing cases before various courts and appellate fora across the country. In addition to his practice, Mr. Banashekar is an accomplished author and educator. He has written several books, as well as served as a visiting faculty member at institutions such as the ICAI, the Institute of Company Secretaries of India, and the Loyola Institute of Business Administration. His expertise in direct taxes has made him a very sought-after and a very popular speaker at seminars, workshops, conferences, symposiums organized by various professional bodies across India, including the SIRC of Chartered Accountants and other regional branches, as well as many other professional bodies. Mr. Banashekar's professional involvement extends to significant roles in various committees and organizations. He has served as the chairman of the Direct Tax Committee of the Hindustan Chamber and is a columnist for the Hindu Business Line in the personal finance section. Additionally, he has been a member of the Southern India Regional Council and held key positions in various committees. His contributions also include participating in training programs for income tax commissioners at the regional training institutes and the National Academy of Direct Taxes. And he's been actively involved in brain stress sessions organized by various branches. Thank you, sir, for raising this occasion. With this, I'd like to start this session. Thank you so much. Please come for the opening remarks.
Vikram, as usual, yeah. He is very fast in arguments also. Normally, there is a complaint from members that you argue so fast, we don't understand what you have argued. That is your intelligence, actually. Thank you. President of Bar, Mr. Sridhar, advocates, chartered accountants, my dear friend Bhanu Shekhar, who will explain the nitty-gritty of deeming provisions, section 56, 69, 69A, 69B and C. The humanity started, and with the human growth, economics also evolved. With the evolvement of economics, taxation system started. And with the taxation system, struggles also started. Struggle between state and subject. State want to extract maximum tax. Subject want to pay minimum, rather less than that. And for that they plan the things. The implementing authorities of Income Tax Act will confine to Income Tax Act. It's a failure for bringing the deeming provisions because they are unable to tax properly. Or it is a vice versa because society is so clever. They plan the things or they conceal. To fulfill the gap, the state has to bring deeming provisions. Take example of 50C, a house is sold. It is a common knowledge that a particular house is being sold supposedly for 5 lakh rupees, and circle registry is being done at 2 lakh rupees. 3 lakh is black money. And if the circle rate is not fixed, people will go out for registration for 20 lakh, 50 lakh or whatever. And government cannot find, or the department cannot find the actual source because black money circulation is there. It is an admitted fact in the Indian economy. To plug that, the deeming provisions are brought in. But deeming provision doesn't mean that that is to be taxed in entirety. Take example of unexplained cash credit. Unexplained cash credit credit is shown in the books of accounts and you ask for information. If you can satisfactorily explain to the satisfaction of the ITO or AO, addition will not be made. No doubt that is not your income. Nobody knows whether that is the cash credit is genuine or not. Sometimes it so happens that genuine cash credit also added, and many a times. But there are many cases where genuinely tax credit is added. Reason being, assessee tried to explain the source, but not to the satisfaction of the AO. There are certain parameters laid down in that. These are the few examples, very navy examples, very basic example of deeming provisions. The state has to bring these deeming provisions due to the demand of time, because either the failure of the implementing authorities or the society is more clever. The best example of deeming case law of Honorable Supreme Court is P.K. Noorjahan's case. That is the basic case. A deeming fiction created by Section 69 regarding the value of investment explained by assessee from his past savings. That was upheld up to Supreme Court, that edition, because assessee was unable to prove the sources. So, first and foremost thing is, in deeming provisions, assessee has to explain to the satisfaction of the AO whatever the investment, unexplained money, unexplained cash credit, or anything. So this is the basic of deeming provision. And one Lord Estate in East Dwelling Company Limited versus Finsburg Borough Council, 2 All India Report 587, has explained this in his own words while explaining deeming fiction. I quote, "You are forbidden to treat an imaginary state of affairs as real. You must surely, unless prohibited from doing so, also imagine as the real consequences and incidents which, if the putative state of affairs had in fact existed, must inevitably have flown from or accompanied it. The statute says that you must imagine a certain state of affairs. It does not say that having done so, you must cause or permit you imagination to boggle when it comes to the inevitable corollaries of that state of affairs," unquote. It means that the government has to take an imaginary thing while enacting this provision. Because imagination is that there in transactions there are tax evasion, so deeming provisions are brought in. Recently, the 56 is amended time and again, and 68, 69, 69A, B, C. There are many other deeming provision in the Act, but today's subject is only this. Today expert, Mr. Bhanu Shekhar, is there to explain the nitty-gritty and all the explanations, because I don't want to speak much on this subject because I'm holding a position in the system. So better Mr. Bhanu Shekhar explain in entirety. Thank you very much.
My chairman, the Honorable Vice President of the Income Tax Appellate Tribunal, Honorable Member of the Central Administrative Tribunal,
Principal Commissioner of Income Tax, Commissioner of Income Tax, and other friends. In fact, it's indeed a great privilege and honor to be here, sitting on the dais along with the Honorable Vice President. And it was he who set the tone when he started off with saying that these are deeming provisions. Two things I'll have to say before I start. One, whenever a biodata is read, I normally give a confession that that was written by me. But this time it was Vikram who redrafted the biodata. So whatever good things he said were probably real also. Second is to the Honorable Vice President, what I say here is not what I argue tomorrow. These are my views, but I argue what I am paid to argue, that is all. They are two clear, distinct facets. I will not want to be bound by what I have said today. And I have been very clear about one thing, advices that come free are always taken with a pinch of salt. Well, the deeming provisions in Section 56 and in Section 69 to 69C particularly. What I will do is, I will start with 68 to 69C and then go on to the provisions of Section 56. In fact, it was the Honorable Vice President, the chairman of this session, who set the tone by using the word deeming in several places when he was opening the whole session. In fact, that was the first doubt that came to my mind as I was reading. I've always said this, the more you read the subject of taxation, or for that matter any law, the more are the doubts in your mind. In fact, to put it very simply, when I was coming this morning along with my driver, I asked him, do you have any doubts on income tax? And he said, no. Look at us all here. I'm sure every one of us is running with doubts in our mind. And the first doubt that came to my mind as I started reading for this session was whether the provisions of Section 68 to 69C are deeming only to the extent of the year to which it is said to be taxable, or is it deemed income itself? Why this question arises, I will come to a little later. But I think the Honorable Vice President made it very clear, which is my understanding too, that it is not merely deeming something to be the income of a particular year, but in the first place is deemed to be income. And also lays down in which year it should be deemed as income. There are two aspects or facets to this. Why I am emphasizing this, I am not touching upon at this point in time, and I shall come to it a little later. Now, if I keep this in the background, I go back to Section 5 of the Income Tax Act. Section 5 of the Income Tax Act makes it very clear and in no unclear terms lays down that income from any source can be brought to charge. Therefore, it is my fundamental understanding that income from a source alone can be brought to charge under Section 5. And once it is from a source, then that income is to be taxed under the 5 heads as are laid down in Section 14 of the Income Tax Act. What does Section 68 to 69C do? Section 68 to 69C, in my view, dealing the requirement of a source in dealing with taxation. In other words, even if it is not linked to a source, the said sums can be taxed so long as they fall within the ambit of these deeming provisions. In fact, I go a step further. I should not even be using the words so long as. I should be using the words only if. Only if you do not know the source can the deeming fictions in 68 to 69C be invoked. Again, this is of great importance to me because I understand that Section 115 BBE, which is now there, which seeks to tax me at 60% plus effective surcharges, bringing me to 78% almost, being the rate of tax other than interest and possible penalties, is something which can be invoked only if 68 to 69C is covered or is triggered, I will say. So if these provisions are not triggered, or rather if a source is established to a particular receipt, or in any manner any investment is tagged to a source, then the taxability is under the 5 heads of income, in which case 115 BBE has no applicability to the SSC. So I start with section 5 and say that in my understanding there has to necessarily be a source to an income. And if there is no source to an income, then the provisions of 68 to 69C get triggered. The chairman of the session, the Honorable Vice President, was also referring to how taxability evolved as economics grew, and how the system developed, and how the tax gatherer wants to gather the maximum tax and the taxpayer would like to pay the minimum possible taxes. And why these deeming fictions? The fact that there is circulation of black money in this economy and in the system is something which is a known fact, and probably an evil which exists, and that is why the deeming fictions. And Vikram was referring to how after demonetization there has been a substantial or an exponential growth in the manner in which section 68 to 69C have been applied by the revenue authorities, particularly in the light of the higher rates of tax. I still remember, as a student of chartered accountancy, I used to go and listen to speeches of Mr. Palkiwala. He used to come every time after the budget and speak here in Chennai. I still remember when he used to often say, tax laws in this country are made on the foregone premise that every Indian is a crook. It was not my statement, it was his. So these deeming fictions are probably because there are people who are evading taxes. And sometimes, as the Honorable Vice President put it, genuine credits can also be taxed because it cannot be proved to the satisfaction of an assessing officer. And as we proceed, we will see that the law as it stands today does not require you to demonstrate just source, but also the source of source, which to my mind is almost an impossibility. It is close to an impossibility. I come to you and I want to borrow 10 lakh from you. I tell you, look, tell me from where you got this money. Only then I will accept the loan from you. Give me proof that it is your accounted money. I will thereafter accept this loan. If anybody here is willing to share all those data with me, I would admit that proving a section 68 is very simple. You will not give the 10 lakh. No, he will have the 10 lakh but won't give. I know Sridhar like the back of my palm, so I really know what he will do. And if at all he gives the money, he will not give the source, probably because he is not able to explain. The commissioners here may take note of this. Well, so what happens is that even a genuine credit can be taxed under the provisions of section 68 to 69C, or a genuine investment for which I am not able to demonstrate to the satisfaction of an assessing officer that it is genuine. Now I will go straight away into section 68. Now before I go into the nitty-gritties of section 68 itself, you will recollect that tomorrow in the first session, you have a separate session on the interplay between other economic legislations and income tax. I don't intend to intrude into that subject at all, for I don't even claim to know those subjects. But, not that I claim to know this subject either. I am here because I have more doubts than you have. That is all. Now, the interplay between those sections becomes even more tricky in the context of section 68 to 69C. Now, take for example the Benami Transactions Prohibition Act. The premise is that I am holding an investment out of monies provided by you to me for your benefit. This is what is the allegation of the Benami Prohibition Unit when they treat me as the Benamidar and you as the beneficial owner. At the same time, the assessing officer makes an addition in my hands stating that it is my unexplained investment or my unexplained credit. I don't know how these marry. Because on the one hand, my income tax officer or the assessing officer is telling me, I am not able to demonstrate the source. The Benami unit is issuing a notice saying that the source is you. If that is true, then how do they marry? The same can happen under the Money Laundering Act. A similar situation can arise under the Money Laundering Act as well. Well, I leave it to the speaker of tomorrow's session to handle this. He's an ex-member of the ITAT and I'm sure he is going to throw a lot more light on this. But this was one of the questions that has been nagging my mind for some time now. Now, section 68, the very basic is that it starts off with saying cash credits and provides that it should be a credit which is found in the books of account maintained by the assessee and that it will be deemed as the income of an assessee in the year in which it is found credited. If the explanation given by the assessee is not satisfactory, the law has been amended time and again to say that in respect of loans, it is not enough if you prove the source, but it is necessary that you prove the source of source. And this has been extended in respect of share capital as well. When I say loans, I mean loans in any manner. It can be a loan, it can be a borrowing, or the like. And when I say share capital, I include share application or the like. Therefore, now the law has gone a step further, requiring me to demonstrate not merely the source, but also the source of source. Now, the first question that occurs to my mind is what the Honorable Vice President again touched upon as the decision of the Supreme Court in Noor Jahan's case. That was in the context of section 69, but will have application probably in respect of all these deeming provisions. What if I am not able to prove it to the satisfaction of an assessing officer that a particular credit is genuine? Is it mandatory for an assessing officer to treat this as income? Now, this decision of the Supreme Court in the context of section 69 in Noor Jahan's case attains lot more significance in the context of 68, particularly after the amendments that are found in section 68. Because if one were to look at the provisions of section 68 as they stand today, on the one hand, section 68 starts with opening clauses where it says it may be taxed. And then you would find that it talks about loans and talks about the source and the source of source, where it says it shall be deemed not to be satisfactory unless. It says it shall be deemed not satisfactory. So the words may and shall are found here. So what is the correct position in law? Is the decision in Noor Jahan's case where the Supreme Court in the context of section 69 said that the word may used in section 69 makes it abundantly clear that even if an assessee is not able to explain the source for an investment, the income need not necessarily be assessed in the hands of the assessee. So the surrounding circumstances will have to be looked into, And only in that context the provisions of section 69 have to be invoked. Now, to my understanding, the word may is still found in the opening clauses of section 68. And once the word may is found in the opening clauses of section 68, I would think there is no mandate on an assessing officer to necessarily add a credit, which is found in my books. Even if the explanation is not satisfactory, if the explanation is not satisfactory, they provide for circumstances. Even if he finds the explanation not adequately satisfactory, the assessing officer is at liberty to look at surrounding circumstances and examine whether that particular amount should be brought to tax in the hands of the assessee or otherwise. Now, the provisions of section 68 are, as we have been talking time and again, is deeming a credit to be income and places a burden on the assessee to demonstrate that the credit is in fact genuine. Normally, if an amount should be brought to charge under the Income Tax Act, it is for the revenue to demonstrate that I earned the income. Take a simple example, very simple example. I gave loan to you out of my own funds. I don't charge you interest. Can the revenue treat or say that I should have lent it on interest? The answer is no. But if they do find that I have charged interest, then of course the transfer pricing provisions may still be an exception. Keeping that aside, in normal circumstances, if I lend out of my own funds, there is no need for me to charge interest. They cannot deem it to be income. And they cannot bring it to charge because there is no deeming fiction. But in the context of section 68 or any of the provisions that we are going to discuss for some time now, if there is a credit which is found in my books of accounts, say for example, it is deemed to be my income, and the burden of proof is on me to demonstrate that the credit is genuine. Now, I don't have to explain to a set of complete professionals here that there is a difference between the burden and the onus. The burden is static, the onus shifts. The onus is initially on the assessee to demonstrate that the credit is genuine, and if the assessee is able to pass the first step by proving the identity, the genuineness and the creditworthiness, now not merely of the source but of the source of source, then the onus shifts on to the assessing officer. It is like a cat and mouse game. So I say I have discharged my primary onus. The onus shifts onto an assessing officer. The assessing officer would then have to bring in evidence to controvert that the data given by me is either incorrect or is insufficient to demonstrate that the credit is genuine. And if he is able to bring in such evidence, then the onus is back on me. At a point in time when either party is unable to discharge a further onus, if I am the assessee, it will be deemed as my income. If I am the assessing officer, I will deem it as your income. It's as simple as that. This is how the basics of section 68 operate. The burden is static, but the onus keeps shifting between parties. That said, we will also have to understand that an assessee is at liberty to require an assessing officer to exercise his powers under 131, to issue summons and require a party to be present, particularly when it is the witness of the officer. I am afraid if it is my own witness, I cannot require an assessing officer to issue summons on such party. But if it is the assessing officer who chooses to bring in evidence or a witness, I think he would be under a bounden duty, if so required or requested by an assessee, to necessarily issue summons on that third party to be present And if he is unable to do so, or unable to make the presence or bring the presence of that person, I would think that the onus that is cast on the officer would be said to be not discharged, and I should be exonerated as an assessee. But if the witness were mine, then probably I cannot say, you bring him only, then I will. That I think I may not be in full agreement with, insofar as these witnesses are concerned. Now, the year of addition is again deemed. In the context of section 68, I see no great confusion, largely, because it says in the year in which it is found credited in the books of account of an assessee. So there is a clear mandate that it should be brought to charge in the year in which it is found to be credited in the books of account of the assessee. So I understand a few things out of this. One, the year of chargeability is the year of credit, and that credit should be found from my books of account. And when I say it should be found from my books of account, what can constitute books of account becomes the next question. I think that is fairly well settled, particularly in the light of section 212A, which would say books of account include the following. But then you will notice that 212A is an inclusive definition, and one cannot say that by virtue of 212A, if something is not regarded as books of account, then it is not at all to be considered as books of account. Because one of the most popular decisions in the context of books of account would be the decision of the Bombay High Court in Bhaichand Gandhi's case, where the Bombay High Court would hold that bank passbooks are not books of account of an assessee. Because today we have gone back to bank passbook. In fact, this is how we have been doing for time immemorial. I remember that my grandmother never used to know how to read or write. And whenever she had to accept some post or something like that, she used to put her thumb finger impression. Today, remember what all of us are doing. Starting from your attendance, to your Aadhaar, to everything, it is your fingerprint now. Right? We are going back in time. Now, when we go back in time, we have to understand that times are changing and evolving. In fact, I'm sorry if I'm digressing, but then I have always understood one thing: there is no new crime. The manner in which crimes are committed have changed. Crimes are the same old. Earlier, you had to go to a bank to loot it. Today, you just need a password to take the money out of the bank account. That is all. The method has changed. Looting continues. So, there is no new crime. What have we done? We have graduated from loose sheet to WhatsApp to hard disk. Today, it has become so easy. In fact, yesterday I met a good friend of mine. I'm sure he's here because he said he had registered sometime in the evening, and he was saying, it has become so boring to deal with these search cases. Every time loose sheet, every time WhatsApp. These are the only two things that we seem to have: hard disk, WhatsApp, loose sheet. And we have still not got over that red diary. Little red diary which contains all information. Now, what is the significance of all of these? Would one say that these are books of account? Well, to my mind, loose sheets cannot be regarded as books of account. WhatsApp messages cannot be regarded as books of account. Right? In fact, the usage of WhatsApp messages itself is a larger question. We have decisions of the Chennai Tribunal, we have decisions of even the Supreme Court, though not in the context of income tax, where they say how electronic evidence can be used, and the Chennai Tribunal will say that even WhatsApp messages are electronic evidences. So the usage of these in the context of section 68 is one question. To my mind, loose sheets cannot be regarded as books of account, We have the old decision of Supreme Court in V.C. Shukla's case, a later decision of Supreme Court in the case of common cause, and lately followed by the division bench of the Karnataka High Court in Sunil Kumar Sharma's case, where they said loose sheets are not to be used as evidence. Interestingly, you will see that in V.C. Shukla's case and common cause's case, the loose sheets or the diaries were found in third-party premises. Whereas in Sunil Kumar Sharma's case, it was found in his own premises. And even then, the Karnataka High Court says it cannot be regarded as books of account, and no addition is possible under section 68. Now, there are a lot other factors to this. We will have to analyze all this in the context of 69, 69A, B, and C as well. But be that as it may, for the time being, I will stop here with saying that loose sheets, WhatsApp images, or WhatsApp conversations, or any of these cannot be regarded as books of account. A diary written by my staff or even by me cannot be a books of account. It is a book, not a books of account. Right? In fact, the Madras High Court in Taj Borwell says profit and loss account is not books of account. Profit and loss account may be drawn from books of account, but that is not books of account. And one cannot more than agree with this, because we all understand that profit and loss account is drawn from books and is not the books itself. Now, it is in this background that we have to look at various aspects of taxability under section 68. Now, we have been talking about what can constitute or what cannot constitute books of account. But then there are a number of other issues that arise. I have seen circumstances where assessing officers have rejected my books of account and then taken the credit from my books of account and said, this is unexplained. Once you reject my books of account, you don't rely on that. Once you choose not to rely on that, you cannot rely on that in bits and pieces. So, which means that the assessing officer, having rejected my books of account, at best can estimate my income. And it would not be permissible for him to ask me to explain the credits that are found in the books of account. Now, in the context of 69 or 69A, the rules may be different, because there they refer to books of account, if any, maintained by the SSA. Now, go back to 69B, it says books of account. It doesn't refer to if any. The words if any are missing. That is again of great importance to me. Right? Now, having said all this, once somebody rejects my books of account, it is not possible for one to say that I need to explain a credit in that books. That said, I'm sure I'm going to be hated for what I'm going to say now, but I would rather be hated, and as I have already given a disclaimer that I don't have to argue what I am saying here tomorrow, I've always been apprehensive about one question. What is the interplay between 44 AD and the 68 to 69C? Now, I would look at it in two angles. I will take the first one. Let us say I simply file my return of income saying that I have a gross receipts from a business activity which qualifies for 44 AD of 1 crore, and I am offering 8 lakhs as my income. What is it that is my responsibility at that stage? My responsibility in my understanding at that stage is only to demonstrate that I have in fact carried on an eligible business. And at best to demonstrate that my credits in the bank don't exceed that 1 crore rupees. Of course, I understand that under 44 AD, banking channel there is a lesser percentage, non-banking channel there is a higher percentage. I don't want to get there because this session is not on 44 AD. This itself I had to read. 44AD I didn't read and come. Therefore, excuse me. But I understand that I have a 1 crore turnover. I minimum need to demonstrate that my credits in the bank don't exceed that 1 crore, in which case I need to demonstrate something else, A. And B, that I in fact carried on a business which is eligible for 44AD. If I am unable to demonstrate that there is in fact a business that I carried on, which is eligible for 44AD, or I did not carry on the business, I would think an assessing officer is at liberty to reject my claim under 44AD. But then what will he add? Is the next question. Will he add the 1 crore or will he add the 8 lakh? And if he is going to add one of these, under which section? This is the first question. The second question, which is probably the question that is the answer which is going to generate more hate, is if I am offering income under 44AD or for that matter under 44ADA, is that an amnesty to me? For the impugned year, it is an amnesty to me. An assessing officer cannot get into anything more. But remember that that represents only the income from the said business or profession. So if there is a credit that is found in your books of account which is not related to the business or the profession, which is coming under 44AD or 44ADA, I would think the assessing officer is at liberty to examine that credit independently. Because the provisions of 44AD and ADA only talk of the income of the said business to be 8% or as the case may be 50%, depending on whether it is a business or a eligible profession. Likewise, if I am earning, say my gross receipts are in real 1 crore and I have in real earned 20 lakh of profit, but under 44AD I show only 8%, is an officer under a mandate to assess me only at 8%. The law says 8% or such higher sum as may be offered by assessee. It doesn't give the liberty to an officer to add more than this. This is the easier part. But then tomorrow, I now have 20 lakhs with me. I have shown only 8 lakhs. If I invest this 20 lakh, can an assessing officer say the balance of 12 lakh is unexplained? At that point, am I at liberty to demonstrate that I actually earned 20 lakh and this is not unexplained? The first thing is you are not required to maintain books of account. And if you are maintaining books of account, then you will offer the higher sum. That is the logic. So I don't think there is an immunity which arises as a result of 44AD or 44ADA. But then again, the question that is looming large is under what section will I assess you? Now here let me take the second of the issues first. I have shown 8 lakhs as my income, but in the next year I have invested 20 lakh or I have brought in a credit of 20 lakh into my books of account. Can the assessing officer treat the 12 lakh as unexplained income of the next year? The answer is quite simple. I would say if I were the officer, I will invoke 68. Again, I will not argue the same things tomorrow. Right? Because I have two people here. One is the one of the senior the CITDRs and the most honorable Vice President, who should not pull me up tomorrow saying you said this yesterday. So I would think that 68 can be invoked. But then the next question, which was the earlier part of it. I offered a gross receipts, or I said my gross receipts is a sum of 1 crore. I am offering 8 lakh, but I am not able to demonstrate that I carried on a business at all. Under what section will the officer add this? It is not an unexplained credit because I have not maintained books of account. I have not shown any investment out of it. I have not made an expenditure out of it this year. So I would think all the deeming provisions fail. This is why from the beginning I was saying it is very important for me to understand not merely whether 68 to 69C is deeming the year of income alone, or does it deem something to be income in the first place. I surprisingly find that section 68 to 69C are not able to tackle this situation. Because this is, if it is found credited in my books, you can add. If I show an investment out of it, you can add. If I show an expenditure out of it, you can add. But if I show nothing out of it, I simply say I earned 8 lakh. You don't want to add, don't add. Refund the tax. That's all you could do. So if I am not able to demonstrate that I carried on an eligible business, what happens is a very, very tricky situation for which I have no answers. But if I must answer this question, I will say that an officer probably cannot tax this at all. The next aspect is with regard to peak credits, telescoping, etc. These are largely questions of fact, and I will probably refrain from dealing with this in detail, because whether the benefit of telescoping will be available, whether the benefit of peak credit will be available, etc., has to be looked at on a case-to-case basis. I can take simple examples for us to understand. See, for example, if there is a large time gap between the withdrawal and the deposit, normally it is looked at with suspicion, and probably the theory of peak credit will not apply. But then if the theory of peak credit must apply, as an accountant, all of us will understand, or somebody who has an accounts background, all of us will understand that there will be cash deposits, cash withdrawals, and then alone the peak credit will apply. Otherwise, the peak credit theory can have no viability at all. But be that as it may, whether the benefit of peak credit is or is not available is always a question of fact. Likewise, telescoping. I think largely telescoping has something to do with the availability of a cash flow. If there is a reasonable time gap between the cash inflow and the outflow by way of an investment. In fact, I remember some years back I was handling a case where name of project written, cash, check, total. Name of investment with the description of party, 2 sheets, that's all loose sheet found. Second sheet, name of investment, cash, check, total. So it didn't take us much time to explain that the benefit of telescoping will be available, because in each and every case we were able to demonstrate that the inflow was before the outflow. So that is something that may have to be looked at again on a case-to-case basis, and I will not deal too much with that aspect as of now. There is always this implications of 68 versus 69 and an addition under the wrong section as well, which has been one of the issues which has been nagging. In fact, I recently chanced to see a third member decision where third member will say that once an addition has been made under a particular section, it will not be open for the revenue to urge at a later point in time that the addition is sustainable under another section. With all humility at my command and with the caveat that I just said, I don't think I will agree with this proposition, not that I will not canvass the proposition. I don't have to canvass what I agree with. I may canvass a proposition, but I may not agree with the proposition. But the quoting of a wrong section by itself cannot invalidate an assessment is something that I would always thought. And there are several high courts to this effect where they would say that it is not necessary that the correct section must have been quoted, and the mere mentioning of wrong section cannot, undo an addition which otherwise is to be made. I also have numerous other questions in my mind. What happens in the case of an NBFC, for example? An NBFC collects deposits from people, and the law now requires that they must explain the source for the credit in their books of account. And the law goes a step further now to say, I must explain the source of source. I really wonder whether such an onerous responsibility which is cast on an SC can ever be discharged. But be that as it may, you have a Lucknow bench of the tribunal in Sahara, India. The only help that Sahara is done to us in the recent past is this decision where they said the same responsibility that is cast on a normal SSE cannot be cast on an NBFC. The rigors have to be toned down for us to be able to hold the credit to be genuine or not genuine. This again goes back to the decision of Supreme Court in P.K. Noor Jahan's case, where the language used is may. And probably that is the basis on which the whole subject travels around. Of course, you also have issues with regard to partnership firms, partners bringing in capital, whether the partnership firm should discharge any burden cast on it to show that the credit is genuine. There is a Madras High Court which says that it can be added in the hands of the partnership firm itself, even though the credit is by the partner. Now, the partner signs the balance sheet. In the balance sheet, he acknowledges that he brought in the money. After he has acknowledged that he has brought in the money, I don't need anything more from him to establish the identity or the genuineness. Creditworthiness, yes, may still be a question, but that is an unexplained investment of the partner as well. Why should I be asked to explain an unexplained investment made by the partner? I am a partnership firm. And if a partner has invested in me, into me, as capital, I would think it is the partnership firm which will have, the partner who will have to explain the unexplained investment. I will pause here on the provisions of section 68, move on to the provisions of section 69 for some time. Section 69 deals with unexplained investment, and interestingly, in the case of unexplained investment, the year of taxability is the year in which the investment is made. In fact, I recently had an occasion to handle this before one appellate forum. What happened is, I booked a flat in a particular year and I paid in stages, what Mr. Gautam Naik was explaining a little earlier. I book it in current year, I pay over a period of time. Now, the appellate authority would ask me, saying, you made the investment in this year, explain in this year. But I paid over a period of time. See, it's basically a cash flow. It is arithmetic. It is not accountancy. I would think I should explain the source when I paid and not exactly when the investment took place. This again is a very important concept which you will see as you proceed into the other deeming fictions. Now, as I said in the beginning itself, you will see that section 69 does not refer to merely books of account maintained by the SSE. It is qualified by the words, if any. So, if books of account are not maintained, still the provisions of 69 can be invoked. The mere fact that an investment has been made which has not been recorded in the books of account can bring the income to tax under the deeming fiction of section 69 in the year in which the investment is made. I have already qualified it with saying that logically it should be attached to the cash flow and not straight away to the investment. In the context of section 69, we come across certain peculiar situations. In fact, from the day I started practice, I have been seeing this difference between the stock statement given to bank and stock statement which the assessee is showing in the for income tax purposes, the stock value. Now, here whether additions can be made merely on the basis of a statement given to bank, etc., conflicting decisions. In fact, I find conflicting decisions of the Madras High Court itself. I don't want to enter that debate in the strict sense. But then, on facts, I would think, I would look at it this way. First, whether the difference in stock value between the balance sheet and the stock given to the banker is on account of difference in value or difference in the quantity. If the difference is in quantity, it is one game. If the difference is in value, I would think it is very easy to urge saying, at the end of the day, I might have given anything to the banker. What can be brought to tax under the Income Tax Act is as per accounting standard to the lower of cost or net realizable value. If what I have given to the bank is the correct figure, you take that. If what I have on my income tax return is the correct value, you take that. It is a lower of cost or net realizable value. But if it is a difference in the quantity and not in the value alone, then the burden is very, very, very high on an assessee to demonstrate that the quantity shown to the bank is much higher. The quantity shown to the bank is much higher than the quantity that is actually available with the assessee. That may be a much more burdensome task which may be there in the case of an assessee. Likewise, in case of searches and surveys, statements are made by assessees left, right and center. In fact, the first search that I saw after I qualified in my practice was where the last question was, do you have anything else to say? My friend, the assessee, says, I take this opportunity to declare a sum of rupees so much as my unaccounted income. I am extremely grateful to the Income Tax Department for having conducted a search on me and found out all this as my unaccounted income. Sorry, Vasu. This will be like the vote of thanks. He will thank everybody who is there, not there. You see, he did it in the morning, he will do it tomorrow. He will do it tomorrow as well. He is here. I noticed that he was here. But that is his job. But then, are these statements binding on an assessee? Now, insofar as statements made in the course of survey, I find the decision of the Madras High Court in Khadar Khan and Sons affirmed by the Supreme Court, where they say a statement made at the time of survey has no evidentiary value. Now, if you look at the provisions relating to survey, there are circumstances in which an officer can issue summons to an assessee and record a statement under 131. But whether that statement under 131 has evidentiary value is a separate question. The next is under 132(4)(a) in the course of a search, like what my client, one of my first clients did. I take this opportunity to declare one vote of thanks. Remember, in 1994, he declared 3 crores. I was all out fighting for him. In 1996, I got him a brilliant order without these additions. In 1997, VDIS came. He came and sat outside my office and said, am I eligible to declare? I really thought he was an honest assessee. In 1997, he says, can I declare? And you know how much he declared? Some 20 crores. Don't tell me he earned it in 2 years. So, which means the department in the search which took this so-called declaration from the assessee, which is kind of vote of thanks of 3 crores, itself was a small number. Our man declared 3 to 20 crores, and worse still is, he declares a substantial portion as gold. For the seniors here, they will understand, gold had to be taken at a predated value. So, if he is declaring at a predated value 20 crores, actually his amount is much, much more. That is how, see, one of the first lessons that I learned was, the last person to trust is your client. He tells you information on what he considers you need to know. Not on need to know, on what he thinks you need to know. You go and ask him, what is this credit? Almost every assessee, I don't know, the Honorable Vice President is here, his own order, but then, and Arjun is also here. Arjun has argued very successfully about a case where a cash deposit is made along with the sale of a property, but that assessee has no other source of income, fortunately. And therefore, the successfully argued that this has to be taxed only as capital gain and not as an unexplained credit in the bank. Heartbreaking, definitely. Be that as it may, the larger question which we were talking about is the evidentiary value. We have circulars of the board where the circulars very clearly say that even a statement recorded under 132(4)(a) in a search proceeding is not to be used for making any addition unless it is supported by other evidences. So I would think that in the light of this board circular, an offer made by an assessee cannot just be brought to tax merely because it has been offered to tax by an assessee. It has to be necessarily a scenario where the assessee or the assessing officer should be able to, with corroborative evidences, show that income has in fact been earned by the assessee. Larger questions also arise when there are investment made in joint names of the husband and wife. If an investment is made in my hands and if I don't have proper source, ask my wife to explain. Why should I explain for what investment she has made? I would personally think that if an investment is in a particular person's name, that person explain. But if investments are in joint name, which is a very, very common feature, then it becomes a bigger challenge. Because there are circumstances where, for example, I might have roped in my wife as a joint name for an investment, or she may have roped in my name only as a matter of abundant caution, or maybe for sentimental reasons, or whatever, or out of fear. I am not saying that she will do it out of fear for me. The other way, I think I would leave it to imagination. But it is possible that there could be 100 reasons why the investment is made. But if a particular person owns up that it is in fact his investment, then I would think the burden is entirely on him to show that the source of investment is from accounted sources. But otherwise, if properties are in joint names and they claim ownership in a particular percentage, then I would think that the burden would lie on each one of these persons to prove the source, as it will apply in the case of, or in a pro rata basis, I will say. Again, I will pause for some time in the context of section 69. I will go on to section 69A, which deals with unexplained money. To my mind, section 69A would deal with money, bullion, jewelry, valuable article or thing, which effectively would mean that it is not an investment which is in the strict sense governed by the provisions of section 69. Now, interestingly here, again, the language used is books of account, if any, maintained by the assessee. So, if there are no books of account maintained, still 69A can be invoked. And it will be deemed to be the income of the year in which the assessee is found to be the owner. In fact, in the context of the provisions of reopening, etc., you will see that when they define that it should be in the form of an asset, expenditure, or in the form of an entry, if the amount exceeds 50 lakh and it crosses 3 years, there is a careful, noticeable absentee called cash in asset definition. It is an inclusive definition, no doubt, but there is the absentee of the word cash when they define the term asset in the context of reopening. Now, why would there be an absentee of cash? Because if cash is found, I would think it will always be taxed in the year in which it is found. And since it is going to be taxed in the year in which it is found, I don't have to reopen an assessment. That is probably why. But then they have also not included jewelry. Why? I don't have an answer. But then, can we always say that it has to be taxed in the year in which it is found? Now, in the context of 69 and 69A, one other very important aspect that you must bear in mind is that if the asset is located in India, then it will be deemed to be the income of the year in which it is found if it is 69A, the year in which it is invested if it is 69. But if the asset is located outside of India, then the Black Money Act gets triggered, and by virtue of section 3 of the Black Money Act, it will be deemed to be the income of the year in which it comes to the notice of the assessing officer, and taxed at the value as on the date on which it comes to his notice. So 69 and 69A are not a definitive mandate in respect of all assets which are declared, either not declared either wholly or declared only partly. Because if these assets are located outside of India, then the Black Money Act alone is applicable and not the regular Income Tax Act. So to that extent, after the advent of the Black Money Act, there is a dilution of the provisions of section 69 and 69A on its applicability in respect of assets located outside India. The fundamental conditions I have already said, you must be found to be the owner of the same in a particular financial year, and even whether or not it is referred to in your books of account, because there is no need even to maintain books of account. If you offer no explanation with regard to the source of acquisition, then it can be deemed as the income of the year in which it is found. Now again, interestingly, go back to the provisions of section 68. Now in section 68, if I say I took a loan from somebody, I need to prove the source of source. But if I say I borrowed from you and bought this gold, or I borrowed from you and made this investment, it is enough if I prove the source, not the source of source. 69 and 69A still don't go back into the source of source. It is only section 68 which has been amended to provide that I need to go to the source of source. I am not giving any ideas. I am only asking you to litigate on these lines. Right? So the provisions of 69 and 69A still remain untouched. We will see till what time. 24th February, July might be the date also, we don't know. The budget is due on that day. We don't know when this will come, but that may probably come, but as of today, this is how it is. Now the language in section 69A says it should be taxed in the year in which the assessee is found to be the owner. And 69A deals with money, bullion, jewelry. Now, money, bullion, jewelry is found in my possession. Let's say a search comes to the premises of X, and in the bedroom of X, they find that he has got a cash of 50 lakhs, 1 crore, whatever. Whose is this? Whose responsibility is it to show who is the owner? It is found in my bedroom. My bedroom is also the bedroom of my spouse. Now, it is the onus is on the revenue to show who is the owner of that particular money, bullion or jewelry which is found. If they want to make an addition in the hands of any person, that addition can be made only after the revenue demonstrates that the person concerned is the owner. This is why I was telling you in the beginning itself the interplay between the other economic legislations and income tax. Assessing officer has found me to be the owner and made the addition in my hands. After that he says you are the beneficial owner. How is that possible? Why would I put my money, buy something or invest in something and make you the beneficial owner? It is unimaginable. That is fanciful. I don't think the provisions of the Benami Transactions Prohibition Act in 29A or the Money Laundering Act will support this possible theory. So, one thing that the revenue can always use is what I understand as the possessory title. So, if it is found in the possession of a particular person, the revenue can presume that that particular asset, money, bullion, jewelry, etc., belongs to that person, because 69A is dealing with movable property. And there is no real title. If you take an investment in an immovable property, say for an example, then there is always this title deed that can be examined to see who is the investor or the purported investor. That may not always be possible in the context of section 69B, 69A, but that said, I would think the revenue can say that the person is in whose possession it is normally to be taken as the owner. It is for that person to discharge the burden that is cast on him to demonstrate that it is not in fact his income. I will go on to the provisions of 69B. 69B, to my mind, after I started reading it, I have understood is probably one of the trickiest provisions. I would rather live with 68, 69 and 69A rather than read and understand 69C. 69B, I'm sorry. 69B would deal with amount of investments not fully disclosed in the books of account. And if you read the provisions of section 69B, it very clearly mandates that it must not be recorded partly in the books of account, if any, not if any, in the books of account maintained by the SSC. So, there must be an investment which is partly recorded in the book and partly not recorded in the books. Books of account is mandatory. So, let me take a simple example. I am a salaried employee. I bought a property from you. I actually paid you 3 crore, but I recorded only 2 crore. Get my facts very clear. I am a salaried employee. I bought a property from you for 3 crores. I recorded only 2 crores. Some reason, some evidence found in your possession, they find that actually you have collected 3 crores, not 2 crores from me. They want to tax that 1 crore extra as full value of consideration in your hands. You have no choice but to accept the reality, probably. Now they come to me. I am not maintaining books of account. I am a salaried employee. Investment partly recorded. Where? In the books of account. I don't have books of account. Can they add the 1 crore? I don't see a provision. It is not an unexplained credit. It is not an unexplained investment, because for unexplained investment, it should be fully unrecorded. Otherwise, 69B will have no meaning at all. If I can bring partly recorded into 69, then 69B will be rendered odious. So, it will not fit into 69, it will not fit into 69A, it will not fit into 69B because I don't have books of account. Whether it can fit into 69C is something I will come back to when I start touching upon the provisions of section 69C. So, it is very, very important for us to understand that for the purpose of 68 and 69B, books of account become important. But for the purpose of 69 and 69A, the absence of books of account is of no relevance. Now come to 69C. 69C talks of unexplained expenditure and says it will be added in the year in which it is incurred. Now, what is the meaning of the word incurred? Now, plain understanding. If you go to a dictionary, it says charged but not paid. Something that has been charged from me but has not been paid is what is incurred. Right? This is something, the opposite of what we understand as accrued in the context of 9(1) or any other provisions. Accrued is something in accountancy which we understand as due but not received. Now 69C correctly, I don't know whether it is right or wrong, has used the word incurred. Do I need to demonstrate the source for the expenditure in the year in which it is incurred or in the year in which it is paid? I think any appellate forum will have to read or understand this as only having to be demonstrated in the year of investment or in the year in which it is paid. Now look at the interplay between 69B and 69C. Now 69B deals with an unexplained investment which is partly not recorded in the books of account, and 69C with an unexplained expenditure. Now let us say I construct an office building for 10 crore rupees, but record in my books only 8 crore rupees. What did I spend? I spent 10 crore. What did I record? I recorded 8 crore. Now under which section should an addition be made in respect of this differential of 2 crore? Is it 69B, which deals with an unexplained investment, or 69C, which deals with an unexplained expenditure? Either way, my tax will be under 115 BBE, no doubt about that. No doubt about that. But that said, you also have to understand that when you talk about the provisions of 69A versus C, B versus C, the year of chargeability is also important. In my opinion, an addition in respect of an expenditure which results in an investment can be made only under 69B. An expenditure which does not result in an investment. When I say investment, say for example, whether my daughter's marriage is an investment, if you ask me, it is, but not. In economic sense, no. But probably to me as a person it is. Right? But in the economic sense, it may not result in an investment. In the economic sense, if it results in an investment, 69B alone can be invoked. Now look at the chargeability under section 69B and the year of charge. It says in the year in which the investment is made or in the year in which the SC is found to be the owner. 68, year of credit. 69, year of investment. 69A, again, the year in which the SC is found to be the owner. In 69B, it says year of investment or the year in which the SC is found to be the owner. Does it mean that an option is given to an officer to decide in which year he wants to tax it? I would think so, no. Because in my understanding, what can come under 69 is an investment which largely we will refer to as an immovable property. What can come under 69A is immovable property, where there is no real title. What can come under 69B is both, if it is partly recorded. So if it is an investment which is found to be partly recorded, then it should be in the year in which the investment is made. But if it is an immovable property in the form of money, bullion, jewelry, etc., which is partly recorded, then it should be in the year in which the SC is found to be the owner. I would not subscribe to the theory that the officer has an option to choose the year. This may again become significant in the context of reopening within 3 years, beyond 3 years, beyond 10 years, etc. But outside of India, then you have no escape because there is no time limit under the Black Money Act. If it is within India, you probably have this luxury. So the year of taxability again is an issue which will have to be discussed time and again in the context of section 69C. Now insofar as 115 BBE, which is the taxing section, is concerned, questions have arisen in the context particularly of 1718 as to whether, because the presidential assent was received only on 28/11/2016, whether it can apply in respect of all amounts which are found chargeable even from 1/4/2016. the chairman of this session, the Honorable Vice President's order would stare at our face and tell us that it can be applied even in respect of investments and credits. No, you are not the affected party. All of us are. The precedent laid down is there. So you are not the affected party, you would be the lead party to ensure that this gets reversed in the light of AN. But that stares at our face, and I would think there is very little scope to get out of it in that sense of the word. You also have the provisions of 271 AAC, which deals with penalty in such cases. I am not going to the depth of 271 AAC for the time being, but just thought I should bring out a few points. From the beginning I have been saying it is very important to me to understand that the provisions of section 68 to 69C are only deeming provisions. It need not be income at all. I was able to lay my hands on a decision of the Madras High Court in a case called SV Kalyanam in the context of section 69, where they said the addition is made under a deeming fiction and therefore 271(1)(c) does not apply. That is why I said it is very important for me to understand it is not merely the year which is deemed, but the income itself is deemed to be income. Something is deemed to be income. Of course, now you have the provisions of 271 AAC which seek to levy a penalty which is probably a small penalty compared to the rate of tax. It is only 10% of the tax, which is roughly about 6% of the income. Not a very big deal compared to what you are talking about, 78% as tax alone. But there I noticed a couple of important aspects of assets. Now the law there says you must, if you want the benefit of 271 AAC, then you must have paid the tax. You must have paid the tax at the time of filing the return under 139, and you should have filed the return under 139. Does it require me to pay the entire tax, or even if I pay partially, say, is it sufficient? And more still, it goes on to say you must have paid the tax before the end of the previous year. So that is a bit of a challenge on me, right? Because I, at a later point in time, I am not able to satisfy an officer. That happens at a much later point. Only in a case where I am offering it, then the benefit is available. Otherwise, this benefit is probably never available to me. Right? That is the only case in which I will not be liable for this penalty. Now, interestingly, it talks of a return of income being filed under 139. Now, I was wondering what happens if I file a return in response to a notice under 148 or in response to a notice under 142(1) or 153A. Can I get the benefit of this immunity whereby if I have paid the taxes, I don't have to be liable for the penalty? Now, if I go to the provisions of 148, it says a return filed under this section is deemed to have been filed under 139. Then probably I am entitled to the benefit. But if I file a return in response to a notice under 142(1), that return is not deemed to have been filed under 139. The same will apply in respect of 153A. In such cases, the benefit of this lower rate of tax will not apply. Of course, in so far as 153A is concerned, we will take that with a pinch of salt, because in most cases where the provisions of 153A are triggered, the penalty may probably not be under this section 271 AAC at all. May not be under this section at all, because it may go under a different section, 271 AAB probably. Now that is in so far as what I thought we should discuss in the context of 68 to 69C and roughly the provisions of 115 BBE and 271 AC, where I thought I just will share my thoughts. I'll quickly move on to the provisions of 56, and I'm only going to deal with two subsections. I'm not going to take much of your time. I know you're waiting for tea. Only 56(2)(7)(b) and 56(2)(10), that is all, because that is where all the controversy is. 5627B is a very simple section which says that if you issue shares at a premium and if it is issued at more than the fair market value, then there can be a deemed income. There can be a deemed income. In fact, this afternoon I was seeing Arjun asking, sorry, not Arjun, Vikram asking a question to the previous speaker, 50C versus 56210. In the hands of a buyer, in the hands of a seller, both can be invoked? Probably the answer is yes. Today you just imagine, Vikram was also talking when he was giving a brief about the background of the subject. He was talking about whether this will apply to bonus, buyback, etc. or to fresh issue of capital. Now, if it will apply to fresh issue of capital, then there is another challenge. Company should issue at exact correct price. Person should buy exactly correct price. Somewhere in between, both will get taxed. I don't know whether business operates like this. Business is not run in the income tax department. It is something which is negotiated between parties. They cannot negotiate exact prices. Why should I buy a property only at guideline value? Why should I not sell it at a higher value or somebody buy it at a lower value? It can happen. Otherwise, there needs to be no negotiation. Simply put, I am proposing to sell this property, guideline value so much, any offers come. That's not how properties are bought or sold. But the deeming fictions are probably there because assessees have tried to evade taxes. I was hearing the chairperson of the previous session also talk about how evasion goes on. Now, 5627B has a mechanism by which you will take into account the NAV or the DCF, which is the option of the assessee, which is or the value as substantiated to the satisfaction of the assessing officer on the value of assets, including intangibles. So I have two options, NAV or DCF, that is one way, part of it. Second, or I can demonstrate to the satisfaction of AO. This satisfaction of AO is such a vague term, it is used all across. Right? In fact, one assessing officer, I don't want to quote, he was saying, how can tribunal reverse this? The satisfaction has to be mine. How can Commissioner Appeal say this? How can tribunal say this? Because I am only the assessing officer and the law says satisfaction of the assessing officer. So the member of the tribunal being satisfied is of no use according to him. I think that is stretching it very far because already deemed. And they are trying to interpret it in such a manner by which they say if the officer is not satisfied, gone. And that too a faceless officer. I don't even know whom I am handling. Right? But then 5627B in my understanding is only applicable in a case where the shares are issued at higher than face value. While I say this, I am aware that I have lost a case before the Chennai Tribunal in a case called Scindia Securities, which is a reported decision, where they say you have fixed the value at 10,000, that is very, very high, which is the face value. I made a mistake. Instead of issuing 10 rupee share, 1,000 shares, I issued one share for 10,000. If I had issued 1,000 shares at 10 rupees, I would probably not have had this problem. But be that as it may, I am in the High Court sitting happily. My revenue continues. The interest of the revenue is safeguarded for the time being. Assessee will suffer. See, I was reading in the newspaper the other day. Rains in Kerala delayed, doctors disappointed. So if you don't have orders which you will fight against, what do we do in the profession? Every day we will have to hold conferences. But that is costly again. They charge for holding these conferences. Now, in the context of 56.2.10, it refers to a sum of money, it refers to immovable property, it refers to movable property, and in respect of immovable property and movable property, it refers to without consideration or inadequate consideration. In respect of money, it says without consideration. Mark this very carefully. For movable and immovable property, it refers to absence of consideration as also inadequate consideration. For money, it only refers to the absence of consideration. Now, it is in this background, I'll quickly go to some of the issues. The first thing that I started reading, when I started reading, was in 56.2.10. If you see 56.2.10, you are aware that it talks about your entering into an agreement on a particular day fixing the value, the sale deed happening at a different date, advance having been paid through banking channels, in which case, if there is a change in the guideline value or the circle rate, you can apply the guideline value as on the date of agreement of sale, without going into the sale deed date. The concept, whether it is retrospective, prospective, tribunals have been consistently saying it is retrospective in operation because it is a benevolent provision. But then the language was very interesting to me. It says, if you enter into an agreement fixing consideration on a particular date and make payment through the banking channels, I am not exactly going through the channels, before the date of the sale deed. It doesn't say you must pay the consideration along with the agreement. It says you must make the payment before the sale deed date. So, if I enter into an agreement of sale today, sale deed 3 months later, 2 months and 29 days later, I make payment through banking channel, I can come back to today's circle rate. But then the next question, can there be an agreement fixing consideration without registration? I think these were questions raised in the first session post-lunch as well. To my mind, if I enter into an agreement of sale, I should register it in the state of Tamil Nadu. In fact, I asked my office to do some homework and they said in the state of Jharkhand, it is not required. Jharkhand is already boiling in the newspaper, and yesterday one girl comes and tells me, sir, Jharkhand, sir. I thought she was going to speak about some politics, and then she said, no, no, sir, there is no requirement to register an agreement of sale. But then the law doesn't talk about an agreement of sale here. If you see an agreement fixing consideration, it need not necessarily be an agreement of sale. That is one aspect. But assuming I enter into an agreement of sale, assuming I have to register, assuming I have not registered, what is the effect of it? I would still think the agreement of sale is voidable at best. And if it is inadequately stamped, the collector of stamps can confiscate the document, ask me to pay the deficit in stamp duty, and ask me to pay a penalty probably, but the document itself is not invalid. Therefore, there is a valid agreement of sale, registered or unregistered. I am not speaking more than this. The next is, if you go to 56.2.10 again, the definition of the term relative. When you read that only, I found something this morning. I am my brother's son's relative, but my brother's son is not my relative. That is how it is worded. Right? That is how it is worded. But be that as it may, there are some exceptions which say a gift from a relative or sum of money or immovable property, etc., received from relative will not be exigible to tax under 56.2.10. And then it also has a, when it talks about immovable property, it talks about immovable property, and the definition of the term property can be found in 56.2.10. And when you look at the definition of the term property, it says property means the following capital assets, namely. It very clearly uses the word property means, and to my understanding, it is an exhaustive definition. Though they have used the words namely thereafter, it is still an exhaustive definition. So if it does not fall within that list, it is outside the ambit of charge under 56.2.10. Now, in this background, when we say it is outside the charge, first thing that is required is it says property means the following capital assets, namely. So, it is a requirement that it should be a capital asset. It is not enough if it is an asset. So, in that background, whether agricultural land can fall within the ambit of 56.210. Agricultural land is an asset, but not a capital asset. Therefore, I would think that 56.210 is not invocable. Go a step further. What about stock in trade? Stock in trade, again, is not a capital asset. It is an asset, but not a capital asset. Therefore, the provisions of 56.210 probably are still not applicable. Vikram, this, when he started, was also talking about what about partnerships, etc., and the applicability of 56.210. Sir, I'll come back to the question, sir. Now, in the context of 56.210, what about an increase in the profit sharing where there is no money or other consideration paid? There is an increase in the profit sharing ratio of a partner, but since no money or property is given to the partners in any form, 45.4 cannot apply. Because 45.4 says receives money or property, etc. Now, if in that case, whether the provisions of 56.210 can be invoked, I would think 45.4 again deems something to be income. If 45.4 does not apply to a particular circumstance, 56.210 cannot be invoked. Even otherwise, the increase in profit share for me from a partnership firm is not a property as defined in the section. Likewise, what happens if I bring in a capital asset as capital contribution into a firm? The value recorded in the books of account of the firm will be deemed as the full value of consideration, and tax will accordingly have to be paid by the partner in accordance with the provisions of 45.3. Can this be tested in the touchstone of 56.210? Because you will see that when I as a partner bring in capital to a partnership firm in the form of an asset, then the value recorded in the books becomes the full value of consideration and I am taxed as a partner. The provisions of 56.210 are for the recipient. Now, the recipient has got an asset where it has recognized the value at, say, 10 lakh, the value of the property being 30 crore. Now, technically, to my mind, it is not as though the partnership firm is a distinct entity. The law in taxation creates that mirage that partners and partnership firms are different. But I would think that the present provisions, there is a risk of an officer invoking these provisions of 56.210, though I would strongly think that it cannot be done. But there is a possibility, and I would think larger clarity should be there in this context. Likewise, what about a share of interest in a partnership firm being transferred by one person to another? Say I transfer it to somebody who is not my immediate relative, as defined in this section. Can there be the invocation of 56.210? I would think that that cannot be regarded as an asset or a property, because again, in the context of property, you see shares and securities. But when I say shares and securities, I would link it only to a company, not to a share in a partnership firm. What about fresh issue of shares? The implications of 56.210. The board came out with a circular. Within a few days, withdrew the circular, saying I issued the circular wrongly. Right? Now, in that background, whether fresh issue of shares can fall within the ambit of 56.210, 56.210 uses the word receives. Receives means it should be something that is in existence before and after I get it. It cannot be something which is created. When I am given an allotment of shares, it is not received by me, it is allotted to me. It is created at the point in time when I get the share. Therefore, in my opinion, 56(2)(10) cannot apply. We have been relying on the decision of Supreme Court, a old decision in Code's Distillery. You also have the Gujarat High Court in this context. But unfortunately, rightly, wrongly, you have a Mumbai tribunal, less said the better, in Sudhir Menon HUF's case, where they said it can apply. Of course, to read and understand the decision itself took me a lot of time, because the language used was all so difficult to understand. And ultimately they said, no, it is taxable. That part I understood that it is. But then as of today, you have Gujarat High Court, and since there is a High Court, I would think that there should not be much of difficulty in, urging that the provisions of 56(2)(10) do not apply in such circumstances. Very quickly, I will touch upon what will happen in the case of bonus shares, in the case of buyback, and in the case of capital reduction. Again, Vikram prompted that I should speak this. So in the context of bonus shares, I would think when I get bonus shares, 56(2)(10) cannot be applied, because what is happening is I had one share, I am now holding two shares. But the fact remains that I am holding the same asset, which is the share of assets in the company. So if the company is worth 10 rupees and I had one share out of two shares, and tomorrow I hold 2 out of 4, my asset is still that 5 rupees of the company only. Nothing more and nothing less. Therefore, I would think 56(2)(10) should not apply. Now, insofar as buyback is concerned, I will analyze it in two ways, two angles. One in the hands of company, the other in the hands of the shareholder. In the hands of company, when it buys back its shares, there is no asset that it will get, because the shares will get cancelled. And since they are cancelled, the company will get no asset, therefore the invocation of 56(2)(10) does not arise at all. In the hands of the shareholder, what he gets is money. I said in the beginning itself that 56(2)(10), when it talks of movable and immovable property, talks about without consideration, inadequate consideration. For money, it should be without consideration. I gave my share, I got money. No question of inadequacy. 56(2)(10) cannot apply, because the word inadequate is not found in so far as money is concerned. Likewise, when it comes to capital reduction, the same rules will apply. Insofar as the company is concerned, the share is extinguished, therefore, there can be no implications of 56(2)(10). And insofar as the shareholder is concerned, I think I would take a similar view that money is received on capital reduction. If it is received, the question does not arise. If nothing is received also, no question arises. Because you must either get money, or you must get immovable property, or you must get movable property. If you get money and there is inadequate consideration, not applicable. If you get nothing, not applicable. I think I will pause here. If the organizers still do permit, I will probably take questions. Thank you very much for the opportunity. In fact, one reason why I am part of the committee, but still I didn't use my influence to get here where I am. Because the minute it started, Kumar was the person who said 68 to 69 C Bhanushekar. That day itself it was over. Right? And poor man section. That's why I am there, sir. That's why we are there, sir. That's for us, sir. That's why they probably chose us. Be that as it may. So, and these are the only subject in this whole 2-day conference which is old. Most of the other things that you are talking about is of newer origin. This is old, but has created such a great impact, particularly after 115 BBE. But I will pause here, thanking the organizers for the opportunity, because this gave me an opportunity to read these sections in depth, which I honestly would not have, but for a session like this. I must thank each one of you for a patient hearing, and of course my chairman will have the last word, like he has in the honorable when he is in the honorable tribunal. Thank you very much.
Thank you, sir. I now request the chairperson to give his concluding remarks.
erudite, intelligent, and convincing. These are poor men, poor assessees, not men, poor assessees sections. It is normally applied not to big companies or because they have large contingent of tax advisors or day in and day out we see in tribunal that small assessees, this 68, 69, 69 ABC and 50, 56 applies to all. Bhanu has covered all the topics except one, that under which head this income is to be assessed if addition is made. He said it will come under residual heads. Residuary head, that income from other sources. Income from other sources. It is also because income tax department commissioner will authenticate this. Thank you for a nice evening. Tea is waiting. So tea is getting, normally now when we hear cases, I finish bench very quickly. And some now two judicial members have come here who finish bench up to, they carry bench up to 1:30, 1:45. We send chit that either food is getting cold or tea is getting cold. Please come quickly. So tea is getting cold, so we'll have. Thank you.
Thank you, sir. I now request Advocate D. Anand, Chairman of the Conference Committee, to present a memento to Mr. Bhanushekhar, please. Yes, sir. Thank you, sir. I now request Mr. M. Swaminathan, Honorable Judicial Member of the Central Administrative Tribunal, to present a memento to the chairperson of this session. Thank you all. With that, we close our day one of this conference successfully. We hope to see you all tomorrow at 9:30 a.m. for all the power-packed sessions we have lined up. Please join us for high tea. Yes, sir. Badam Alwa is waiting.